the proposal that is sent by the society is already rejected. Now, considering the request of the petitioner independently will not arise, and the petitions have become infructuous in the light of the letter dated 14/10/2024. Next para. Having heard the counsels on either side, there is a material on record. The petitioners, who are the agriculturists who have sustained losses in view of the heavy rains and landslides, have made a representation. And in fact, the survey was conducted. The Tehsildar also forwarded his proposal to the Deputy Commissioner, stating, I placed a report that what are the losses that are sustained by the petitioners. The seventh respondent has also requested the government to waive off the loan. That request of the, no doubt, that request of the society, seventh respondent society, is rejected by letter dated 14/10/2024. But the presentation or reply oblique order to the representation of the petitioner. If the petitioners are aggrieved by the same, they would get an opportunity to assail the same. In these circumstances, this court do not find force in the argument of the learned counsel for the seventh respondent as well the learned AGA that the writ petition has become infructuous. Accordingly, this court is passing the following order. All the writ petitions, you write all the numbers, are disposed of, directing the respondent number 3 and respondent number 5 to consider the representations in the light of the report of the Tehsildar and pass appropriate orders within a period of 8 weeks from the date of receipt of the copy of the order. Accordingly, dispose of this.
Please, much more.
Yes.
For dismissal, still number 2. List
Here
number
for
1.
the petitioner.
Kumar Kokakar, Sandesh Katgeri.
Lord, validity of the domestic violence is challenged by the petitioner here, my lord. Last time I have made the submission of the Honorable
But
Supreme
he has
Court.
already, and the Supreme Court has upheld, and he has already paid the amount
Yes, my lord.
in the.
I have produced the copies in the matrimonial dispute in MFA. Substantially
the-
has paid in fact.
Yes.
That is not the point for consideration in this petition. There is no doubt that I have compromised with my wife and I have get rid of the things to clear up the things. Now I challenge the provisions of some of the provisions of the act
Which were not upheld by the Supreme Court.
which have not been considered and not upheld. 2F is not challenge that has been upheld. I am challenging 2A and 3A. Agreed person.
Violence Act.
Still it is a 2Q is retained, my lord, in the act, I think, having struck down. What of,
No, let us see what is that he is saying and what was considered by the apex court. What are you questioning?
yes. The adult main was the issue, my lord. Their lordships held that cannot be held to be only for adult. It has to be held to other female main. So that was not struck down by the Bombay.
What is that,
2A, my lord. Agreed person.
Aggrieved person means
Yes,
any
ma'am.
women who is or has been in a domestic relationship. This is not considered by the apex court in their such judgment.
No, it is not. It's only 2Q, my lord, it is. If I am right.
What is 2Q? Respondent means any adult male
Yes.
person who is or has been in a domestic relationship with the aggrieved
Agreed
person
person. And against whom the agreed person has sought relief
under
under
this
this.
act. Hmm.
Provided that an agreed wife or male,
Yes.
female living
What
in a
is
relationship.
modern in this?
There is no interim order. No. There is no interim order. Because I challenge the provisions of the
Only
these
these two you have challenged.
3 minutes, section 20 also minutes.
20.
Yes.
What is 20?
monetary relief is concerned, my lord, that is challenge.
On what ground, please argue on that? Why they are unconstitutional?
Yes, ma'am. 2A is, my lord, is discrimination in nature. A good person means any woman who
Please
is,
read the preamble, why, what is the purport of this act?
I do understand, but the very act itself is domestic of violence of
Need to
women.
take care of
Yes.
so when the purport itself of the act itself is that, how can you say that the aggrieved person should be somebody else?
It is not against the,
Anything your purpose is worked out.
no, no.
That is already paid.
That is there, madam. I am not on that. So far as the wife, the dispute is concerned, it is all. Why I am submitting, madam, this? Kindly see, madam, it is totally abuse of process and the misuse of,
Please come, please, Arya, please look at what is the purport of this Protection of Women from Domestic Violence Act.
yes, madam. If
Then
you-
how then, under that act, how will the husband be an aggrieved party?
For this reason, you lordship may kindly see page 21 of my writ petition. There are so many directions have been issued. One of the direction may kindly, page 21, 71. There are so many directions are issued by the trial court. I am not on that. Only on the paragraph number 4 of the operative
There are
portion.
two different things. Now, if you are arguing the validity of an act,
Yes,
a
yes,
particular provision,
Yes, yes.
don't go to that. You have to restrict yourself.
Yes, yes.
To this. So please, no, please, you please tell the court how this 2A is bad. Aggrieved person. When the act itself is for the protection of women from domestic violence, aggrieved person would be the woman. Act itself is that.
So that itself, my lord, is unconstitutional because it is a violation of Article 14. With due respect, sometimes the reverse harassment also merits. That is the one of the reason why trial court has given I am agreed only paragraph, just I will read it one. The respondent is hereby restrained, that is myself in the trial court. I am the respondent in the trial court. Respondent is hereby restrained from entering the shared house, that is first floor and the ground floor of CTS number so and so, Shivani, Budwarpet, Tilakwadi, Belagami, without prior permission of the petitioner, that is the wife. It is my house. I have constructed by raising the loan. To enter my house, prior permission is required by the wife.
That is on the merits of the order.
No, no, this is how my lord, it has been misused. Without prior permission of the petitioner and also restrained from causing any kind of physical disturbance to the normal living. That is disturbance, my lord, it's, but should be a permission from the wife to enter the house. It is very unfortunate. That is the reason why, my lord, I challenge the,
When you're indulging in violence, that is a protection order to the wife.
no, that is protection. To enter the house,
Because now she is exclusively staying, residence order is granted.
a restraint order is granted.
Is
No, no,
granted to her
no.
to stay.
Rest-
So if you enter the house and create any problem, if the sufficient material is placed before the court is justified. That's what is, you can't, because you are dissatisfied with an order, you can't question the act virus without, just like that. Please come. The
Kindly
person-
see para 15, my lord. Their lordship, para 15 of the impute judgment of Hiralal Osra, that judgments which are 2016 judgment. So, my lord, para 15, my lord. Their lordships have,
You
In the
have
memo,
filed it
yes,
by way
ma'am.
of a memo, yes.
Yes.
Para?
15, my lords.
Hmm.
Their lordships have, in accordance with the law laid down,
1 minute, let me, page number,
page 20, my lord, 20. A running page, ink page, my lord.
yes.
In accordance with the law laid down in the judgment, it is important to first discern the object of 2005 from the statement of objection. What is meant by domestic violation? Para 3, that it is there proposed to enact law keeping the rights of the guaranteed articles 14, 15, 20 Constitution to provide for remedy under civil law, which is intended to protect women from being victims of domestic and prevent so and so. My lords, para 17, their preamble agreed. Even thereafter, my lords have extracted everything is considered. Even 17, 18, and 20 also. Residential order, all these things have their lordship considered. Thereafter, para 20, my lords, in that page 26.
Yes.
It will be noticed that definite domestic relation contained in section D is very wide. It is the relation between the person who live in or live together in shared household and are related to one of the four ways: blood, marriage, or relation in the nature of marriage, so and so. My lords, thereafter, my lords, their lordships have held. In fact, act has been considered. Thereafter, my lord, kindly see page 40, paragraph 44, my lord. Page, your lordship, 37.
Yes.
An application of the aforesaid receivable principle would make it clear that having struck down the expression adult male in section 2Q of the 2005, the rest of the act is left intact and can be enforced to achieve the object of the legislation without offending word. Under section 2Q of the act, while defining respond, a provision is provided only to carve out an exception to the such person. So that is, my lords have held their lordships, my lord, long back.
Yes.
In fact, Article 15, my lord, says, it should not be against, my lord, the,
Article 14, 15, 21.
just because of the,
No, Honorable Apex Court is upheld in this. No, there is nothing to, consider by this
but
court.
that has not been questioned. Only 2Q was questioned. While considering, of course,
The court observes that. Now,
Yes,
just
yes,
now what he read just now, you must have seen. Yes, please come. The present writ petition is filed. Question, seeking the following prayer. When counsel appearing for the petitioner submits that the aggrieved person is only a woman, and that is discriminative and violative of Article 14 of the Constitution of India. It is submitted that by order impugned, by order impugned, the court had directed the husband not to enter into the premises without permission of the wife. It is submitted that the said house belongs to the petitioner, and the court ought not to have passed such an order. As such, the petition is before this court, questioning the act violence of the Domestic Violence Act 2005 as unconstitutional and being violative of Article 14, 15.1, 15.3, and 21 of the Constitution of India. Land Council appearing for the Union of India
yes,
submits that the said issue is no more res negra as Honorable Apex Court in case of Hiral P. Harsora and others versus Kusum Narottam Das Harsora and others, reported in 2016, 10 SCC 165, has held that the entire provisions of the Domestic Violence Act have been upheld with Honorable Apex Court except 2Q. Yes,
yes, ma'am.
except 2Q. He has relied on paragraph number 44 of the said judgment. Please extract that paragraph number 44. Further, it is submitted that in the petitioner in MFA number 101955 of 2021, dated 5th April 2023, had paid an amount of rupees,
Para 3,
entered into a compromise and paid an amount of rupees 25 lakhs each.
1 crore.
Where do you get that?
Para 3, your lordships may extract that.
An amount of rupees 1 crore was paid to the wife along with the other properties. It is submitted that now the entire dispute between the parties is compromised, and at this stage questioning an order that's passed on the Domestic Violence Act cannot be considered. And further, in the light of the judgment of the Honorable Apex Court, nothing survives for consideration before this court. Next, having heard the counsels on either side, there is a material on record. The first submission of the that the person aggrieved is a woman is unconstitutional and violative of Article 14. This court is not able to accept the said submission. First, as it is already upheld by the Honorable Apex Court in Hiralal P. Harsora the judgment referred to supra, and the fact that when the act itself is for the protection of women from domestic violence, in that case, the women, the aggrieved party would be the women. Then coming to the order of the protection of the residence order that is granted by the court is concerned, uh, that is in consonance with the provisions of the act, which are upheld by the Honorable Apex Court in the judgment referred to supra. Hence, this court do not find any reasons to pass any order in this writ petition, accordingly dismissed. Yes, next. Yes,
What's matter? Bill number 3,
yes,
showcase mention kai. PR Dwarkanath.
it's a writ petition of 2010,
Recalling.
coming for, when is the order passed?
Third October 2013.
No representation, list this matter for dismissal on Monday.
Second. Seal number 4, P. Hegde.
Please. Lordship, suit is of the year 2013, Lordship.
Yes. It is already under dismissal.
Please,
This
Lordship.
matter is under, this 3, give that.
3.
Just know what is adjourned. Oh, it's on orders. Yes. This also will post it for dismissal. And
Please.
there is no representation on behalf of the petitioner. On the last, on 28/1/2026, as well today, Land Council for the petitioner submits that it's a suit of 2013, which is
2013, Lordship. This is up.
2013, which is stayed by this court,
Please, Lordship.
which is stayed by this court. This is matter for dismissal on Tuesday. Yes, next.
Third. Seal number 5,
This matter, my lord, I have submitted that I will provide the particulars of place where yes, visit the order.
Take that.
I served the copy on the other side also.
This is the address.
My lords,
Yes.
they have given an address of Vega City Mall, Bandirghatta Road. In a city mall, they are given address to meet my daughter. And it is not a small place to meet. It is the number of floors there. There is a no contact number and there is a no specific place in the Vega City Mall.
Shall we send the registrar?
My lords, I'm not submitting that. But my intention, at least there is contact number to contact the person.
Give the phone number, how will he contact, there should be some number of the contact number.
And
Will provide,
Furnish it to the council.
I will will provide them.
my submission before this honorable court, I may be permitted to visit in the school premises only because I have a threat from the petitioner and family members. Last time also they are tried to implicate me in another criminal case while meeting. Therefore, I have a threat. I am request before this honorable court, I may be permitted to.
You have not filed any writ petition questioning the order that is passed by the family court.
My lords,
That is his writ petition. And you want complaints of the order of the family court. No, you cannot seek whatever, alteration in the order or the modification in the order.
my lords.
No,
my lords,
your lordship may
there is
kindly
an-
peruse
my lords,
order number 5, may I read it?
Yes.
Respondent is permitted and allowed to meet the child on her birthday at her school premises or any convenient place during the lunch hour for 1 hour. So lunch hour is from 1 PM to 2 PM. So I have given the time. This is a convenient place.
Which is the day?
Sorry.
That is a Saturday or
It is working day.
it is tomorrow is working.
tomorrow? Then how come she will come to that mall?
Bangalore, it is in Bangalore.
Huh?
Bangalore.
And she has school. How will she come to the mall in the afternoon?
It is very near to the school. It is, I am told that it is hardly 1 or
Why do you create inconvenience to the girl? Why can't he meet in the school?
No,
What will
school-
happen?
And
no, school, with due respect, my lord, this is third round of litigation. On the earlier occasion, he is not ready to disclose the place where he was working. It was given in a sealed cover. Because I'm going to cause some inconvenience. Now my apprehension is that if he is allowed to the school, he will cause inconvenience.
My lords,
Please come.
my lords,
Therefore-
one more submission.
therefore,
There is a next
The trial court
condition,
has
my
made
lords.
it clear.
Respondent father submitted on the last occasion that as per the order passed by the family court on the birthday of the child, he is permitted to meet her in the school or the convenient place. He is not aware of the whereabouts of the wife and the child. Hence, his court yesterday has directed the learned counsel appearing with the petitioner to furnish the address of the petitioner. Today,
Please,
the
where-
memo is filed. It is stated that
My lords,
I will
one more
provide it-
submission, my lords.
I will
I'm
try,
interpreting.
I will provide the mobile numbers. I will
My
provide
lords,
the
there is a
mobile.
next condition, at serial number, respondent is permitted to allow the attend all the school events of the child along with the parents and grandparents whenever.
you want the order to be complied, file your contempt petition.
My lords, there is this condition.
Want, I will not even grant this order.
My
I
lords,
will
my
adjourn
lords.
the matter. Because you
My
don't
request-
fight, this is not the way you fight this litigation. It is not, you both of you are fighting for the sake of fighting. Now ultimately, on the birthday, which is, when is that? On?
Tomorrow, my lord.
Tomorrow, you want to meet the child.
Yes, ma'am.
Happily meet the child first.
Yes,
Instead of making all this.
Please, my lord.
Yes, what did you write? Memo is filed stating that the father has never visited the child till this date or made any attempt even for a single time till this date. As it is submitted before this court, the father may visit the child on her birthday at 1 p.m. in the Vega City Mall, Banerghat Road, Bangalore.
And I will provide the mobile number.
Learned counsel appearing for the respondent submits that there is no contact number provided. Learned counsel, in response to that, learned counsel for the petitioner wife submits the petitioner mother submits that he will furnish the phone number to the respondent, counsel. Learned counsel appearing for the respondent submits that he wants to meet the child in the school. And as per the order passed by the court, by the family court, he has all he can be part of all school activities. At this stage, this court is not inclined to go into those aspects. If the order of the court is not complied with by the mother, he has a remedy to file a contempt. However, considering the fact that the child's birthday is tomorrow, that is on
30th.
30th,
Please.
this court is passing the following order. The mother shall facilitate the father to have the visitation at Vega City Mall, Banerghat Road, Bangalore, between 1 to 2 p.m.
Please.
1 to 2 p.m. Number 2, the mother, it should be the responsibility of the mother to see that the visitation goes on smoothly and the father will have the exclusive visitation, shall have the exclusive custody of the child between 1 and 2. Yes, sir.
Both the parties may be directed to report the result of the visit, tomorrow's visit. Madam.
To whom it should be, what should be done?
Reported to the court.
What?
Sorry, madam.
What is to be reported?
Visiting.
Nobody
Whether
will stop you. Whatever you want to report,
Please.
you report. Yes.
Please, my lord. Let.
Yes.
Seal number 6,
List after service of notice.
One submission, Lord.
seal number 7.
Mr. Apurva Somanor appears for Cantonment Board, Belagavi. I've served him copies also. I've also
The
instructed.
name of so and so.
Yes, may I request, my Lord, on 12th, this is regarding
In the name of so and so.
in preliminary hearing, because only change of name, my Lord, covered by judgment of this honorable court. Now, the school authorities are, my Lord, little bit, my Lord, hesitant to give, my Lord, documents. There was some urgency, but my friend said that he has some, my Lord, inconvenience till 10th. So
12th.
12th in preliminary hearing.
Yes. The 7.
Please.
Seal number 7,
Your Lordship, I'm appearing for the
Petitioner in 7,
Let's see, in connected matter, I appear 7.123. These are the matters are linked with my,
7, my lord, main
So
matter.
it has to be go before, my matters are should be listed before quota number 7. Because the order which was passed by the Deputy Commissioner and the Land Revenue Act, the conversion order which was challenged, it has to go before quota number 7. Kindly
They are
deal-
listed here. Why they are listed here?
It was oversight, it was given a number of my colleague.
D-Link 7.1. What about 7.2?
Well, 1, 2, 3 are my matters. It has to
7
be.
point, well, then why did you give these numbers?
Not me, my lord.
Who gave
It
them?
was listed on 19 last week. That's probably my colleague.
D-Link,
1,
like
2, 3.
council appearing for the petition in 7.1, 2 and 3 submits that it is not connected to 7, that is WP number 108187 of 2025, D-Link 7.1 to 3.
8 was given on this day only.
Yes, yes. Yes, what about your case?
My lord, it may be listed on third,
Why?
my lord.
Why?
It is listed yesterday only, my lord. And 1 week time was given to comply the office objections.
Why these matters? Where is the order to connect these matters?
In my case, it was there.
You said before the other court.
Yes. Due to oversight.
It's the same, they have to one, that same order.
My lord,
Yes, next.
main petition may be listed on 3rd of February.
Yes, list along on 3rd of February.
Not along, only 7, my lord.
7 only I'm saying.
Please, much
Already
obliged.
D-Link the other matters. D-Link list before the court having roster. Yes.
Seal number 8. Sunil Desai.
List after service of notice.
Please, Your Lordship.
Yes.
Interim order may kindly be explained.
Yes. 9.
Seal number 9.
Time to
Upelur.
take steps to respondent number 4, my lords.
A week's time. Default order. Next
My
step.
lords, interim order may kindly be extended, my lords.
Interim order will be extended.
Obliged.
Yes. 10.
10, I appear for the 10,
Whatever.
state is
10.
already appearing.
And seal number 10.
My lord, seal number 10, my lords.
Rahul Srikanth.
State
May I
has
make
been
one
notified. My lords, may I make one submission? my lords? Notice has to go to the contesting respondent number 2 and 3. State is 2 and 3, my lords. State is the formal party. Respond 2 and 3, both are state only. That welfare board.
2 and 3 are the members of the board.
If you don't pay the PF, how will the notice go?
Milords, the state government, Milords, was representing all the
No, we are not
respondents.
we are not
Milords, in
representing.
the first instance, Milords, my lord was pleased to hear, and Milords directed the state government to secure the instructions on the conditions.
Who is,
My lords, the second respondent
Kindly
is the
see the earlier
secretary
orders, Milords.
and CEO of the Karnataka Building and Other Construction Workers Welfare Board. And third respondent is the joint secretary, my lords. They have to be notified, my lords.
Milords, the state, Milords, has taken, Milords, the notice for all of them in the first instance. And my lord was pleased to direct them, Milords, to secure instructions with regard to tender conditions. And my lord was pleased to pass an order stating that, Milords, the tender condition is, yes,
I would have issued notice to
yes,
them.
yes.
This notice has to.
Now he is telling.
I'm not saying whether the notice has to go or not. Why was it not informed to the court that you don't appear for them when the matters came up earlier? It's waste of time.
Actually, labor department only.
Then I passed an order saying that this is how it has happened. On the last occasion, the government said that they will take notice for all of that, and the matter is adjourned till today. Now this representation is made and they're insisting for interim order, so that there be an interim order. At least to whom you people are representing, there should be a clarity on that whenever the matters come.
Sorry, my lords.
But the senior counsel is online. Senior counsel is online.
Look, these are, tender is notified for obtaining these 35 mobile clinics for managing and organizing. The conditions that are imposed is contrary to law. They say that KPMG registration is required because the law itself does not provide for such registration.
Sir, the CM.
This order is passed on 12/1/2026. The additional government advocate shall take instructions with regard to eligibility criteria, that is rupees 29.4 crores turnover in the preceding 3 years, whereas it was earlier rupees 8.29 crores, and also with regard to the KPMG registration certificate.
Yes.
On that day,
But I'm making it very clear that I'm very much dissatisfied the manner in which the government is proceeding. The representation that is made before the court. Writ jurisdiction is completely depends upon the instruction of the government. I don't understand why the government is not filing its objections, and without government objections, why the courts are entertaining these writ petitions.
I'm sorry, Manoj, on that day.
It's strange.
Yes.
I've never seen this. Like, if once the notice is ordered within 2 weeks, no, at least I must have seen 1,000, 1,500 cases. Not even one case the government will file their objection. Who is the opponent in the writ jurisdiction, in the writs? And if the government, then what for the advocate should be there in the court? And I told the AAG, why is he not, consider what the court has said, it should have been implemented. Ask the AAG to come. There should be some seriousness. I'll take up once the AAG comes.
Please.
Yes.
Seal number 11. Dharwad.
Senior is online. Manoj.
One primary
I
submission.
appear for the petitioner's counsel, Miller.
Yesterday's matter, Manoj, it is kept today.
R9 to R12, my lord. Yesterday evening, I have got the briefs, my lord. I have not filed wakalat. I request for 4 days of time, my lord. I will come up with objections, my lord. I have not yet received complete papers. That's
What does this matter about?
Yes, senior Manoj is online.
This is Miller.
Senior counsel.
In an election petition, office bearer president election is stayed because they have made an application. That's the only reason given for staying the president election. Therefore, your lordships are directed to show their name and
That they are
post
not
it.
feeling well, is it that?
No. After the completion of
In this matter,
After the completion of the election, there is a
interim order.
Yes.
in
Senior
an
may kindly be
election
heard, Manoj.
petition, an interim order is passed saying don't hold the office bearers election. The translation of the order annexure J is furnished today, my lord. Your lordship may kindly see.
Please.
Kindly see the paragraph 7, my lord. After 7,
Yes.
after paragraph 7 in the translation, alleging all the above
Yes.
points, an election suit has been filed in this court under section 70 so and so of the Cooperative Societies Act, seeking a stay on the elections already held and all further proceedings of Mudol Taluka so and so Cooperative Society Bagalkot and election proceedings of the office bearer scheduled to be held on 2/1/26. During the hearing held on 30/12/75, advocate so and so appearing on behalf of the petitioner presented his oral argument along with petition. He has filed IA number 1 to issue a stay order on the election process of office bearers. Considering the translation is wrong, my lord. Considering the request, an interim in the interim application IA number 1 filed by counsel for plaintiff, it is ordered that stay order be issued and the election process of office bearers to be held on 2/1/26 be stayed. This is the only reason given, staying the election as if.
Yes, how can it be? No instructions are required. We are only looking at the legality of the order.
Miller?
No instructions in this.
If my
We
learned
are
friend
only
wants time,
Yes,
kindly have it.
I will.
What happens is
Saturn.
your instructions will not change your instructions
Yes, ma'am.
will not change the order. You can't supplement your arguments or your instructions.
No, my lord,
into this
the
order.
maintainability of the writ petition and all, my lord, today I will be, I am not in the position to argue, my lord, since I don't have any papers and instruction. Kindly give me 5 days of time, my lord.
Yesterday, I got the instructions, Your Lordship, wherein he has told that when the prima facie it found that there are some illegality, because as per the submissions made by the petitioner, respondent, Your Lordship, they have, it was stated, Your Lordship, there are some 9 people were dead, Your Lordship. The report is there, and they have shown that death certificate also. They have casted the vote. When these kinds of malified prima facie found that, immediately.
There is all that.
Your Lordship, page number 60 of the petition, Your Lordship.
I'm looking at the translated copy.
Please, Your Lordship, para 6 and 7, Your Lordship.
No, that is the case.
That is the case.
of the-
That is the reason, Your Lordship.
It's there
It
in-
need it.
No, when an order has to be passed, there should be a reason in that.
Please.
Why it is doing. No, they file a writ petition. No, I'll pass an order saying that in view of the above reasons, I will grant interim order.
Because
That
as
is not-
elections were conducted, calendar of events was held on 2/1/26, Your Lordship. If the again,
During the hearing held on 30/12/2025,
Please.
advocate appearing on behalf of the petitioner presented his oral argument and along with petition has filed the IA-1 to stay. Because of that, I am granting it. That can't be the order.
next paragraph in where he has explained, Your Lordship.
Paragraph
returning
number
officer-
7.
Yes, we will read that.
The written.
Returning
All the
officer.
contention of the
The returning officer has allowed the deceased, the members to vote in the election. Deceased members were allowed to vote in the election, and 9 voters are deceased. It is clear that the defendant number 1 to 5, in collusion with the returning officer, that is defendant number 8, and the chief executive officer of the defendant number 9 society, have committed fraud in the election. And the election process is not fair and has carried out corruptly.
That is the allegation,
Looking at,
what he makes.
these are the allegations, Your Lordship, where we are supposed to look into and verify. That is the reason, Your Lordship, the respondent interim order has been granted, Your Lordship.
Out of 12 seats, election is challenged in respect of 4 seats.
No, please read paragraph number 7.
Please,
Paragraph
I'll
number
read.
7.
Please.
That's the reason.
The returning officer has allowed deceased members to vote in the election, and 9 voters are deceased. It is clear. 9 voters are deceased. It is clear that defendants 1 to 5, in collusion with returning officer, that is defendant number 8, and the chief executive officer of defendant number 9 society, have committed fraud in the election, and the election process is not fair and has been carried out correctly.
No,
That is
all
the
these are not
allegation.
the find. Alleging the above
Please,
points
Your
they find.
Please, Your Lordship.
Where is
Yes,
the
Because-
answer?
I will
Where
only-
is-
That is to be verified, Your Lordship, during, after issuing the notice. If in,
You can issue
because,
notice, you can't stay without.
but the
without
elections
anything.
were held on, listed on 2/1, it was listed, Your Lordship. It was supposed to held on 2/1, Your Lordship. That's the reason interim order has been granted.
2/1/2026, what happened after that?
No, in view of this interim order, my lord, it did not take place. In view of this interim order granted by the DRCS, which is now in challenge before this honorable court, that did not take place.
No,
He
there is no interim order.
grants stay of office bearers election.
It is till 2/1/2026.
It's not even,
After that, what?
Nothing has happened.
Then if nothing happens, then there is no stay.
No, my lord, election was to be held on 2/1/2026 for constitution
No,
of
he
the
did
my lord,
not.
office
He
bearers of the
granted
society.
a stay of holding election.
Yeah, yes, he granted.
2/1/2026
Yes, my lord, he granted stay of that process. That is erroneous.
Of office bearers election.
Just 4 to 5 days, my lord, because there is an appeal provision. Maintainability of the writ petition, I want to harp upon, my lord. Kindly give me 4 to.
And when the
It may
order
be.
itself is bereft of reasons,
Yes.
order itself is bereft of reasons, what is to be done?
Yes. Kindly maybe posted on 4th itself, my lord. I will come up with objections and argument, my lord. I will undertake to argue on that day, my lord.
Yes,
4th,
I'll take it up on 4th.
please.
4th, my lord.
City
Please,
Council. Yes.
please,
This matter
please.
on 4th at the request of Land Council for
My name
responding,
may
no
be-
further time will be granted.
My name may be shown, my lord.
So and so, or in the
Saurabh
name of
Beg.
so and so, for so and so.
Great.
Yes.
Seal number 12,
Please, it may be taken in the same stage.
Murali Maliwal.
In the same preliminary hearing.
Please.
Yes.
Please, I appear for petitioner, my lord. I've served the copies to the returning officer and this thing.
Where is
The
that?
returning officer has contacted me, Your Lordship. She has stated, as the 13D is not complied, Your Lordship, and the elections where she has permitted to cast the vote as per the direction of this honorable court, Your Lordship. Let the permission may be given to announce the result.
Yes,
Considering their votes also.
Please, Your
yes,
Lordship.
my lord.
For this, what you're supposed to do is, whatever instruction should be, you should get it from the concern and you should pass it on. to the-
Actually, Your Lordship, returning officer, we are not appearing, Your Lordship.
Then
But,
whoever is, the returning officer is notice is served.
Yes, notice. Notice is served to him.
sir, but I told her, Your Lordship, she has contacted me. As I told Your Lordship,
It doesn't go like that.
please, Your Lordship.
Everything has to be, this is not a simple issue where on instructions we do it. Tomorrow, if somebody says that we have not given that instructions, where is the proof for that? Because the proceeding should run in the procedure known to law. Whoever is the respondent should come before the court.
I told her to contact your
When you are
returning
representing, I
officer.
can understand. Even if you are representing also, this kind of submissions on, we can't take it. There has to be a written instruction and or else the objections have to be filed. If she is interested, let her come to the court and tell the court.
Please.
Whatever is the interim order earlier granted is extended until further orders. Learned Council, SCGP submits that it is the instruction of the returning officer that they failed to follow 13(3). Hence, the writ petition may be allowed. On these kind of instructions, the writ petitions cannot be disposed of. It is a duty of the concerned to file objections before this court. If objections oblique their instructions, whatever it is, but basing on instructions of the HCGP, we cannot pass orders. Yes, interim order earlier granted is extended until further orders.
Please.
Yes.
Seal number 13, A.S. Patil, Venkatesh Karvi.
Appearing for petitioner, my lords. It's the same matter, my lords. My lords have permitted us to cast the vote.
What about this? What about the notice in this?
So summons have been served, my lords. Hand summons have been served upon the respond number 2 to 5, my lords. And acknowledgement to that.
The earlier matter also.
5 is not, 5 is served.
Served, sir.
Respond number 4.
In your matter, the hand summons are served.
Yes, yes.
In earlier matter also.
Yes.
It is submitted that the hand summons are served and the memo is filed. Hence notice to so and so is held sufficient. Then 13, in your case,
So hand summons.
respondents,
Sir.
2 to 5, my lords.
2 to 5, same hand summons held sufficient.
My lord, date may be fixed, my lords.
Huh?
It's the election matter, date may be fixed.
We will not fix the date. Let them come.
No, my lord, so
They
they
have
have
to
not,
come.
till my lord, they have not announced the election, that is what.
What to do? It is their duty to come before the court. We just can't, pass orders just like that. No, I think that this is the wrong procedure that is adopted here.
No,
The party who is concerned, returning officer, whoever
Please,
it is,
please,
they
please,
should come
madam.
before the court and file their objections and say, why should we fix a date and again adjourn the matter? If they file a vacate petition, it will come. From now onwards, I'm going to pass any interim order is until further orders, unless and until the state files this counter, nothing will be entertained. Yes, Mr. AG.
These cases of
Please tell one thing I want to know.
Please.
In the writ petitions of 2025,
Yes.
how many writ petitions are filed? In how many matters the government has filed their objections? If you tell the court will be happy to know that. Not even one, not even one. At least I must have seen 15 to 2,000 cases in this couple of,
Please.
not even in one case, the state will file the objection. What is this procedure? I'm not able to understand. And how the court is functioning like that is a very strange.
Yes, we require to file the objections, my lord. But many cases, my lord, there are two.
And I will also pass a judicial order now saying that as per the writ rules, within so and so time,
Please.
if the state fails to file their objections, it is deemed to be that there are no objections and the writ petitions have to be allowed on that ground.
Yes, in respect of, yes, my this is a.
It's a very bad procedure.
Yes, yes. In respect of the additional advocate general office is concerned, the problem is many cases we are not receiving the parawise remarks, my lord. That is a one.
That is not anybody's concern, neither the petitioner's concern nor the court concern.
No, yes.
It is
I'm not telling.
you and your clients.
Yes.
And as AAG, why I am asking you is, you are the one who has to.
Yes, yes, it is my
inform
responsibility.
The government what is
Please,
happening.
please.
And now, from now onwards, in all the
Well,
writ
now,
petitions.
after the lordship direction, my lord, we have proceeded with filing the objections, my
It
lord.
is so unfortunate that the court has to give directions for the state to file their objections, which was not being done from decades together.
No, I've already instituted.
What I'll do is,
Please.
from now onwards, I'm indicating and doing it.
Please.
I will grant the interim order until further orders wherever the state is a party, so that either the state or the affected parties, till they come, the stay will not be vacated. So that we will at least get into the practice of filing objections. This is high time we should do it.
Yes, sir. Yes,
No,
ma'am.
the other day when the tender matter has.
Yes, that also, my lord, that is mistake on part of our officers, my lord. We should not have taken the notice in the first day itself, my lord. It's a board and corporation, my lord, is represented by the separate panel council. That is, it is our duty. No, it is our duty, my lord. We should bring to the knowledge of the court, my lord. We could not have been accepted the notice, my lord. There is a separate corporate, the panel
And I want you
advocates.
to issue a circular by the government or anybody saying that in all the matters, in all the writ petitions, wherever the state is a party,
Please.
the concerned officer shall file the
Yes.
objection within 4 weeks.
Please.
Or else action shall be initiated
Please.
against the concerned who
Yes.
is not filing objections. You
Please.
should or else if you want, I can pass a judicial order.
Madam, may I request, let there be in one case, there will be judicial orders, my lord. To enable me to, my lord, to.
I will pass an order.
See, in one case, my lord, with the.
Today itself I'll pass in one of the cases.
Please.
And let that be
Please,
implemented.
because,
Or else
that-
I'll also say that after, as per the writ rules, how many days?
It is 14 days only it has to be filed.
Then that 14
From
days only
from
I'll
the
say.
date of the notice, it is 14 days we have to file it.
If they fail to after notice within 14 days, because once you're appearing in the court, that
Yes.
amounts to notice.
Yes,
From
yes.
there, 14 days, if you don't file your counters, your objections, that is, you have waived your right to file the objections and you will not be permitted. And on that ground, the writ petitions they will start allowing the writ petition. Because state is.
Yes, it is our duty to assist this court by way of and many cases, my lord,
Just know in the other matter, she
Is-
submits that the returning officer says
But in the-
that I have not followed 13(3). What is the returning officer doing? At least some instruction should come. If she is not represented, you are not representing, some advocate should be representing her, and some paper on something that should be given to the court.
Yes.
Basing on these kinds of instructions, if an order is
no,
passed,
it is amount to, yes, miss.
that is saying that she has not issued 13(3). Who is saying it? On what capacity? And how it has to be considered by the court?
Yes.
If the state is vigilant and if the state is that they're filing objections before the court, I don't think this would be the number of writ petitions that are pending
Yes.
before this court.
Yes. Yes, it is our duty to file it, my lord. Otherwise, we can't give the valid assistance this court, my lord.
Because you
Cases
are
where
not
moreover.
expected to know.
Please.
You are not expected to know without they filing the objections.
Objections.
And even the government advocates also, how will they know?
No, it
when the
can't be.
officer
It
coming?
can't be. It can't be.
And even that is like very embarrassing for them also.
Yes.
Before the court to tell every day that we don't have instructions. I will pass an order. I will give all these directions. From hereafter, wherever you don't file, you have waived off your right to file the objections. That would be the order.
No. So at present, my lord, we will ensure that, my lord, let there be direction, the general directions, my lord.
And
But,
what about this? What has happened to this tender matter?
the
You
ta-
don't have any instructions on
No,
that?
no, but we can, there is a separate panel council for that, my lord.
And one more thing, where is the list of panel councils? None
That-
of them do know.
That is,
that
this court has maintained that, my lord, in the last, there is a separate list of the panel councils, my lord. In last, we have made an effort to,
If you have it, who is
and
the
it- and
panel
it is,
council for that?
and it is uploaded in the High Court website also, my lord.
Who is the panel counsel in their case? In the tender matter, who is the panel counsel?
It is uploaded in High Court website also.
Who is he? Does it have a panel council? Karnataka Building and Other Concerned Works Welfare Board. Huh? You should have kept it by this time. I told you long back to get it. Yes. Please take out hand summons on this and file a memo, then it will, I'll take it up on Wednesday. The petitioner is permitted to take out, and the learned HCGP takes notice for the first respondent, 2 and 3. Then counsel for the petition is directed to take hand summons and file a memo. Once the memo is filed, list this matter. Wednesday.
Wednesday.
Yes.
4.
Next.
Seal number 13.
Please. 13th is. There is election matters.
It will
Please.
come once they file.
Please, my lord, please.
Interim order extended until further orders.
Seal number 14.
In this matter only, and in this, give that file.
Please, please.
In this case only, I'll pass orders, Mr.
Yes, sir, please, my lords.
AG.
Yes.
In the same order, I think like returning officer, I think I said in the earlier case, in that you find. This court is observing that in none of the writ petitions, the state is filing its objections. This court, from the last 2-3 weeks, have observed in hundreds of cases that right from the old matters till 2025, none of the cases objections were filed. In the writ petitions, the whole purpose of granting, the serving notice to the respondent government is to ensure that they get instructions on time, which will facilitate the court to pass orders. It appears that there is no such procedure adopted by the government, and why the officers are not giving proper instructions, filing objections before this court, it is not known. This kind of an approach is not expected from the state, which is the major litigant in all these writ petitions. As per the writ rules, after service of notice, they have to file is it 14 days?
Within 14 days.
Within 14 days, they have to file their objections. Unfortunately, even after 10 years also, they do not file objections. Hence, this court is of the view that whenever the objections are not filed as per the writ rules, the right to file the objections forfeited, and on that ground, the writ petitions have to be allowed. Even a mandamus writ petitions which are filed years ago are still pending before this court. This kind of an approach cannot be entertained, appreciated by this court. Hence, today, this court has called the Additional Advocate General and also brought it to his notice that this is the way the matters are pursued by the government, and it cannot go on further, and the consequences the state has to bear. In this matter, the returning officer, even after issuance of, after receiving the notice, has not come before the court, but informs the government HCGP that she has not followed 13(3). Hence, the writ petition may be allowed. That cannot, the court, basing on those kind of instructions, cannot pass any order. It is the responsibility of the returning officer to come before the court and by engaging an advocate and file her objections, if any, before this court. It is submitted by, you represent whom?
I'm respondent number 6.
Respondent number.
That's
Learned
cooperative
counsel
society.
Representing respondent number.
6 members.
Respondent number 6. There is no respondent number. Only 4. In the first matter, you don't appear.
No, second matter, that is still number 13.
Learned
1 3.
counsel appearing for the
13.
unofficial respondent submits that. It is an election matter, and as it is stated by this court, as there may be orders. Whatever it is this court, without the said instructions being on record, cannot pass any orders. Interim order earlier granted is extended until further orders. So in the next case, just interim orders earlier granted is extended
Please.
until further orders. Yes, next.
14.
Yes.
Summons have been, copy has been served to the council for the appearing before the.
You have served the copy.
Please.
Take that. It is submitted that as per the order dated 23/1/2026, the petitioner has served the hand summons on the council appearing for the respondent, and a memo is filed in that regard. What is the name of the advocate?
My lord, sir, yes, BB Sangwade,
So it's better in the memo that name should come.
please.
It is submitted that they have served the memo on so and so. Print the name of that advocate in the causeless. The notice to so and so is held sufficient. Yes. You have an interim order?
Please.
Order earlier granted is extended.
Maybe date may be fixed for final. A date may be fixed,
Yes.
please.
6 matter, no urgency.
Please.
Is 15.
Hearing on
My lord, sir.
Seal number 15.
Senior counsel is online.
Appear on behalf of the petitioner.
Be convened.
Appear on behalf of the petitioner college.
Yes, yes.
My lord, my lord, the petitioner is Ayurvedic
The other
Medical
team,
College.
With the permission.
Running
One
from
minute, Mr.
19,
Yes.
please.
My lord, on the other day, my lord, your lordship has directed me to get the judgment. But wherein, my lord, in case the college has violated, my lord, any rules, Lord, the Honorable Division Bench, my lord, Bangalore, my lord, has imposed a penalty on the colleges, my lord, and regularized the, my lord, the admission of
My lord,
students.
my learned friend also, my lord, should be fair to the court. My lord, because this order has been stayed by the Honorable Supreme Court, and there the facts are different and the facts are different here. He should be fair to the court, my lord. This interim order, my learned friend will produce, my lord. There is a stay of the interim order.
Let us see on what grounds this writ petition is filed.
The instant writ petition, my lord.
Yes.
My lord, there the division bench, my lord, there the division bench, my lord, had imposed cost because they were illegal.
Let's not go into that order. First,
Yes,
let's go with the merits of this writ petition. Yes.
Please. Now, my lord, in this matter, my lord, from 1991, my lord, the college is functioning without any complaint whatsoever. My lord, we have the permission to run, and permission has been given every year. Now, my lord, only during the
When
COVID
was the
period,
first permission given to this college?
beg your pardon, my lord.
When was the first permission given to the college? When was it established?
My lord, in the year 1991.
From 1991 till this order dated 2021, there is a continuous.
Continuous permissions every year.
And
Correct?
And
Yes.
subsequently also, my lord, even
24, 25.
24, 25 also. So it's only during this period, only during that particular, during the COVID times.
Yes. Yes.
So
Let's look at the input order.
yes, ma'am. Now, my lord, there are twofold submissions, my lord. One, on the technical aspect, my lord, though on the merits, my lord, I will submit, my lord, because with regard to now, what has happened, my lord, is this matter had come up before the learned single judge on an earlier occasion where they were directed to, my lord, look into, my lord, because their basic objection is that faculty members are not enough. But now, as per their own rules, which prescribes 26, and as per their own report filed on the last date of hearing, my lord, now they are more than 26. However, my lord, may I just take your lordships to the impugned order that's at Annexure E. Annexure E, my lord, at page 26.
Yes, let's read the order.
Yes, ma'am. If your lordships would turn to page 28, my lord. Para
I think we'll see from the beginning so that the court will understand what exactly is the whole thing.
Yes, yes.
May I read, my lords? Please. With reference to the subject mentioned above, I am directed to inform you that in pursuance of the provisions of the National Commission for Indian System of Medicines Act of 2020, the Indian Medicine Central Council Act of 1970, 48 of 1970 has been repealed with effect from 11th day of June 2021. With effect from the said date, the Central Council of Indian Medicine, constituted under subsection 1 of section 3 of the Indian Medicine Central Council Act of 1970, has been dissolved. Now, in exercise of the powers conferred by subsection 3 of section 1 of the said act, the central government notified that all the provisions of the National Commission for the Indian System of Medicine Act of 2020 has been come into force with effect from 11th day of June 2021. In view of the above, the central government constituted the autonomous boards with effect from 11 June 2021, and as per Regulation 59 sub clause 2 of the National Commission for Indian System of Medicines Act of 2020, medical standards, requirements, and other provisions of the Indian Medicines Central Council Act of 1970 and the rules and regulations made thereunder shall continue to be in force and operate till such new standards or requirements are specified under this act or the rules and regulations made thereunder. Further, the provisions of the consent regulations which are inconsistent with the provisions of NCSM Act of 2020 shall not be applicable. As per the Indian Medicine Central Council requirements of the minimum standards for undergraduate and Ayurvedic colleges and attached hospitals regulations 2016, 3 subclause 1 subclause A, the Ayurved colleges established under section 13A and the existing under section 13C of the Act and their attached hospitals shall fulfill the requirements of minimum standards for infrastructure and teaching and training facilities referred to in the regulation 4 to 11 up to the 31st December of every year for consideration of grant of permissions for undertaking admissions in the coming academic session. However, Government of India, Ministry of Ayush, via its letter dated so-and-so dated 26/3/2021 and 15/4/2021, issued relaxation support policy for Ayurvedic ASU and S colleges in unprecedented times of COVID-19 pandemic for the academic session 2021 and 22. And as per the policy, the colleges to be considered on the basis of Part 1 visitation pro forma submitted by the college, provided that the college shall submit an undertaking and indemnity bond stating that they shall fulfill respective requirements in terms of the required teaching and training facilities specified in the relevant regulations throughout the academic year. Further, in view of the above, the college has been assessed on the basis of the consent regulations and relaxation policy issued by the Ministry of Ayush and on examining in terms of the Indian Medicine Central Council requirements of the minimum standards for undergraduate Ayurved colleges and attached hospitals regulations 2016, provisions under the NCASM Act of 2020 and relevant regulations thereunder, it is found that the college is not fulfilling the following notified and approved criteria for granting conditional permission for the UG BAMS course for the academic year 2021-22. Shortcoming as per Part 1 submitted by the college teaching staff. College is not fulfilling the criteria of 11 higher faculty in Pearl department. Shortcomings in teaching staff are as under the minutes that table minutes. Then details required as per the regulations.
Let's see, Ayurveda, so and so.
Yes.
One
Yes.
HF means?
Minutes further it gets modified minutes. This is the basic prima facie opinion that they form.
Higher
faculty.
Higher faculty.
Yes. It gets modified minutes further in due course. Details required as per the regulations minutes that we can skip minutes. Paragraph 4 minutes. Therefore, under section 20 and 29 of NCASM Act of 2020 and relevant regulations thereunder, and to follow the principles of natural justice as mentioned in the Constitution of India, an opportunity of hearing was granted to the college on 1/10/2021 to present the case through virtual mode. Whereas the college through its representative, Dr. S.R. Jagirdar, Principal and Inamdar College, Principal and Inamdar Secretary, appeared before the hearing committee on 1/10/2021 and made their submissions virtually against the shortcomings communicated by hearing notice dated 28/9/2021. The shortcomings communicated to the college, submissions made by the representatives of the proposed college and observations made by the hearing committee are as under. Minutes of the hearing committee. SSV Ayurvedic Medical College, Sonso District, Gadag. Teaching Jagadish working as a professor in Samhita Siddhanta department. He is graduate and joined on 1/9/1988. He worked in the department of Samhita Siddhanta as lecturer during 1988 and 1992. After that, he had worked in Rasa Shastra and Bhasajna Kalpana on 14/8/1992 to till 2012 as professor and principal. On dated 1/5/2020, he was shifted to Samhita Siddhanta as professor and till date institute showing him as a professor. As teaching is non-PG, So as per the consent regulation, non-PG teacher cannot be shifted to other departments. Swasthya Vritta, no higher faculty available. Rachana Sharira, as per their submissions, they joined reader, but not added in part 1. Balaroga, as per their submission, they joined reader, but not added in part 1, but no lower faculty available. Kaya Chikitsa, Dr. Gargi joined on 1/7/2021, but not reflecting in part 1. Kriya Sharira, Dr. Taufik joined on 1/4/2021 as lecturer, but not reflecting in part 1. There is no lower faculty in Balaroga department. Website is working and updated. However, as per the Indian Medicine Central Council requirements of the minimum standards for undergraduate Ayurveda colleges and attached hospitals regulations 2016, 3 subclause 1 subclause G of the position prevailed on the date of visit to assess the fulfillment of requirements as specified in these regulations, except sub-regulation 2 of regulation 7 shall be taken into consideration for grant of conditional permission. Whereas the observations of hearing committee based on the submission made by the college representatives during hearing and assessment report of the medical assessment and rating board have been carefully examined in terms of consent regulation, and it is found that the college is not fulfilling the following basic eligibility criteria for UG BAMS course under section 28, 29 of the NCSM Act 2020 and relevant regulation thereunder for the academic session 2021-22 due to the shortcomings in the teaching staff as under. Now, my lords, this is a conclusion. There is no faculty available in the Department of Kaya Chikitsa as per RMS 2016. College is not fulfilling the criteria of minimum 12 higher faculty in 11 department as per RMS 2016. Please.
College is
My
not.
lord, now here, my lord,
Yes,
may
sir.
I make this submission? Now, on one of the technical submissions, if your lordship sees paragraph 7, whereas the observation of hearing committee based on the submission made. So there was a hearing committee which heard the matter. However, my lord, if your lordships were to turn to para 9 of the impugned order, my lords.
Yes.
Here it says, therefore, it has been decided by the president, medical assessment rating board Indian so-and-so to issue denial of permission to so-and-so. So, my lord, now this has been heard by somebody, order is passed by somebody else. In fact, my lord, there are 2 judgments of this honorable court which say that the person who hears, my lord, your lordships are aware, my lord. I don't really have to even show those judgments, but those judgments are there, my lord, where the person who hears, my lord, will have to pass the order. So that is on the technical aspect of the matter. But that does not mean, my lord, that we don't have case on the merits. My lord, now here, now what they say, my lord, the faculty, if I may be permitted to take your lordships to the regulations, my lords. Because there, how many faculty members and how many? So that if your lordships would get it at, my lords, page 55, my lords. Page 55. My lords got.
Yes.
My lord, in that note, Roman 3, my lord.
Where is 55? This repetition,
Page.
the total pages are 27, 30. 29 pages are there in this.
My
Lords,
lord, this
you must
is
be
the
referring to memo.
regulation.
Have you filed?
No, my
Then where is 50?
lords, I am not. In the memo, my lords, I think you must be referring.
Oh, even that memo 50 is about.
No, my lords. There are, my lords, totally 3 memos, my lords, which are filed. One memo is filed by us, my lords, giving all the details. And my lords, 2 memos are filed by the other side.
My lord, I apologize, my lord. Probably I didn't give my lords the correct page number. My lord, if your lordships were to look into the
He is
regulations.
referring to memo, my lords. I can assist him with the page number, my lords. Memo or what is he referring?
Yes. Gurudev, I looked, Mr. Gurudev, please show in that schedule 5, Roman 3.
Schedule.
May I, my lord, may I just read it, my lord?
This is the one. This is the one.
Yes.
My lord, in that, if your lordships were to turn to schedule 5, in that below, my lord, the tabular form, there is a note in that Roman 3, my lord. My lord's got it.
Yes.
My lord, in that Roman 3, may I read it, my lord? The deficiency of teachers for up to 60 intake capacity shall not exceed more than 10% of total requirement with availability of minimum one teacher in each of the 14 departments. The total number of higher faculty shall not be less than 12 professors or readers distributed in minimum of 11 departments. This relaxation for seeking conditional permission to undertake admission for particular academic session. For example, the college having up to 60 intake capacity shall have a minimum of 27 total faculties, out of which minimum 12 professors, readers covering not less than 11 departments. Now, my lords, here in the note filed by NCISM, the National Council for Indian Medicine, they themselves now, my lord, show that there are 28 faculties. So it is not a case that those faculties are not there. My lord, because if your lordships were to see, there were a series of orders passed by the learned single judge, because there was confusion, my lord, because in respect of some faculty members, my lord, the code, my lord, was not entered. That my lord would, my lord, see that it is just a irregularity, and it is not that. So for that, my lord, if your lordships were to turn to the order sheet, my lord, like my lord, I would just very quickly take your lordships, my lord. Otherwise, I wouldn't have pointed out the orders passed by the learned single judge on earlier occasion, my lord, because those orders, my lord, now have culminated in a memo filed by the respondent NCIM. That, my lord, if your lordship sees the order dated 11/2/2025.
Yes.
My lord, in that para 10, my lord, I'll not take your lordships to the entire thing.
Yes.
Though the petitioner is directed to furnish all the details in the physical format, a report is also directed to be prepared by the NCISM as regards all the details required for the NCISM to consider the approval of the petitioner college, including the details as indicated above. As such other details may be required, the said software to enable the generation of the report to be implemented within 1 week from today. The petitioner shall submit all the details in the physical format within 3 days from today. The last date for payment, my lord, then that interim order is passed. Subsequently, my lord, then and on 22/2025, my lord, time was sought to file the report. Then your lordship may kindly turn to 24/2/2025. Like how, my lord, the NCISM, my lord, in spite of the orders passed by this court, this is important, my lord. A memo, my lord's got it, my lord. Order dated 24/2/2025. My lord's got it. My lord, a memo along with the, yes, ma'am. A memo along with compliance report has been filed by the learned counsel for respondent number 2 to 4. Once again, similar objections have been raised regarding eligibility of some of the professors, respondent number 2 to 4, who had been directed to go through the documents in detail, verify the details already available on the website of the NCISM to ascertain the eligibility of the lecturers to be professors and are eligible to teach certain subjects. Today, for example, there is an objection to the candidature of Dr. S.R. Jagidar and professor contending that he does not have the postgraduate degree. An examination of the biodata of Dr. S.R. Jagirdar indicates that he is the principal of the college, that he was born on 21/7/62. He had passed out in the year 1987 and has been employed since then in teaching roles in various colleges. Thus, in view of the clarification issued by the Secretary CCM that the requirement of a postgraduate degree for employment as a professor would apply only to a recruitment made after 1/7/89 and not before. The said clarification having been issued way back in the year 1991 has been completely disregarded by the persons who have formulated the table attached to the memo filed by the learned counsel for respondent 2 to 4. Though the court would be well within the jurisdiction, your lordship may mark this, to take immediate action for such misleading of the court, one more opportunity is granted at the request of so and so learned counsel to tabulate all the details properly after examining all the documents in proper manner. It is if again similar issues are found, then this court would have to issue necessary directions for disciplinary action to be taken against the concerned officers, so and so. So, my lord, after this my lord, then they file. Now, my lord, which the regulation which I pointed out, now even according to them, my lord, there are about 2 faculties, my lord, more than what is required. So if your lordships were to see the, my lord, the memo filed by them, filed by the respondents, my lord, subsequent to the order passed by this court, they filed 2. One, again, they made certain changes, and then again they filed it on 25/2/2025. So, my lord, this, if your lordship sees, Mr. Gachinat can show the 25/2/2025.
25
my
to
lord.
2025. Memo dated 25 to 2025 at page 11, my lords.
The last memo in this case is on 4/1/2026. One is on 11/2/2025.
No, 25 to 2025, one more, that the memo has been filed by the other side.
It's not there
But
in
I
the
think the office objection is, it says, if I'm not mistaken, my lord, the cause list says otherwise, that it has not been, I'm not sure whether, my lord,
It's
they
been
have only
filed, my lord.
served
It
a
is
copy.
handed
I'm not
to
sure
the
whether it
court
has
on the physical.
been filed
In open court,
registry.
please, my lord. In open court, my lord, it has been.
Memo dated 25 to
25 to 2025, my lord.
Not here.
My lord, because
That is
the
24. Page 11.
Yes.
Page 11, notes.
So, my lord, if your lordships were to turn to page 11,
Yes.
the second tabular form,
Notes, I think the connectivity got lost.
Lord. Page 7, my lord.
So
How many
page
total?
11.
35.
Lords, page 11, if my lords could kindly see, my lords, that the Sri SP Siddhaling Shivacharya Swamiji so-and-so hospital,
Out of 35, they
out
said
27,
3, 4,
yes,
5,
lords,
6.
20, I have counted that, lords, 28 are found to be eligible.
No, he said 6 are not eligible.
28 are found to be eligible, lords, whereas requirement is only 27, as per the RMS regulations.
No, not like that.
No, they say,
Lord,
lords,
page
can
number
be
7, my
considered
lord.
as eligible faculty.
Lord, in some of the subjects, my lord, Lord, there are professors, my lord, who are working in the said college, my lord. We are not denying that.
We are
My
not
lord,
going into that. Please come to the table that is furnished by you at page number, page number 11.
Lords, 11, 12, 13 and 14, lords, all consolidated.
Let him say, yes, 11.
please.
No, as far as Jahagir is
Please,
concerned,
my
you
lord.
said
My lord, insofar as he is concerned, my lord, I have
eligible, you said.
no. Please, my lord, please, my lord. At page number 7, my lord. At page number 7, my lord, Mr. Jagirdar, my lord. Lord, he was a faculty appointed as a professor in the department of Rashi Shastra.
No, no. We are
Kalpana.
not into whether he is eligible or not. Let's take it as of now that he is not eligible.
Eligible, my lord.
What about
Next, my lord, Sutara Taufik.
6?
To my lord, Dr. Sutara Taufik Apso.
No. 6, serial number 6. You
Yes.
said they are not.
Please.
Again, for 7.
my lord, serial number 2, 3, 4, 5, 6 are all, they say, can be considered as eligible faculty in the last column.
I'm only referring to who is not eligible.
Yes. No,
Yes.
why we wanted to
So,
give this context was,
in page number 11, there are 2 people who are not eligible.
Please.
In page number 12, there are 2 people who are not eligible.
Please.
You
Yes.
don't have the memo?
We
Mr.
have.
Counsel.
Yes.
Yes,
Please.
sir.
I have a
He's a
copy.
referee.
So in page number 12, there are two people
Yes.
who are not eligible.
Please.
Because you have
Yes.
made it in block.
Please.
Then at page number 13, there are one, two,
Two,
three
three, ma'am.
people who are not eligible.
Please.
That's it. So
Please.
altogether, how many? 3
Oh,
plus 2,
35.
5 plus 2,
Please.
35 minus 7.
Please, my lord. That is why, my lord. In conclusion, my lord, may I request your lordship to conclusion? My lord, the report has been submitted by the.
5 minus 7 is 28.
Please.
According to you, 28 people are eligible.
Please, my lord. In different subjects, my lord, but in certain subjects, my lord.
Let's go.
Please, please, my lord, page number 9, my lord. This is a report submitted by the, my lord, the professor of the NCISM main head of the department, my lord. Conclusion part, my lord. I may be permitted to read this.
Page number?
9, my lord.
Yes.
The conclusion part, my lord, with the permission. The following faculties were not considered in their allied subjects, namely Dr. S. Jagirdar, Dr. Nagaraj Nadgir, Dr. Avni, as these faculties do not have PG qualifications.
Let's not confuse, neither you, don't confuse the code, don't get confused.
No, no, my
What
lord.
I wanted,
Please.
now you have given a tabular form. In the tabular form, you have already mentioned these people's name. Again, we don't have to look at it. Those were, now, as of now, we are accepting that they are not qualified. They are not qualified. So excluding the unqualified people, according to you, qualified people are 28 in number. Is it correct or not?
Please, but my lord, but the thing is, my lord, in certain departments, my lord, at least one higher faculty should be there, my lord. In certain subject, my lord, that is why, my lord, the impugned order they mention in certain, my lord, departments like, my lord, Shalya Tantra, my lord, like this, they have mentioned.
Let us take that there are 28 higher qualified professionals available in this college.
Yes. Please.
Is it correct?
Please,
Is
my
it-
lord.
You accept that?
Please, my lord.
Yes. Now, come to the department wise. Where do you get that?
Please. My lord, page number 7, my lord.
7 of your memo.
Please.
Do the file.
Memo.
Yes.
My lord, insofar as these doctors, my lord, I may be permitted to read because, my lord, they have, my lord, have a PG degree in some other subject and teaching in some other subject, my lord. That is our main, my lord, concern. Because, my lord, if, my lord, they are qualified with the allied subject, my lord, they can teach allied subject. But the professors who have qualified in a certain subject, my lord, they can't teach in another subject, my lord. That is why, my lord, page number 7 of my memo, my lord, the following are the discrepancies found during the verification and Excel visitors report. Dr. Jagirdar, faculty was initially appointed as a professor in the Department of Rasha Shastra and same was approved in his OTMS, my lord. My lord, OTMS, my lord.
No, it would have been very easy. What are all the subjects? What are all the subjects? According to you, according to them, who is teaching, who is eligible, not eligible, in the same.
My lord, only, my lord, because only these 6, my lord, who are not eligible, my lord, in the impugned order, it has been clearly mentioned.
My lord, may I make this submission? Though there was a direction to my learned friend, my lord, then my learned friend, when he files this report to this honorable court pursuant to the directions issued by the learned single judge, my lord, he should not have written in the last column, can be considered as eligible faculty in respect of all these. And my lord, I my lord, read out the order.
It is such a simple issue. This issue
My lord, I have made a report, my lord, the another copy I have submitted. My lord, in Ayurveda Samhita and Siddhanta, my lord,
Where do I get that?
my lord, in another memo, my lord,
Give that.
please. My lord, I have mentioned it. These are the shortcomings, my lord.
Give him a copy of it.
I have given one.
And may I make this submission also, my lord?
Yes.
My lord, it's only during that period, my lord, this discrepancy. Now, the same college, my lord, they have given us the permission for the last
And
2 years.
subsequently,
this
we have
year
given
also.
permission, my lord.
We have
Insofar
been
as that
given.
year is concerned, my lord.
So it obviously means, my
For
lord,
2
that there
academic
is
years, it's
total
been rejected.
compliance. So it is not that there is no compliance. So there is, and the students, my lord, have taken exams. They are all in third and fourth year.
One higher faculty is, my lord. There is no higher faculty in that, my lord.
Shortcoming is
Please,
one higher faculty.
please.
Then
Like that, my lord, I have the only copy.
what I am asking.
Please.
No, the whole purpose of this regulation is to give the children good education.
Please.
With the orders of the court, all that things have happened. Now they have studied, they
Please.
have completed. Now, more or less, now it has become an academic purpose now. That's what the other day also I told.
Please. But my humble submission, my lord, after passing of this order, my lord, there is an appeal provision, my lord, under the authority itself, my lord. There is an appeal provision under 24(6) of NCSM Act. No, my lord, that is one of my submissions, my lord. If, my lord, because, my lord, we don't have any objections, my lord, insofar as the student's interest is concerned, my lord. Because in other, my lord, other writ petitions also, my lord, this court has protected the interest of students and permitted to, my lord, appear for the exams. My lord, insofar as,
First of all, in these kind of deficiencies,
please.
courts shouldn't pass order permitting them to take the children, take the students. Now, first step is over. After that, court will protect the interest of the children. Ultimately, courts are protecting the interest of the institution.
That is why, my lord, in this writ petition, my lord.
How the interest of the students is protected when they are not getting
Please,
the proper
please.
education as per the standard fixed by the council.
Please, my lord. Because the interest is protected only because the admissions have been approved based upon the interim orders, my lord. That is the reason, my lord.
That order shouldn't have
No,
been.
my lord, but
Please.
it is not as though, my lord, it is not as though that.
That
there
is why,
was
my
no
lord,
faculty. As
in
your
writ petition, my
lordships
lord,
saw,
though it might have
as
been.
your lordships, my lord, are aware and saw, my lord, that those faculties are there. My lord, it is not, and in respect of some, they say, my lord, the teacher's code has not been uploaded. So that's why, my lord, in that earlier order passed by the learned single judge, they said that you can have a look at it.
No, it is now entirely, the court has run the entire court, the institution is run by the court by giving permission to that, permission to this. If whether they are qualifying or not qualifying should have been decided at the earliest. And if they are not, they are not permitted to take the students. If they are running the college without the contrary to the council's regulations, what is the purpose? There should have been an order at the.
I understand. My lord, I understand what your lordships are saying, that, my lord, the courts are virtually, my lord, allowing the students to take up. My lord, but your lordship may kindly see, prima facie, my lord, what has happened in the matters. My lord, they, my lord, don't come forward, they don't file their objections. They don't, my lord, say as to what. If your lordship sees, my lord, I wouldn't have generally referred to the earlier orders
Very
passed.
conveniently,
But
1 minute, senior counsel, very conveniently, this petitioner would come to the court before the last date of every time. Orders have been passed looking at the grave urgency, like the other day also, when this matter
Yes.
came up before the court, that was the grave urgency. So that's what this has been operating from the last 4 years.
My lord, I understand. My lord, my only submission to your lordship is, my lord, that till 2021-22 during that COVID period and subsequent to the COVID period, my lord, the college is completely compliant. My lord, I can understand this is not a case where my learned friend, my lord, was trying to rely on a judgment which has been stayed by the Honorable Supreme Court. There, illegal admissions were made. So, my lord, this is not a case where we have made illegal admissions. It was only a case where, with regard to the faculty, and as your lordship saw, there are enough and more faculty are already there and teaching.
Because court has given you permission to take students.
Not with.
No, my lord, students, there is no issue with regard to the students. There is no issue with regard to the intake of the students or illegal admission. My lord, my learned friend is relying on that division bench judgment where, my lord, though there is a procedure that is through NEET and that KEA, my lord, Karnataka Examination Authority, they have to come through them to the college. There, what the colleges did was, they took the students directly. They didn't take them from the pool. That's why, my lord, the courts were a little upset and said that the Honorable Division Bench said that as a deterrent, so and so cost is imposed. My lord, that has been stayed by the Honorable Supreme Court. My lord, the copy of the order is there. My learned friend, my lord, Mr. Gachinmat will show it to your lordship. Even otherwise, my lord, my submission is this, my lord. Now the students, my lord, are already in the 3rd and the 4th year, my lord. They have already, and my lord, the other students are studying. The college, my lord, they have given us the permission this year, previous year, and the previous year, my lord. Only during that particular period, they say it is non-compliant. Even for that, my lord, we have produced. And my lord, Jagirdar, every time they come up with a thing postgraduate degree, that, my lord, we pointed out that if he's appointed prior to 89, my lord, that PG is not required. My lord, all those, in spite of the court directing them and saying that if you again and again do this, we'll have to either take disciplinary action against the institution.
No. I just want to, you please point out one thing. What is wrong with the impugned order? Are leaving away the technicality, According to you, what is wrong with the impugned order? That I want to,
My
I
lord,
want
the
to
technicality
understand.
also will have to be seen, my lord. My lord, the technicality also will have
No,
to
that
be
we will
seen
see.
for
That I
this simple
understood
reason,
that
my lord.
the
There is
authority
a
who heard.
my lord, because if yes, my lord, there is
Was
a direct
misjudgment.
judgment on that, my lord.
That
There
we
is a
will see.
direct
We will
division
see.
bench judgment. My
That we
learned
will
friend will
see.
give it to
No,
your lordship.
apart from that, what is wrong
Yes,
with the order? As on that day, whether this
my
college
lord,
is fulfilling the eligibility criteria for grant of permission.
they are. My lord, as
Page
on that date,
58.
they are
How?
fulfilling because what they had said was not correct. If your lordship turns to annexure E, my lord, it is only
Yes.
because of whether they had fulfilled or not, series of orders were passed. So what now they have said that these are the eligible faculty members. What they are saying that they are talking about what they were
No,
eligible
for the
as on that date.
understanding of the court,
So my
court
lord, because
wants to
there was
understand from the impugned order.
yes, ma'am.
Court wants to understand from the impugned order saying that they
Now,
said
my
this
lord, now the
person is
impugned
ineligible.
order. Yes, my lord. Now if your lordship sees,
Yes.
yes, my lord. Now if your lordship may kindly turn to page 28, my lords.
Yes.
Now, in
Yes.
page 28, after 7, my lord, 1, they say there is no faculty available in the department of Karya Chikitsa as per so and so, my lord, that there is a department, we appointed that out. I'll come to that a little later. Then colleges is not fulfilling the criteria of minimum 12 higher faculty in 11 departments as per RMS 2016. So that's so and so. College submitted a list of 35 teachers in the list of teaching faculty submitted Excel, out of which 6 teachers are not considered due to the following reasons. So, my lord, the order says 6 teachers only out of 35. Now, your lordship may kindly see some of the objections are, if your lordships were to see, my lords, has one not considered as a teacher has neither updated the OTMS profile nor having the new unique teacher code. Then Nagraj not considered eligible as provision of allied subject. Here, my lord, they are not correct. They are not correct, my lord, according to their own rules. If he has been appointed before 1/7/1989, my lord, then he need not have PG qualification. So they are not correct in saying so. Then third, not considered eligible as provision of allied is
So
not applicable.
One, what do you say about one?
My lord, now with regard to one, not considered eligible as teacher has neither updated his OTMS profile nor having the new unique teacher code. Now, my lord, this, in fact, when the earlier occasion, my lord, the learned single judge had asked us to file all these documents we had filed. There, my lord, that detailed order, I did not want to waste your lordship's time. There they have said that teachers' codes are mentioned. They said, you please hyperlink, find out the teachers' code. They were directed to do that. Now, my lord, your lordship, my lord, at least one. My lord, I'll come back to one a little later.
Lord,
My lord, your lordship, kindly see
Lord, now,
serial number 2,
No,
serial
we'll ask
number
him
2
about
and
one.
3.
We'll ask him about one. Yes.
2
my
and
lord,
3, my
in
lord, may I
online, my lord,
just
in OTMS application, my lord, there was no, my lord, because the all the, my lord, information insofar as these professors are concerned, my lord, it is uploaded in the website, my lord. But in that, my lord, that is OTMS application is called. But in that,
Now, in this new list which
there
you
is
have
no code.
provided,
Please,
the list you have provided, what did you say about this?
please,
Tariq,
but the
Siddharth
first,
Taufik, where is he? It's serial number what?
please.
Siddharth Taufik, even today you said he is not eligible. On
Even not even
verification,
today, my lord, as on that day.
on verification,
Please.
it was found that neither his teacher code nor TCRA is available as he has not applied for the same. Therefore, cannot be considered as eligible faculty.
Please, my lord, and my lord, another issue, my lord, in annex.
Only clarify about this, so Sutra Taufik.
Taufik, please. My lord, he's, my lord, page number 7, my lord.
When he has filed this memo, have you filed any reply to this?
No, we have not filed reply to this.
He has stated that so and so people are not eligible.
Uh,
Because this issue has been made so complicated, there is nothing in this. When you are
yes,
saying that so and so is not qualified. Now, for a particular department, there should be so and so high qualified people.
Please.
Where it is there, where it is not there. By giving this this tabular form, are you saying that Because there are 28 people, you want 20, what they are saying is.
No, no.
You want 20, but why?
My lord, number of, my lord, they are saying about the number of professors who are working in that college, my lord. My lord, my submission is this, my lord, in the impugned order.
Lord,
It's
can they
clearly
be,
mentioned in
my
the
lord, can they be allowed to shift the goalpost every time? My lord? Now your lordships were referring to the impugned order.
In the impugned
Now
order,
your
my
lordship
lord.
may kindly, my lord, your lordship may kindly come to serial number 2, 3, 4, 5 and 6, my lord. Now serial number 2, that is Dr. Nagraj Nadgir, my lord, and then serial number 3, C.S. Hiremat, then serial number 6, Dr. S. Sayani. My lord, all these, they're talking about PG qualification. My lord, your lordship may kindly see, this is the shortcoming. So this is what is the reason given. Now, in respect of all these three, my lord, we have pointed out, and my lord, the court has taken note that this was a requirement who are appointed subsequent to 89. So, my lord, those who are appointed prior to 89, my lord, they need not possess PG qualification. That is very clear. That, my lord, the learned single judge has pointed that out in the order, and where certain strictures have been passed against them.
But insofar as Nagraj Nadgir, Professor
Now,
Nagraj Nadgir is
every
concerned, my
time the
lord.
court asks them a question, my lord, now every time a court asks them a question, they will come up with something else to say. Now, as your lordships rightly asked us, what is wrong with the order passed by the impugned order, my lord?
Is employed in
Lord, in this, my lord, in the impugned order, my lord, we have specifically mentioned
your
that
lordship's
college is
specific
not
question to me
fulfilling 11
was,
higher
my lord,
faculties,
your
my lord.
lordship's specific
My lord,
question
the
to me
list
was,
which has been furnished by
what
us
is
is, my lord,
is
it is a
the,
list.
my lord, what is wrong in the order? My lord, may I just explain, my lord? My learned friend may permit me. My lord, your lordship's specific question to me was, what is wrong with the order passed? My lord, that, my lord, I have been able to point out.
Because we don't require all, whatever, wherever the clarification is required, if I understand that clarification from him, it will cut the issue. We don't have to hear it elaborately. You understand? Now, according to him, so and so is not qualified because he is not having PG. As per the earlier order passed by the single judge, if they're employed and if they were appointed or so and so prior to 1990,
They don't need the PG.
PG is not required. So that you should clarify.
Not like that, my lord. Lord,
He
because they have not
he
produced any
improvises.
rules insofar as that issue is concerned. They are saying that if the appointment is earlier to 1991, then we are not governed by these rules. And my lord, there are no other rules, my lord. My lord, what we are saying before this court is that, my lord, there are 12, my lord, higher faculties are there. Out of which, my lord, in 11, there are no, my lord, 11 higher faculties should be there. There are 12 departments, higher departments. At least, my lord, 12.
I require both of you to file your written submissions and look at it. I can't.
Please.
This is not going anywhere. You also file.
Please, please.
Yes. Why
Please,
you
ma'am.
have to file your written submission? Why the impugned order is wrong? Why impugned order is right? Both of you file. I'll understand from it, and
Please.
then I'll hear. Yes, this is matter next week. Yes,
Oblige.
next week.
Grateful.
Let them, the students, have to take up their examinations. Notification is now
I've
issued.
already permitted them write the exam.
Yes, that, the interim order.
If I leave it here, they will complete. That's what I told him last
Lord,
time.
date may be fixed, my lord.
Also make
At least, my lord, this court may.
Make efforts to see that they get employment also. High Court will pass an order for employment.
My lord,
Right.
Very unfortunate.
So, my date may be fixed, my lord, because otherwise it may again, my lord, continue.
This matter on
10th,
of
my lord, may I
February.
request 10th?
11th February.
Oblige, grateful.
And if possible, let the senior counsel come physically that day.
Oblige.
Because it's difficult.
In the meantime, the notification, date is getting over. That is the reason.
This is the student, due to paucity of time, this court is not able to hear the matter finally. Already from the last 4 years, basing on several orders passed by this court, they are paying the examination fees, they are appearing for the exam. Hence, this year also, the respondent shall permit what is the now requirement?
Now I have filed IA with the specific prayer as which exams they are supposed to take. If that IA is allowed, with this.
A number?
IA filed on 7 January 2026.
And look at the prayer, 7 January, IA is allowed. Yes.
Both the matters. Both the matters.
Yes, next.
Oblige. We'll file the detailed written submissions.
Grateful.
I'm impleading my respondent. Last occasion, my lord, it was took time for filing up the objections. Here, your lordship kindly see, my lord. Earlier, my lord, the petitioner was
Who filed the impleading application?
myself, my lord. I have filed this.
As proposed R3.
Yes, proposed R3.
Where is the petitioner?
Last occasion it took time for file objection.
Representation on behalf of the petitioner. List this matter for dismissal on Tuesday.
By Tuesday, 12th.
Yes. 17.
I'm for the petitioner. I filed application for.
Yes, I
paper
number 1
publication.
of 26 for substitute service of notice on R1. The same is allowed, mentioning the is permitted to take out notice and so. Mention on or before so and so, mentioning the date so and so. Yes, next 18.
24.
Yes, 18.
Still number 18?
My lord, this is a
Your Lordship,
steward vacating I filed by me.
Yes.
Your Lordship, this is compromise petition, Your Lordship, wherein filed by the defendant number 1, all the respondents, Your Lordship. Challenged by this is a suit for partition, Your Lordship.
Who are you?
I'm defendant number 1, Your Lordship.
You are a party to the proceedings?
I'm the party, but I am not signatory to the proceedings, Your Lordship.
Fine.
No, Your Lordship. It
Where is the compromise decree?
Page
Is it
number.
Annexure PC, may kindly see. A writ petition
Page number
C.
32,
Wherein
Your
it is
Lordship.
disclosed that total property 4 share have is divided.
No, a party to
Page
the
number.
suit is not a party, is not a signatory to the compromise.
He has signed, his instance the matter was referred to the Lok Adalat.
That means my.
Your Lordship, page number
His
35.
legitimate share 1/4 he is allotted.
Whether the.
There is no fraud. In the absence of any fraud, he has no right to challenge the division after lapse of 7 years.
Please tell whether she is a signatory to it or not.
Please.
She is a signatory to it or not.
She is not signatory, the advocate has filed, signed. But his ultimately the result is the same because his legitimate share of 1/4 is allotted. As per the compromise decree, mutation has taken place before the revenue department. Subdivision hasn't taken place.
What were you doing for 7 years?
Your Lordship, earlier I have approached a miscellaneous court, Your Lordship, wherein I have filed a miscellaneous.
When did you approach? Which year?
It's in the year 2017.
2017, Your Lordship.
You are a defendant in the suit.
Please, Your Lordship, defend number 1, Your Lordship.
If you are not aware of the compromise decree, you would have pursued the matter what has happened to your suit.
Please.
So when is the compromise decree?
Compromise was on 19/8/2017, Your Lordship.
19/8/2017. When did you file the miscellaneous?
Miscellaneous was filed on 2017, Your Lordship. Please, Your Lordship, please, Your Lordship. On 4/9/2017.
Then what
And
happened?
subsequently, it was stated, Your Lordship, Lok Adalat order is passed and they cannot.
When was it?
That order is on 9th March 2020, Your Lordship.
9th March.
9/3/2020. Please, Your Lordship.
Then immediately this, but why are you, what are you doing?
Because, Your Lordship, subsequently 2020, Your Lordship, because of COVID, he was not unable to.
It was not till 24.
And another thing, Your Lordship, the explanation I have given in the petition, and during that time, Your Lordship, his son is also, he lost his son also. That is the reason, Your Lordship, he has.
Come to the compromise memo.
Page
that is
number
filed.
30, page number 32, Your Lordship.
30?
32, annexure C. Page number 35, where is the defend number 1, Your Lordship? I am the defend number 1. My signature is not there, Your Lordship.
Page number 34, share is allotted at 4. Page number 34 of the compromise.
How can the court accept this kind of a compromise?
But advocate, there is no prejudicial cause to the other side because it is a matter of fact, it is a suit for partition, 1/4 share is allotted to him.
You can't argue that.
But it is after a lapse of.
In a compromise memo, the signature of all the parties is required.
But
that is a duty of the court to see that.
But
all
my
the
lord,
parties
this is
are
only my
present.
submission that in the absence of any fraud, there is no injustice will be
This is
caused.
a fraud.
This is not fraud. Advocate has signed at the order sheet. We can say order sheet dated 12/2/2023. It is clearly disclosed that.
Mr. Counsel, if you hear my question, then you will be able to answer. I'm saying.
Please.
For plaintiff number 1, plaintiff number 2, defendant number 2 signed. Their advocates have signed.
Signed.
Why not defendant number 1?
My courtesy order sheet dated 12/8/2017, where it is disclosed that it is at the instance of the petitioner, the matter was referred to the Lok Adalat. On this ground, miscellaneous petition was dismissed.
This one ground is sufficient to set aside this judgment.
But my relying the Honorable Supreme Court
No,
judgment.
I know what are the grounds for setting aside, but not without a signature. How can the court do it?
It is that the
What is the
petition.
business of the advocate to sign the compromise decree? Is he the party?
Your Lordship, signature is also not that advocate signature wherein it was stated advocate respondent defend number 2, not defend number 1. Page number 30, please.
Yes, please come. The present writ petition is filed seeking the following prayer. The facts of the case are OS number, the respondents have filed OS number 546 of 2019 on the file of the Principal Junior Civil Judge Dharwad. The petitioner before this court as defendant number 1. The matter was referred to the Lok Adalat and as per the compromise entered between the parties, a compromise an award is passed on
Your Lordship,
on
19/8/2017.
19/8/2017. According to this is the submission of the land counsel appearing for the petitioner, defendant number 1 is that she is not a signatory to the said compromise memo, nor her advocate. According to her, the advocate's signature is also forged. Immediately after she came to know about this, they have filed miscellaneous before the, where is that miscellaneous?
At page number 43, Your Lordship,
They filed the miscellaneous before.
27 of 2017. Civil miscellaneous 27 of 2017, Your Lordship.
Miscellaneous number
27 of 2017.
17, before the civil judge,
Please, Your Lordship.
Dharwad. And that came to be dismissed by order dated 9th March, by order dated 4/9/2000, 9th March
9/3/2020, Your Lordship, page number 56.
2020, that against the Lok Adalat award, they cannot file a writ petition, they cannot file a miscellaneous. Thereafter, in the year 2024, the present writ petition is filed. When counsel further submits that it is stated, where did you say those reasons at page number?
Please, Your Lordship.
Reason for the delay,
Reason, please, Your Lordship, in the WP, Your Lordship.
where is that?
Delay when?
Which paragraph, which
Para,
page?
please, Your Lordship, page number 7, para 13, Your Lordship.
It is stated that due to the pandemic, petitioner was unaware of the dismissal order. During 2021, petitioner's wife left him due to the property dispute, as petitioner has no income at all and there is no property in his name. As they were staying in the suit property, there is no other place to go. Petitioner's wife and his 2 children left the company of the petitioner. Petitioner was in complete depression, lost interest in the dispute. On 4/5/2023, petitioner's elder son expired. It was shocking for both petitioner and his wife. After that incident, petitioner's wife came to petitioner to lead life. Meanwhile, when people started visiting the suit property to purchase, as they're staying in the suit property, then they came to know about then they have approached this court by filing the present writ petition. In the process, the delay has occurred. It is submitted that the said compromise decree is not binding on them. The same is obtained by playing fraud. As such, the same needs to be set aside. When counsel appearing for the respondent plaintiff submits that there is, even if the no signature of the petitioner defendant number 1 is present in the compromise memo, the advocate has signed, no prejudice is caused. In such case, the compromise decree cannot be set aside. He has relied on the judgment of the apex court in case of case Srinivasappa and others versus M. Mallamma and others, reported in 2022-4 Karnataka Law Journal 372. He has relied on paragraph number?
Last paragraph.
Last, which paragraph? 30?
35.
He has relied on paragraph number 35. Please extract para 35. Relying on this, and council submits that this is not a case where the compromise decree has to be set aside. Next para, having heard the councils on either side, peruse the material on record. Whenever a compromise is entered into between the parties, when the same is reported before the court, it is a duty of the court to see that, to seek the presence of the parties and also ask the parties whether they wanted to, whether they have entered into the compromise as per the memo filed before the court, whether all the parties to the compromise have signed the same or not. But in this case, admittedly, the signature of defendant number 1 is not present in the compromise memo. In that case, the court ought not to have, the Lok Adalat ought not to have passed the award basing on a compromise. When the party signature is not present, whatsoever is the reason, that cannot be termed as a compromise entered into between the parties. In the considered opinion of this court, this is the then council has relied on the judgment where that on what are the limited grounds that are available for the court to interfere with the Lok Adalat award. This is the bare minimum requirement that a party to the compromise should be a signatory to the same, and without that, this court need not go into another aspect. And on that ground alone, the compromise has to be set aside. Accordingly, the compromise decree dated so and so is set aside, and the parties are at liberty to pursue the suit.
That OS is to be restored, Your Worship.
OS is restored.
Please, Your Worship.
Yes, next. Switch off this AC. Yes, next. Allowed, petition is allowed. Yes, next.
For the respond number 1 and 2, my lords.
My lord, next
Number
week,
19.
on 5th,
I filed IA for vacating interim order.
Why once the interim order is granted,
they filed objections. The objections are in detail.
what is the impugned order? Let's see.
Impugned
Lord,
order, my
it's
lords,
a
so that is on.
suspension and transfer of the petitioner employee for posting some WhatsApp messages regarding the functioning of the institution. On that ground, he was suspended and transferred, and we have challenged that. Honorable Court granted stay.
So according to you, what is wrong with that order? Does it amount to the
Yes,
misconduct?
It does not amount to misconduct.
Yes, yes.
Because it was not against any particular person as such. He is a functioning senior employee, my lord. Just regarding the discussion, it was posted.
What was the WhatsApp messages that you have posted?
My lords, that is
Kindly, my lord,
not,
on
they are not
next week.
produced.
What are the contents of it?
Next week, my lord. Contents.
Anashar Atol I have produced.
Should have placed it before the court.
WhatsApp messages are there,
What
but
are
it is
that?
in
What are the
Kannada.
contents of it?
My lords,
Next week, if it may kindly be
Anashar
taken.
Atol, my lords, I have placed. I have placed with
where
my
is it?
pleadings. Anashar Atol.
Para?
Please, my lords, for a moment. Page 53, my lords. That is in Kannada language. He made allegation against the entire officers of the Karnataka Housing Board.
Please file the translated copy of
Please, my
that,
lords, please.
WhatsApp chats.
Please.
The land counsel for the petitioner shall place before this court the translated copies of the WhatsApp messages that were sent by the petitioner. This is matter on 17th of February.
17.
Please.
Next.
Obliged.
20.
Lords, I oppose for extension of interim order. This is the second time wherein he is doing the same thing.
Let it go. Because when you're hearing it, what the interim order he had, that should continue.
He is already, my lords, before taking interim order, he already transferred, relieved and transferred.
That is just 17th of February. We'll
Please,
decide
ma'am.
that.
Please, please.
Interim order, all you granted is extended till then. Yes, next.
Obliged.
I
Yes.
appear on behalf of respondent, Your Lordship. Council on record is not keeping well. Kindly have it next weekend. already asked.
Please.
We have,
Identical.
they have a stay subsisting, Your
Item was
Lordship.
earlier granted is extended. At the request of respondent, list is matter in the month of March. Yes,
Grateful, Your
21.
Lordship.
Lord,
March.
Lord, interim order to continue.
Interim order
Please.
is extended.
Much obliged.
Yes, 21.
Preliminary hearing matter, serial number 21 to 25 adjourn, serial number 26.
Yes.
Please. Lord's writ of mandamus, my lord.
26.
Occasion, your lordships have directed the government to take instructions. Lords, in this matter, my
Lords,
lord.
I have instructions. They are not disturbing my lords. If anything, I am not against my lords. The rule of law has happened. We will take action.
Lords, if that.
This is what is this matter?
Lords, it's a
This
writ
is
of
my lords,
mandamus,
the-
my lords. Writ of mandamus, my lords. Petitioner is carrying on a business of hotel, my lords. My information is, my lords, respondent number 3, being police authorities are harassing the petitioner, my lords, though there is a notification which I produced at Annexure F. If that is.
According to you, they are not
Lords,
interfering.
Annexure F
So
is,
I'll say you shouldn't interfere without following due
my lords,
process.
in routine business, we are not interfering. Anything,
Better to the notification, my lords.
if
And,
anything
this
illegal activities are
That
taken
is
place, that.
Same circular.
Yes, yes.
Let them adhere to the
Petition
notification.
is filed seeking the following prayer. It is a case of the petitioner that is carrying on the business of the carrying on the business of hotel restaurant. He has obtained the permission. He has taken the trade license, and the same is renewed from time to time and is valid up to 31/3/2027. And the petition shop has been registered under the Commercial Establishment and the Karnataka Shops and Commercial Establishment Act 1961. And also under the Food Safety and Standards Authority of India. It is a grievance of the petitioner that repeatedly during the last week of November and first week of December 2025, the officers of the third respondent visited the hotel restaurant of the petitioner and started abusing them in the presence of customers. And also warned the petitioner to close their shop at 10 p.m. Otherwise, they will register a case and also inform that they have instructions from his higher ups to take up action. It is submitted that when the respondents have insisted to close the restaurant, the similarly placed people have filed WP number 106364 of 2024 and batch. The said petitions were allowed by order dated 20/11/2024. And directions were issued to the respondent authorities not to restrict the business hours till 1. No. It is not to restrict till 10 p.m. and they can do the business till 1 p.m. as per the government notification.
1 a.m. in the midnight.
1 a.m. as per the government notification. It is submitted that the respondents are not adhering to the GO that's issued, the notification that's issued by the government, and also several orders that are passed by this court, by the coordinate benches of this court from time to time. Learned AGA appearing on behalf of the respondent submits that as per his instruction, they are not interfering with the business of the petitioner. It is, however, it is submitted that even as per the order that the petitioner is relying upon, if any illegal activities are carried out by the petitioner, the respondents are always at liberty to visit the premises and premises next per having heard so and so. The grievance of the petitioner is that they are interfering with the business of the petitioner and they are insisting him to close the business by 10 o'clock. As per the notification issued by the government, they can keep it open till 1 a.m. Learned AGA submits that they are not interfering. Considering all these submissions, this court is passing the following order. The respondents shall not interfere with the business of the petitioner, and as per the notification, they can conduct the business till 1 a.m. Number 2, this order will not preclude the respondent from visiting the premises if there is any other activities are carried out by the petitioner. 3, the respondent shall follow the due process of law before, shall follow due process of law. Yes, accordingly disposed of. Next.
Disposed. Seal number 27, adjourn seal number 28. Hemant
For the
Kumar and
petitioner,
how-
Lordship. I have complied, my Lordship, as per interim order, my Lordship.
Huh?
I have deposited sum of rupees 5 lakhs before this honorable court, yesterday, my Lordship.
As per the, it is submitted that as per the order passed dated
12/1/2020.
2026, the petition has deposited 5 lakhs. Hence, the interim order earlier granted is extended until further orders.
My Lordship,
Notice to the respondent.
my Lordship, kindly, kept in any, my Lordship, amount deposited before this honorable court, my Lordship, the registry is directed to kept in any nationalized bank FD.
This amount deposited shall be kept in a national bank. Why do you expect national bank? They will come, not risk required.
Obvious.
Yes. Next.
Number 29.
29.
On last, Lords, I appear for respondent.
I don't know, let him, after my argument, he has got right to speak, my lord, saying that he has filed an application for rejection of the plain, my lord. That matter is going on, that is nowhere connected to with this, my lord. This petition, this order are passed.
Please come to the first.
Yes, ma'am. The first matter, my lord, 242 WP. Here, my lord, the order, interim order, which was granted by the trial court during vacation, I had complied. The interim order was not to.
Come to the order, page number.
Page annexure L is the order. Annexure L.
Page number.
Page number, your lordships may get at page 1.
Let's see the order.
129. Here, my lord, the relevant portion would be 144, my lord, the 146.
Let's read it.
Yes, ma'am. The counsel for the defendant 12511 so have objected the extension of ex parte TI. The counsel for the plaintiff submitted that he has complied the provisions of under order 39 rule 3 of CPC. It is to be noted plaintiff have not served all the copies on which he has relied on while obtaining the said relief as provided so and so. The provisions of order 39 rule 3 is mandatory provision and the compliance in respect of said provision cannot be made partially. It has to be complied in strict adherence to the statute provision which is not made by the plaintiffs in this suit. It is to be noted that the plaintiff have obtained equitable relief of injunction and it is to be noted that as rightly referred by the learned counsel for the defendant so and so in ARA 2000 SC so and so. The compliance of this that is essential. So in this perusal of the record shows that plaintiff have not complied. So and hence this court is view that without compliance, the order of extending TI would run contrary to. So it is vacated. It is exactly opposite, my lord. I have produced, my lord, the fact itself. Kindly see page, my lord, annexure J, page 112, my lord.
No, where is the impugned order?
Yes, ma'am. The impugned order, your lordship may get at the along with the order sheet. I have produced annexure B, C, page 51, my lord. Page 51. 50 is the order, my lord, where during vacation.
Let's read it.
Page 50, my lord. The plaintiff has sued for declared general body so and so null and void also for perpetuation. Plaintiff also seek by way of interim arrangement.
What is the impugned order? I'm not able to understand.
No, impugned order. No, the impugned order is page 51 was the order passed by TI, my lord. That was extended from time to time. They filed an objection not to extend it. Now the order annexure L is the impugned order, which is passed by the.
You have placed before the court several orders of the court. Which date it is, which page it is, that's what I want to see.
The first initial order passed.
No, the present order, where
present order is page 45, my lord. The page 46, the last operative portion is page 47, 147, my lord. In the order sheet of the trial court itself, it is referred. Page 147, my lord. Yes, last operative portion, my lord.
Let me read from the beginning of 146. Yes. Please read.
My lord, it says I have not complied order 39 rule 3B, my lord.
Where is the proof that you have complied?
Yes, that's what I was saying, my lord. Kindly see, I have produced I have filed these documents before trial court annexure J, certified copies, page 122. 112. On the day of the order was passed on 28, my lord, 28/5/25. Annexure B is the order TI. And I filed a memo with affidavit, my lord, page annexure J, page 122.
Yes.
Lordship may got memo is there.
Yes.
Along with memo, affidavit of the plaintiff is filed. Kindly see next affidavit is there, my lord, page 153. And postal acknowledgements are there, page 100 and
Yes.
115, my lord.
Notes, this my friend is saying that compliance. Notes, he has stated in his affidavit also application is sent. As per my lord's order 39 rule 3, plain all documents and applications. Notes, even my lords in the affidavit he has not mentioned.
Let us see what are the documents to be filed.
Yes, my lord, may kindly see it.
39 rule 3.
It says immediately you have to file it.
Please come to the provision.
Yes, ma'am. 3,
Before
my lord,
granting
A
injunction.
also can be seen. The court shall in all cases except where it appears the object of granting injunction would be defeated by delay before granting an injunction, direct issuance of notice same be given to opposite party, provided where it is proposed to grant injunction without giving notice of application to the opposite party, the court shall record the reason for its opinion for object granting injunction would be defeated by delay. So require the applicant to deliver to the opposite party. Order 30.
Yes.
The lordships may directly 13A only can be referred.
Order
39,
rule 3.
3B, 3 small a. My lord.
Yes.
My lord, after granting interim order, whatever is there, the court below, the other plaintiff has to comply. To deliver, provided so to deliver to the opposite party or to send to him by registered post immediately after order granting injunction has been made, a copy of the application for it together with copy of the affidavit filed in support of the application, copy of the plaint and copies of document on which applicant relies, and to file on the day on which injunction is granted or on the day immediately following that day, an affidavit stating copies aforesaid have been so delivered or sent. Lordships, the very next day, 28/5/25 is the order granted. I filed on 26th, my lord, the affidavit with memo. I had complied it, my lord. And I filed the acknowledgement also, my lord.
Yes.
Notes,
Then
my
even then the-
submission.
Why is it so complicated? No, something has to be done as per the order 39 rule 3.
3.
If it is done or not, where is the confusion for that?
Notes, my submission for my lord says, notes, the plaintiff, who is the present petitioner, has not sent any plain documents or other
Can you
applications.
send the documents?
Yes, my lord, I have produced your lordship the acknowledge. That is, I have given certified copies. My lords may kindly see the
The so-and-so court is directed to send a report to this court.
Yes.
Whether the petitioner has filed all the documents as required under order 39 rule 3AB.
3B.
Does this matter? Yes, rule 3B.
Yes.
Does this matter on Tuesday?
My lord,
The
sir.
Registrar Judicial is directed to communicate this order.
Yes, my lord, in fact, I have produced the
The interim order that is granted by the
trial court.
by the trial court, the interim injunction shall continue till Tuesday.
Please.
Notes, one submission.
Yes.
Notes, may I request one submission? Instead of this, my lords, let there be already the application is interim order is vacated. Since last 3 months it is
On
vacated.
these grounds, when the petitioner says he has done it, why should it be vacated?
This court and Supreme Court has taken a view. Unless plain and documents are produced, that cannot be done.
That's a whole dispute. According to him, he has done it.
Notes, if that is for a moment, I will take according to his own application. He says only applications are sent.
No,
Only
no.
applications. Notes, I will
My
take
lord,
note.
affidavit is.
I'm telling you, if the court receives a
Yes,
report
madam.
from the learned judge that there is no complaints of order 39 rule 3A and B, this writ petition shall be dismissed with costs of rupees 15,000 to be paid by the petitioner to the respondent.
Notes, one submission before that. Page number 115. He says postal acknowledgements.
Now you will get 50,000 if you have a case.
Notes, my submission, my lords.
Okay, let's this matter Wednesday, the Registrar Judicial is directed to communicate this order, and along with this, the court shall send what are the documents that are sent as per order 39 rule 3AB.
That is, my lord, I have produced the acknowledgement with affidavit.
The
Yes, yes, ma'am.
Court will produce,
Because
and I am telling you 50,000 you have to pay, otherwise you will not even contest your case. And
No, no.
I will dismiss it with, I will vacate it.
Yes.
I will vacate the interim order, and you can't have any other order also.
So no, the fact that in fact he don't appear by way of caveat in this petition, in the connected he appears, my lord.
Okay, why are you
Though,
when you
yes.
feel that you have a case, you don't worry.
Yes, yes, definitely. My lord, the
District
document.
on Wednesday, yes. Both the matters.
Allah, next case one is that, my lord, the connected case, my lord. 3029/1, my lord. In that, my lord, I challenge the order written statement, he filed additional
That I
written
request
statement.
time, I had informed my party.
That
That
we
anyhow
will
it is.
see on Wednesday, both the matters I will decide.
Yes,
Yes.
in fact,
Yes, next.
Seal number 30, Sachidanand Babaji.
Let it be in the preliminary hearing, my lords. Let the matter be in the preliminary hearing.
Everybody wants preliminary hearing. How is it possible? Let it come wherever
No,
it is.
this-
We'll
Since there's a
complete-
compliance report.
We'll complete the list. Yes.
My lords, I directed the petitioner defendant.
Where is
I
this?
filed an affidavit, my lords. I have also served on the
Where is
respondent
he?
council. I have served.
Where is the council? I'll pass over. If he doesn't turn up, I'll pass orders in the afternoon.
Please, my lords.
Yes, pass
Pass
over.
over.
Grateful.
Yes,
Seal number 31 to
33 or 34.
34, adjourn.
Yes.
Seal number 35.
In this case, I need some more time to get instructions. Say number 35,
Hmm.
I need some more time to get instructions.
My lord, there is some. No, last week matter was listed, my lord. This honorable court directed to secure the records. My lord, here, my lords, what had happened, my lord? The order passed by the third respondent is contrary to their own notification, my lord. I am permitted to read. My lord, page number 59, my lord, sir. For a moment, this is the PDS matter, my lord.
Hmm.
Lord, I am permitted to read, my lord, this provision, amended provision. My lord, sir, some facts is that, my lord, fifth respondent moved an application.
No, before that, let us just see
Please,
what is prayer.
prayer, please. Let's make some facts, my lord.
No, I'll hear the
Please.
facts also. Let me understand
Please,
what it is.
Now, my lords,
Order
the
passed by
issuance of
respondent
license in favor of the fifth respondent,
Number 3,
my lord, issue.
Deputy Director of Food
Respondent
Civil
number
Please,
three
please.
is my lords,
Who is the state?
Deputy Commissioner, Food and Civil Supplies.
Order passed by him.
My lord, license, my lord, is granted in favor of the fifth respondent. My lord, signed application filed by the petitioner was rejected. My lord, this is case is that, my lord, the fifth respondent moved an application before the third respondent on the ground that his father has expired. He was the license holder, and on account of death of his father, my lord, he moved an application. And my lord, annexure A, my lord, page number 20, wherein, my lord, the third respondent, in view of that notification, has rejected his application on the ground that he has not passed the 10th class, and, my lord, he has not produced any source income. On that ground, it was rejected. Thereafter, my lord, he moved and he filed the fifth respondent filed a writ petition before this honorable court. My lord, this honorable court was, my lord, and he has suppressed that that was the covered matter. My lord, page 24, my lord. The fourth para, my lord, 13559 of 2020.
This is the whole difficulty with this covered
Please,
orders.
that copy also I have produced, my lord.
What I am trying to tell all the advocates, please argue on the merits of the matter instead of saying covered order for everything.
Yes, covered. They have submitted the covered matter, and the matter came to be allowed. Not immediately, my lords, I question this.
What is the writ petition? What is the covered order?
Please, my lord.
Set aside the order passed with the single judge in writ petition number to restore the writ petition and permit the appellant to prosecute the petition.
My lord.
Where is that
That is
order?
not, my lord, earlier order, page number 24.
20?
4, my lord.
Starts with page number 21, my lords.
What is this order? The petition is allowed. The order endorsement dated 23/10 passed by third respondent is hereby quashed.
Not para 4, my lords.
Issue directing the respondent to transfer the faith free shop license in favor of the petitioner on compassionate grounds within 4 weeks.
Not para 4, my lords, the para 4. Now, my lords, that judgment I may permitted to read, my lord. That I have produced that judgment.
That's anyhow.
Lord, may I
My
make
lordship,
one
please
submission?
clear.
After this, my lords, I have questioned this writ petition order.
This order has to be questioned, is it not?
I have questioned it, my lord.
What
I have
happened?
questioned it. Please. Page 33, my lord.
Page 33.
33. 32, my lords, interim order was granted. And 33, my lords, considered my facts, and the matter remained back to the third respondent to consider in the fresh.
Then whether that order is set aside or not.
My lord, page 35, my lords.
That's what I'm looking at.
Please. My prayer was that, wherefore it is prayed that the honorable court be pleased to set aside the order passed by the learned single judge so and so number annexure G, restore the writ petition and permitted the petitioner proceed with the petition by allowing the petition present writ petition in the
Where is
interest.
the, ultimately, what is the order?
Please, my lord, page 37, my lord.
I have seen it. Where is that order in favor of the fifth respondent is set aside?
Set aside, my lord, what had happened, my lords, we all were argued. Thereafter, only after, my lords, the taking submission of the fifth respondent only, my lord, the matter remained back to the third respondent, my lord.
For remanding back the matter, what is to be done? The order needs to be set aside or not?
Please, my lord.
No, that order is not set aside. But that order passed in favor of the fifth respondent
Please.
is still in force. You need to seek a modification of this order. Without setting aside an order passed by another coordinate bench, how can this order be passed?
My lord, after, my lords, the hearing of the both the parties, my lord.
You understood what is the
Please,
court
that is,
referring. So
that
please
is,
do that. Please do that. There is an order
please.
directing the respondents to consider, to allot the shop to the fifth respondent on compassionate grounds.
Please.
That order is set aside, that order is questioned by you.
Please, my lord.
Which is not set aside, which only said, consider the case of the parties. How can it be considered without setting aside that order?
Because with the consent of the fifth respondent, my lord, it was remanded, my lord.
But order has to be set aside.
That is true, my lord. But now, my lords, in fact, my lords, I am running the license, my lord, of the.
Where is the consent recorded? Please come to the order and show me one line.
Please, my lord.
Show me one line from the order. Where was the consent of the fifth respondent is recorded?
My lord, he was presented, my lord. He was party as respondent 5, my lord. He was appeared for the advocate.
If you don't ask the court, what do you want? What will the court do? This is how it is. Now you have landed up in this. And you cannot have any order from this court unless and until this order is modified. Unless and until that order is set aside.
Moreover, my lords, as per the observation of this honorable court, the license was given as temporarily to him as an alternative, my lords, remedy. That is observation made at inquest.
According to him, if he is not entitled for
Yes, that is one of the ground.
That is what.
On a compassionate
Yes,
ground.
unless
This order is set aside.
unless this order is set aside, he cannot see.
He can't have that. What I'll do is, now I will set aside the order that is passed by the respondents. And you seek clarification.
Please, that will, my lords.
In your writ petition.
Please, my lord.
Then
Much
only
obliged.
then you can approach the respondents and respondent will.
Please,
shall
please, my
consider.
lords. Please.
Please come. So the moral of the story is, don't say covered order.
My lords, I didn't, my lord.
The writ petition.
The fifth respondent, my lord.
Fine. Seeking the following prayer. The facts of the case are, the respondent number 5 was seeking compassionate appointment, and when the respondents have not considered his case, he has filed WP number 106778 of 2024. And a coordinate bench of this court by order dated, where is that?
My lord, page 42, my lord.
42. Not 42.
33.
It's not 42. Just Zarur's order. Where is it?
That is, my lord, Sanexer, page number 21, my lord.
By order dated
21/11/2024.
21st November 2024. The writ petition is allowed and a mandamus is issued directing the respondent number 3 to transfer the fair praise shop license in favor of the fifth respondent on compassionate grounds within 4 weeks from the date of receipt of the copy of the order. It is a case of the writ petitioner that the fifth respondent is not eligible to be appointed as he is not fulfilling the eligibility criteria. Hence, he has filed WP number 100613 of 2025 and an order was passed dated 24th November 2025, whereby a direction was given the respondent to consider the application of all eligible persons and pass necessary orders in accordance with law within an outer limit of 4 weeks from the date of receipt of the copy of the order. Now, the impugned order is passed by the respondents dated 24/12/2025. Where is that?
My lord, page 140, my lord.
140.
141, my lords.
What did they say by virtue of this order?
They have, my lords, mentioned the earlier writ petition order and
Rightly, it is submitted that they pass an impugned order mentioning the earlier order passed in WP
page 145, my lords, they have mentioned.
WP 106,778 of 2024. Of 2024. Learned Counsel submits that when the petitioner is not, when the fifth respondent is not eligible, it is not open for the respondents to grant him the license to run the paid praise shop. It is submitted that without application of mine, basing on an order that is passed by the coordinate bench of this court, this order is passed. Next para, Learned AGA submits that in the light of the order passed in WP number 106,778 of 2024, dated 21st November 2024, the respondents have granted the license have transferred the license on compassionate grounds to the fifth respondent. It is submitted that when there is an order of this court, they cannot, the respondents are bound to consider the same.
Lord, in fact, it was not transferred, only order has passed and initially, my lord, third respondent was rejected on the notification. Thereafter, temporary, my lord,
Ultimately, as per the order, they have done it.
temporarily they have issued to me, my lord.
Now,
Till today, my lords, I am only, my lord.
it is not transferred to him.
Now it is my order has been passed.
Now
Annexure-
order passed.
They have,
Annexure K.
don't say transferred, the order of the court, they have implemented. The petitioner has not questioned the said order granted in the writ petition referred supra. And it is submitted that there is no illegality with the order. Having heard so and so, there is a material on record. When an order is passed in WP 106,778 of 2024, issuing a mandamus to the respondents to grant the fair play shop license, transfer the fair play shop license in favor of the petitioner on compassionate grounds, the petitioner, without assailing the said order, he cannot file a separate writ petition. If he is aggrieved by the said order, he could have, you ought to have filed a writ appeal against this order. And as long as this order is staring at the petitioner and which is in favor of the fifth respondent, the official respondents cannot pass any other order. In that view of the matter, this writ petition is disposed of, giving liberty to the petitioner to avail the appropriate remedy available to him, and basing on the said orders passed by in the writ petition, he can approach the respondents and the respondent will consider the same in accordance with law. Yes.
My lord, this annexure J, my lords, may be cautioned.
No. Because that order, unless until this is set aside, then you will approach, then they will set aside.
My lords, till then, my lords, because I was protected by this honorable court, my lord. Page 37, my lord, for a moment.
Such time, the interim arrangement. Now,
Please.
if the court is disposing
The
of
temporary
saying that,
arrangement shall continue, my
then
lord.
what will happen is presence of the fifth respondent is necessary. I can't dispose it off.
My lords,
Can't dispose it
the
off.
But
Annexure
then
K.
interim order
my
may,
lords,
my lords,
Annexure K passed on 24/12/25. By this time, there would have been change in the, my lords, the license.
Because without fifth respondent's presence, this order can't be passed.
Cannot be.
Saying that because already there is a positive order in his favor that to
but
transfer
my
it.
lords, till
Did
today,
you last disperse the essential commodities? That you tell?
till today, my lords, we are, my lord, page 37, my lords, for a moment, page 37.
Because if I have to keep the writ petition pending, I can't grant you any order.
Interim orders, my lord.
No. Because you're not entitled to.
My lord,
Without questioning an order which is
please,
passed
that
long
is,
back, you're entitled.
But even though, my lord, the notification, my lords, issued by the government itself is contrary to their own order, my lord.
It is based on a judgment. Why are you not understanding it?
Please, that is what. But judgment also, my lord, in respect of judgment is concerned.
You yourself have filed the judgment of Justice Pradeep Singh Arur, where a mandamus is issued to them. You don't question it. You
I have
file
questioned
another
it, my lord. I had questioned it, my lords. It was argued at length, my lord. Thereafter, only fifth respondent has produced a judgment saying that it's a covered. Let the matter may be remanded and, my lords, consider all the application with a
File a
fresh.
modification in the writ
My
appeal.
lord, till then, that is what, my lord, sir. Temporary arrange was already, my lord, given to the present petitioner. My lord, page 34.
Such an order while disposing of the writ petition without notice to the fifth respondent.
My lords, I'll take out notice, my lord, till then, my lords, at least, my lord. Page 37, my lords, already, my lord.
My lords, the
Their own, I don't know why, my lords, government is this much, because the order passed by the state, third respondent is contrary to their own notification, my lord. Already, my lords, they have rejected their claim.
You don't have to submit like your client. You are an advocate.
Please,
isn't it? There is an order of the court. Why do you say again and again that it is contrary to the law? If it is contrary to law, why did you not question it?
I'll question it, my lord, till, my lords, I'll take out notice.
You don't require court's advice to question it.
My lords, I'll take out notice to the fifth respondent, my lord.
Do whatever
Till
you
then, my
want to do.
lord.
I can't be part of these kind of orders. Yes, dispose of whatever you want to do, you do.
My lord, till then, my lord.
No till then.
Temporary arrangement, my lord. Because I am, my lord, I am running the.
You're doing it, do. I can't grant any order.
That too, my lord, that too given by the fifth respondent only, my third respondent.
If you want, I'll keep the writ petition pending. Notice to the respondent, no interim order. Whatever order I have dictated, you'll delete it. Notice to the respondent.
Fifth respondent.
So and so, for other respondent, then HCG takes notice.
My lord, I'll do one thing, my lord, I'll question, my lord, the.
That is good for your
Please,
client
that is.
ultimately. Immediately, if you file that recall of the order in the writ appeal, that it is not a covered judgment, then all this will be heard.
Yes, my lord.
It's a very simple.
Please.
Yes, same order. Yes, next.
Seal number 36. Appanor, Nagaraj.
please, lords.
Recreation club matter, lordship.
Recreation club matter, my lords. Similar orders, my lords, please to pass yesterday and day before yesterday.
What is that? What is his contention that we need to know?
Lordship, police authority, lordship, insisting for obtaining a license under Karnataka Police Act, lordship, for running a recreation club, lordship. In club.
The present petition is filed. Sign the following prayer. It is the case of the writ petitioner that the petition association is duly registered under the Karnataka Societies Registration Act, is conducting the games, indoor and the outdoor games, for recreation of the members. And it is running the skill game for its members through the association, though the association need to obtain the license. Though the association need not obtain a license under the provisions of the Karnataka Police Act, the authorities are insisting for the same. It is stated that as per the judgment reported in case of Rama Recreation Association versus Commissioner of Police, reported in NILA 1993 Karnataka 3357, the association cannot be compelled to obtain a license. It is submitted that in a similar matters, the coordinate bench of this court has passed orders, that is WP number 101879 of 2024. And a similar order may be passed. Non-council appearing for the so-and-so HCGP submits that they are not interfering with the same. I think the earlier order that is passed, you have taken or that?
My lords, conditions, page number 24.
Huh? Like same, yes. Contentions of the or him also the same. Yes, next.
Please.
I take notice for respondents.
Yes. Yes, next 37.
37.
Hello. Petitioner before the Honorable Court seeking compensation for the
yes.
electric line over the petitioner.
My lord, I appear for the response. Lord, I'll get instruction when they will, my lord, deposit the amount. I will get the instruction.
when they will deposit.
Well, no, the deputy commissioner already passed an order, fixed the compensation.
Now, what is the relief they are seeking?
Relief, they are seeking mandamus not to install the new tower. Already tower has been installed.
No, my lord, because this,
In the earlier order,
Yes.
we'll ask them to approach.
No, yes, my lord. In that case, my lord, there was no order by the deputy commissioner. Here, the order has been passed by the deputy commissioner, fixing the liability and further directing the owner not to obstruct for installation of the tower. But the order is,
That order is appealable to the.
no, my lord. The enhancement of compensation, he has to file an appeal before the district judge. Here,
but they have not paid the compensation
Therefore,
by the
my lord,
fixed, paid the any amount to the petitioner.
I'm saying, what is your grievance?
My lord, that is not my grievance. No, my grievance is that they have not paid any amount till today. Now they are drawing a new line. They have coming, please,
To your prayer.
my lord, please come to page number.
Direction respondent number 2 not to draw high tension electrical lines over the petitioner's land.
My lord,
This prayer is not maintainable.
Please, my
You
lord.
cannot stop them from laying the
please,
lines.
but this is the new line. I'm not,
Whatever is the line,
Please,
you
ma'am.
can't stop them. You
Okay,
can only
I understood that, but please come to page number 19. 19. My lord, this shows that they have taken up newly construction of the electric power, this one lines, and my lord, because this causing damage to the crops also.
Then I think we had elaborate.
My lord, DC has passed an order. They have not paid the amount. That is what my grievance.
Prayer. Where is the prayer?
I will file an amendment to that, my lord, please, with respect to that.
You should have done it. You should know what you want. Last time we had a
My lord,
decent
because
discussion.
my lord, my submission is that my lord is not convinced with my
You
lord.
can't stop the installation.
Yeah, that's what. My lord is not convinced with my submission with regard to stopping of the drawing of lines.
Yes.
But my now I have to go with the compensation only. Then they have to pay. They have not paid the compensation.
When are you supposed? What is the
therefore,
procedure?
I will get instruction when they will,
What's the procedure?
but we have to pay them the compensation as ordered by the deputy
What
commissioner.
is the duration? What is the time?
But time, the DC order, not there is no time, but within a reasonable time, or within,
No, there would be either under the Electricity Act or under Telegraph Act, there will be a duration. Otherwise, eternally you can't
no,
make them wait.
therefore, my lord, only, my lord,
This is matter on Tuesday by the time counsel for the respondent shall get specific instruction
yes, ma'am,
as per the DC's order when the amount is going to be paid.
yes, ma'am.
My lord, till then stay my calamic grant.
No,
Because there is a specific order from the court.
page 18.
I will not grant those kind of orders that is contrary to the Telegraphic Act, that is contrary to the Electricity Act.
My lord, please.
Yes.
There is an order from this honorable court only.
Order on Tuesday. I will not grant, I made it clear. Yes, 38.
38 also same.
Yes,
Identical.
same order.
Third.
Yes, 39.
Till number 39, Gayatri Asa, yes, party.
Yes,
Appear for state.
Petitioners.
yes.
Petitioner is seeking a writ of mandamus.
Hmm.
The direction to the respondent number 2 and 9 your lordship, to consider their representation submitted on 16/12/2000.
Representation dated 16/12. What is that representation?
Your lordship, to not to change the nature of the properties and not to demolish the pipelines and the fence
Respondent,
around.
you are seeking the direction.
Respondent number 2 and 9 your lordship.
2 and
9.
who is who? Deputy Commissioner Ballari. 9 is?
9 is the police your lordship.
There is no 9. There are only 8 respondents in your case.
Lords, the
Respondent number 2 and 5 your lordship, actually.
6, 7, 8 are private respondents.
Where is the police?
Please, your lordship. They have to impede
Yes.
your lordship, the
So why
commissioner.
they shouldn't do it?
Your lordship, what has happened is in case your lordship, in the earlier, in the 1989, your lordship, the original grantee was granted this survey number 115 your lordship of Kasba village your lordship, and thereafter your lordship, the petitioners ancestors came into power your lordship after the death of the original grantee your lordship, and they are cultivating the land, said land your lordship. The 7th respondent and 8th respondent started restraining them your lordship. Thereafter they filed a suits your lordship. The petitioners have filed various suits your lordship against them your lordship, and seeking for the restraints. Suits are pending your lordship. And meanwhile, No, Your Lordship, sir. Yeah, this also will come to that on point, Your Lordship, sir. There's no injunction, Your Lordship, sir. Thereafter, Your Lordship, sir, the petitioners approached the this honorable court, Your Lordship, wherein this honorable court had granted a interim order, Your Lordship. Thereafter, and writ that was challenged before the division bench, wherein the division bench in writ appeal, Your Lordship, issued a direction to appoint a commissioner, Your Lordship, court commissioner, with regard to the inspection of the boundaries and fence, Your Lordship, produced at page number
In the writ petition.
writ appeal. In the writ appeal, they have, Your Lordship, it's produced at annexure. F, Your Lordship, it starts from 108. Direction is at page number 131.
Where are you in this writ petition? Where are you? In this writ appeal, where is your name?
Page number 115, my lords. The petition number 1 is at serial number 11. K. Mohan, son of Kurban. His petitioner number.
And what are the other petitioners? Iresh?
In the next following page, my lords, page number 116, serial number 20, my lords, it appears that he is the father of petition number 2, my lords.
This is Shanti Kumar.
It's 116, my lords, page number
11?
116.
Yes, I'm looking at it.
Serial number 20, my lords.
Idigara Iranna.
He's the father.
P.
Petition number,
Mahendranath Reddy, where is he? Where is Mahendranath Reddy? Saroja?
He's not a party to that, Your Lordship, sir.
Then what happened to this writ appeals order?
And writ appeal order, Your Lordship, thereafter, Your Lordship, in the suit, Your Lordship, sir, which has been filed
All
by
these
the,
appeals are hereby disposed of.
with
Impugned
a
order
direction. Direction is at page number 113.
Relegated to work out their remedies before the concerned civil court, before whom original suits are pending. The original suits between the parties are directed to appoint a court. That is direction to the civil court.
Please, thereafter, Your Lordship, the civil court, Your Lordship, issued a direction to appoint a court commissioner and submit a report in accordance with the guidelines laid down by the division bench, Your Lordship, sir. Thereafter, Your Lordship, the court commissioner had acted suo motu and started dispersing the properties and removing the pipelines and the border stones, Your Lordship, which has produced that produced the photocopy of it, Your Lordship, at annexure K, Your Lordship.
First of all, how can you come to this court by filing a writ petition?
Please,
Between the very same parties, a suit is pending,
please,
which is a comprehensive
please.
one. Which will be
Wherein
taken care
in
of
that
by
suit, Your
interest
Lordship,
both the parties.
please. In that suit, Your Lordship, in the OS, which has been direction issued, Your Lordship, annexure G, wherein the present petitioners are not as a party. They have filed a separate suit, Your Lordship, against which in that also he contended that he filed an objection in that, Your Lordship. IA was pending.
Can't file a suit. Court can't grant.
We have filed a suit, Your Lordship. That's what.
Pursue it, seek an injunction against all of them.
Please, Your Lordship. But in meanwhile, Your Lordship,
No
they are,
meanwhile,
Your
no
Lordship,
meanwhile.
kindly see the objection, Your Lordship.
No, meanwhile, Mr. Counsel.
Kindly see the
You
objection,
can't,
Your Lordship.
You can't, the abuse of jurisdiction like this.
And
Let's-
till then, Your Lordship said,
Not till then.
they will not to
Not till
precipitate
then.
direction may be issued, Your Lordship, because Your Lordship, the court order is clear, Your Lordship, at post number 4.
The following prayer
Let's,
to consider the,
if I make one submission, let's, there are around 15 to 20 suits pending, Mulats. In one of the suit, court commissioner was appointed. Mulats, in that suit, we are not arrayed as respondents. Mulats, there are already 15 suits pending, and in that, court commissioner is not appointed. The reason for filing this writ petition is this. Mulats, the police authorities and the deputy commissioner and assistant commissioner are assisting in removing the demolishing the borders and fencing.
who are the respondents in the suit?
Please, Mulats.
Respondents in the suit.
Private respondents and also the government.
So you can file an IA in the suit, making all these parties
Let's,
as the respondents and also seek a relief. You have no, you don't have any document in support of your title. You are
Mulats,
saying that
it is a
you have been
granted
in
land.
possession of the property.
No, Mulats, it is a granted land. It is a granted land. It is not disputed.
Why
The,
did you file the suit?
Let's sued because in the year 2007, the private respondent, that is 6 and 7, purchased some extent of land, my lords. After that, before 2007 only we were in possession. My ancestors were in possession and we were cultivating the lands. After they purchased the land in the year 2007 and 8, they came and started making disturbance in the possession of the petitioners herein. So, my lords, we filed suit for seeking that pursuant to the land tribunal orders. Let's the extent of the land is 1075 acres. So we were in possession, Mulats. That's why we filed a suit for declaration and injunction, Mulats. There were earlier also, Mulats, there are 3 to 4 round of litigation even before this honorable court, which went up to writ appeal, Mulats. In the last occasion, Mulats, in the writ appeal, what the court said is, you adjudicate all your rights before the civil court, and Mulats, the court directed the civil court to appoint a court commissioner. So, Mulats, court commissioner was appointed only in one of the suit, wherein these persons are not respond. Lots, we are not objecting to court commissioner's work, wherein he can survey the land and submit report, Mulats. What we are requesting is this, Mulats, let them not to remove the boundary lines. With the help of police, jeep and JCBs, they have come. Mulats, deputy commissioner being the authority.
Have this piecemeal reliefs, one from the civil court, one from the high
No,
court.
Mulats, we have also filed suit for injunction.
That's what, in that suit, filed an IA.
We have filed an IA.
Showing them as respondents. You have already filed.
We have already filed.
The more reason that the petition has to be dismissed.
Let's-
When you have availed an alternative remedy, you can't file a writ petition. And the court,
Let's-
you can't, this piecemeal, High Court is not a kind of a, a one-stop before.
Mulats, I'm
going to
not
the
seeking
civil-
injunction here.
Huh?
What? I'm not seeking injunction before this honorable court. I have
That is
sought
not
injunction.
Exactly, no. And at the same time, High Court is also not a post office where whatever representation you say, like inward entry one and the outward entry, and there is an order that you consider the representation. First of all, when you make a representation, the authority which is having the representation, whether the power to do it, what is the kind of representation you're making, the kind of representation which you're giving to them, that can be an IA for you in your civil court.
Mulats, we have already filed an IA. In that, Mulats, the private respondents.
Understood, and you understood what I'm saying. I will not grant any order in this.
Mulats,
No. Unnecessarily precipitating the issues.
Mulats, may I request one more thing. Mulats, this writ petition can be dismissed. Mulats, a direction to the civil court to consider my suit, which I have filed for permanent injunction at the earliest, Mulats, because the deputy commissioner is.
Please understand, when you're making a request to the court, you have to understand as an advocate whether that is permissible. First of all, exercising the jurisdiction under 226, granting an order, directing the trial court to do this is not permissible. First of all, giving any direction to the court as per the Supreme Court judgment is not permissible unless and until such an exemplary or it's a very kind of a case which requires. Because this court cannot fix the board of the trial court.
May I make one more request, Mulats? One request, because Mulats, these are the tenants.
File checking the following prayer.
Mulats, may I request it tomorrow, Mulats? If not, I'll withdraw it. May I request it tomorrow? If not, I'll withdraw the writ petition.
Yes.
I'll just seek instruction with regard to.
Yes, next.
Tomorrow. Seal number 40. And Kumar. Number 40.
Yes.
The respondent KSFC has not served upon me the statutory notice under section 13.2 and section 13.4 of the Surface Act, my lord. It's only when they issued an e-auction notice to sell the property, they served me a notice.
If I will grant you interim order, I'll record it that if they have come up with the document to show.
I have produced the documents, my lord.
No. If 13.2 notice is issued.
Yes.
Then this writ petition shall be dismissed with
Yes,
cost
madam.
of 50,000.
Yes.
The present writ petition is filed questioning the e-auction notice. It is submitted that the respondents have failed to follow the procedure contemplated under the Surface Act, and no notice is issued under section 13.2 of the Act to the petitioner.
And also 13.4, my lord.
13.4. Considering the submission of the land counsel for the petitioner, there shall be stay of all further proceedings pursuant to the notice dated 5/1/2026. If the respondent placed before this court the documents to show that 13.2 or 4 notice is served on the petitioner, the writ petition shall be dismissed with exemplary cost of 50,000. Yes, next. Next,
This is yesterday's matter, my lord.
yes.
My lord, file is appearing.
This
No, this is yesterday's matter.
250 will take. Yes, 42.
Please.
Number 42.
Yes.
Chetan Munwali.
Please, my lords. Arising out of execution proceedings, judgment debtors, my lords, impugned order is at annexure A,
Page number
14, my lords, wherein I had sought for stay of the execution proceedings. Lords, brief facts are this, my lords. An ex parte, my lords, a suit for specific performance was filed against me. Ex parte decree was obtained. After
This day you will seek in that, to set aside the ex parte decree, there you will seek injunction.
in order, my lords, order 21 rule 26 provides me for my lords seeking stay.
That is true, but when you're seeking
What
an
has
ex
happened?
parte decree to be set aside, there the interim order would be stay of all for the.
Yes, my lords. What has happened is, my lords, there is a delay and notice is ordered. Notice is not served upon the decree holder.
How much is the delay?
Lords,
How much is the delay?
it is specific performance suit, my lords.
That's what I'm saying. How much is the delay?
Delay 1 year,
In
my
setting aside the ex
1 year,
parte.
1 year. 1 year delay, my lords.
Why you were not, why you have not appeared?
Lords, no, according to my instructions, my lords, no notice was served. Only after service of notice in the execution proceedings, I came to know. Thereafter, my lords,
Let's read this order.
yes, my lords, annexure A, my lords, reasoning portion, my lords, starts page number 18, my lords.
It observes that suit summons are served. And,
Yes, my lords.
and he remained absent before the court. Where is that IA that is filed before the court? That IA in that, to set aside the ex parte.
Application, my lords. Civil miscellaneous petition, my lords, page number 58, annexure E, my lords.
Let's read, what did you write?
Yes, my lords. Paragraph number 3 is relevant, my lords. Married and
On this ground, 100% that judgment will never be set aside. What is this?
Which
At
ground?
the Seat of the summons, the petitioner defendant has met the respondent, for which the respondent plaintiff assured the defendant that he will withdraw if petitioner made payment of interest.
That is.
That's why you have not contested. Then suit is filed in which year?
Suit is of the year 2022, my lords.
It was decreed on 11/4/2023.
23, my lords.
You filed it in 2024.
Yes, my lords. 2024.
Notice to the respondent.
Lords, stay, my lords. Why I'm telling, my lords? May I,
Not entitled for any reason.
one submission, my lords. One submission. Without, my lords, without following the procedure, now executing court has appointed court commissioner to execute the sale deed, wherein, my lords, he was supposed to submit a draft sale deed before the court and seek for objections. Thereafter, it has to be approved, and now thereafter sale deed has to be executed. Now, directly, my lords, court has appointed him to execute the sale deed.
I think the execution is within how many, immediately within 1 year, the execution is filed.
Yes, even otherwise, my lords. Now I have entered appearance in the execution petition. He has to submit, my lords, court commissioner is supposed to submit.
On that ground, you have come before the court.
No, my lords, these are the procedural labs which.
So let's see the grounds. Is it that ground?
I have not sought that ground, my lords. I have not sought that ground. Only is, my lords, order 21 rule 26.
Party who is aware of the proceedings, keep quiet, let the court to pass a judgment and decree, and comes in the execution petition and says that the execution has to be stalled. Why?
My lords, my civil miscellaneous is pending there, my lords.
That's why I looked at your affidavit.
My lords,
Bona fides.
at least, my lords, if he had appeared there, this respondent, he is prosecuting execution and he is not appearing in my miscellaneous petition.
No, let him come. We will tell them to appear.
Till then, my lords, if sale deed is executed, at least, my lords, let the sale deed not be executed, my lords. Why, if
There should be some bona fides in your application. That's what I'm saying. Now, why should the executing court state? What are the exceptional reasons? You have an ex parte decree. You have already preferred an appeal before the miscellaneous petition.
Yes,
in the
ma'am.
miscellaneous petition, you are supposed to seek what is the duty of the executing court? When the executing court will stay? Under what circumstances?
Well, it's order 21 rule 26.
Yes. What are the circumstances?
The court to which a decree has been sent for execution shall, upon sufficient cause being shown, stay the execution of such decree.
But what is the sufficient cause? Sufficient cause is already before the miscellaneous court.
Yes, my lords.
That court will see. Now, both courts will not exercise what you have sought before the
I
miscellaneous
have not
court.
sought in the miscellaneous stay because only I have sought condonation of delay
Now
applications.
you have come, now the cat is out of the bag. Yes.
Suit is for partition and separate possession.
Hmm.
Mother died during the suit was dismissed. Mother died during pendency of the appeal. Initially, mother had executed a will in favor of 4 brothers. Thereafter, in the appeal, she died. During pendency of the appeal, she died. A memo was filed by the appellants stating that she has died and appellant and other brothers may be treated as LRs. That was allowed. Subsequently, we sought for recalling of that order and another application was filed to treat us as LRs based on a will executed by a mother as a legatee under the will. That application was opposed by another brother. He was originally my lord's beneficiary under the will, but subsequently he comes up with a plea that there is that original will is cancelled and she has executed another will in our favor, and they cannot be treated as. Trial court, my lords, without holding any inquiry under Order 22 Rule 5, directly comes to the conclusion, holds that I have not shown any cause, and
Already you are treated as LRs of the deceased.
along with other brothers.
Along with other brothers.
With
No, how can you say the will which is disputed by one of the brothers?
It was marked before the trial court.
No, which is disputed by one of the brothers saying that the subsequent, no, you are
Yes,
on
my lords.
record.
In
You are
that
on record as LR of the deceased mother.
other
along with
brother,
others.
other brothers also, my lords.
Other brothers also, because you are all LRs of the deceased.
Yes, my lords. But my lords, he has disputed it. My lords, Order 22 Rule 5 contemplates inquiry.
Has he not produced that document which he is relying on, saying that after cancelling this will, a subsequent will is executed?
Under Order 41 Rule 27, an application was filed by him. In that, he has stated. That's all, my lords.
And what is the implication of this order? Anyhow, you are the LRs and you are there on record.
Now,
Only thing is, with regard to this has to be decided.
yes, my lords. Order 22 Rule 5, my lords. That inquiry is not done.
Notice to the respondent,
Not stay of further proceedings, my lords.
Petition is permitted to take out hand summons and shall file a memo to that effect.
Now, my lords, matter is posted for final arguments, my lords. Matter is posted for final arguments, and that brother, and one more thing is what is I have filed another appeal.
In an appeal, how can you seek such a direction? The court has to decide about the will.
Yes, my lords. Order 22 Rule 5 contemplates.
No. It is marked along with the suit. What happened in the suit?
Suit is dismissed. Suit is I was defendant in the suit. I was defendant in
No,
the
it's
suit.
partition suit. When you say that you are the so and so,
Yes.
there will be a finding on that.
Suit is dismissed.
Suit is dismissed, but you are also in a partition suit. Right of all the parties should be determined.
Wherein it was held that, my lords, it is her self-acquired property.
And
Subsequently,
what about the suit? What was the finding on that? About the will?
that judgment is not readily available.
So, basing on what is the finding in the appellate court,
That is not considered. That appellate court, my lords, only my lords considers there is a subsequent will in his favor, another brother's favor.
when did you file this IA saying that in the light of the will, I should be declared as LR?
My lords, IA number 3, my lords, 17/7/2025, my lords.
When was this appeal filed?
Appeal is of the year 24, my lords. 21. Appeal is of the 21. Now it is transferred.
The petitioner is permitted to take out hand summons once the hand summons are served is the matter. Is 45.
Number 44. Vasant Bhatt.
Yes.
Society election matter, my lordship. Total members of the society, 4,817.
Yes.
The petitioners are the members of the 5th respondent society, my lordship.
Yes.
1,535 members are the eligible list as per the annexure C, my lordship. But in the more than 50% of the members are ineligible candidates in the forthcoming election.
The prayer you're seeking, quash the final ineligible
Only-
voters list.
Yes, only for cast the vote in the election.
What do you say?
I'll take notice for respondent number 1, Your Lordship. The
The
societies are
so
there, Your Lordship.
HCGP takes notice on behalf of respondent number.
1. Page number 37, Your Lordship.
Where are the respondents?
37, Your
To
Lordship.
take notice for the first respondent.
Only first respondent. Your Lordship.
The hand summons 2, respondents
2, 3, 4, Your Lordship.
5.
Five,
In
yes.
addition to the court notice. Yes,
Memo for hand delivery kindly make it.
No,
Memo
it's
for hand delivery, my lords.
what hand delivery?
Interim order may kindly be granted.
First, I have not granted in a interim order.
On the cast of the
No.
vote in the election, my lords.
No.
In the
Let
day
us-
after
let
tomorrow,
them
at
come,
1
let
to
them come.
2026 is the election is there, my lords.
Let
Suppose
them
if you,
come. Yes, 45.
Number 45. Suhas K.
Appearing for petitioner, my lords. Petitioner is an obstructor, my lords, to the execution proceedings initiated by the respondent number 1 to 7 against the respondent number 8, my lords.
Yes.
My existence in the shoot schedule property is that, my lords, the respondent number 1.
Where
by
is the
done-
order?
Order is page number 82, my lords.
Page number 80.
82. The issue involved is that, my lords, my existence to the property that I am the leaseholder, I wanted to prove it through a secondary evidence, my lords. Prior to this, my lords, I filed an IA directing the respondent number 1 to produce the original rent agreement, my lords. That came to be dismissed. I preferred a writ petition before this honorable court, my lords. This honorable court, my lords, annexure L, my lords, page number 68, disposed of my petition saying that in such direction cannot be issued to the respondent for production of original rent agreement, my lords. Since there is I am not having the original rent agreement, my lords. By way of photocopy of the original rent agreement, I wanted to adduce my evidence, my lords.
Can it be done?
It can be done, my lords, when there is a foundation done as per the section 65, my lords.
A Xerox copy.
Yes,
What
ma'am.
is the purpose of using that copy?
Otherwise, my existence in the shoot schedule.
It is an ancillary purpose, we can understand.
Please, my lord.
This the purpose, the main purpose is to show that you are the tenant of that premises.
Please, my lord.
For that purpose, a Xerox copy cannot be marked.
But the original document is with the respondent number 1, and they are not allowing me, they are not
That
producing.
order has a retained penalty by virtue of the earlier order passed by this court.
Please, my lord.
So, a Xerox document cannot be marked.
But my lords, my submission is that, my lord, there can be constructive or tentative marking subject to the final adjudication, my lords. That is.
No, while marking the document, you are saying that for the primary purpose to show you are in occupation of the so-and-so.
End of the
you
shoot
want it,
schedule
but
property.
it can't be done.
That is what is held by the coordinate bench, my lords, wherein.
Notice, that is, there is a judgment of the Supreme Court, you read it.
My lords, now by the virtue, if this petition is permitted, my lords, my entire existence will be eliminated, my lord, without making me as a party to the proceedings, my lord.
Ultimately, court cannot do something which is not permissible, whatever are the consequences of it.
But the precondition has been met, my lords. I have laid down the foundation for.
It is not about the condition, like there is a pleading with regard to this, it is not about it. Whether a particular document is admissible in evidence or not is a first issue. It is not admissible because it is a Xerox copy.
But there are preconditions given by the coordinate bench of this honorable court, my lords. For a moment, my lords, only for a moment.
Yes.
Through this judgment, my lords, internal page number 9, my lords.
Yes.
Wherein the coordinate bench, my
Yes.
lords,
Yes.
whenever an objection is raised during the evidence taking regarding the admissibility of any material or item of oral evidence, the trial court must make a note of such objection and mark the objected document tentatively as an exhibit in the case, a record that the objected part of the oral evidence, subject to such objections to be decided at the last stage in the final judgment, my lords. This is my contention, my lords. Tentatively, I may be permitted to mark, my lords, and that can be taken up in the final adjudication, my
No,
lords.
no.
My lords,
Two things, either notice or dismissal, whichever you want.
I'll take a notice, my lords.
Notice.
Any date I may be permitted.
Once you take out notice and file the memo, it will come. the hand summons and shall file a memo to that effect. Once a memo is filed, is the matter. Yes, next.
Much obliged.
Preliminary hearing, B group matter, serial number 46, Gayatri SR.
Yes.
The allowing of the amendment petition is called in question.
T22 writ petition, no urgency now.
The reason is this. Earlier in the
There is no urgency now. Now the court
2007
also has-
suit, Millards,
This is matter on 10th of March. Yes, 47.
Millards, interim order may kindly be extended. Interim order.
Interim order will be extended. Is 47?
Serial number 47,
Yes.
Surabhi Kulkarni.
Petitioner, my lords. Questioning, my lord, the selection of the
Okay,
candidates. The post of Gram Panchayat, grade 2.
What
my
is
lords.
urgency for this?
Urgency, my lord, is that the publishing, my lord, the seniority list, my lord, it is affecting my seniority.
Right from 2024.
24, my lords, I'm moving the matter, my lord.
No, I have no time. List it in the month of March. In 48.
March.
Number
Feb-
48.
No,
Anand
not
Kumar
now. 48. This also in the month of March. 49.
March.
50.
Serial number 49.
Please, Millards, for petitioner.
All the matters, 49, March.
Millards,
50 also March.
senior is ready with the arguments, ma'am. Kindly
Huh?
pass out. Senior is ready with the arguments, ma'am. Kindly at
Which
2:30.
case?
Serial number 49.
24 matter, no urgency. Yes, 50.
There is no stay also, Millards, since there is some urgency.
50.
Yes.
Raghavendra Purohit, 50.
In all these matters, wherever interim order is there, extend 50 also next, all 15.
March.
Yes.
Serial number 51.
Yes, 51. March.
Judge.
Till 50,
52.
all matters in the month of March, interim order. No, I think this, any interim order is there extend.
Serial number 44, my lordship on submission, serial number 44 election matter, date may kindly fix
When is the
tomorrow.
election?
As a day after tomorrow,
Day after
First-
tomorrow is election.
first Sunday, first,
This is matter tomorrow. This is, get instructions in this. Get instructions. This is matter tomorrow. The responding, the HCG, please get instructions in this regard.
settlement is not reported.
Page number,
Pardon.
page number.
31, madam.
Yes, let's read.
At the present for JDR number 1, settlement is not reported. At the request for advocate for DHR, issue warrant against JDR number 1 if PF is paid and SA charges are deposited within 4 days from today.
Why you were not present?
First, my counsel was not present, my lord. That as per order 21 rule 37, my lord, there must be an application and should have heard the JDR on the source of his ability. Was there any dishonesty?
And counsel appearing for the petitioner submits that only only on one occasion, that is on 7/1/2026, the JDR was not present. And on that, the court has issued an arrest warrant. The court had failed to follow the procedure as contemplated under the Civil Procedure Code while passing such an order. Considering the submission of the learned counsel for the petitioner, there shall be stay of all further proceedings pursuant to the order dated 7/1/2026 passed by so and so. The petitioner is permitted to take out hand summons on the counsel appearing for the respondent before the trial court and shall file a memo to that effect by 17th of February. If the memo is not filed, the stay granted by this court stands vacated. Yes. What is that submission? Yes.
My lord, sir. That JDR number 2 is there, my lord. That since I have not claimed any relief against the JDR numbers.
No. Cause title has to be the same as from the court below. If you say below the note that JDR is not a proper and necessary party, hence notice is not required, you can write office objection to be complied with. Yes. Pass over.
Just one pass over matters. Seal number.
Directed him to file the affidavit. Your lordship may kindly peruse the affidavit. Nothing is mentioned about the building. Dispute is in respect of the construction of the building.
My lord, I have mentioned suit property item number 2, my lords.
No, suit property
That is
is
on
not-
which they had sought injunction order. I have clearly mentioned it, my lords.
Injunction is in respect of construction of the building without any permission from the local authority and without any authority. Because the title, he has no title. Record of right in respect of the land stands in the name of a deceased person. So that is the dispute. And the trial court has passed the order in respect of construction of the building. So he should state that I am constructing the building in certain number so and so.
My lord, that is.
What is the nature of the building? Its length and breadth. Everything is
My lord,
suppressed.
You can't be so hyper technical. He said in respect of the suit schedule number 2 property, he will not claim any equities. That will suffice. I will dictate in the order.
My lord, a submission, my lords. If I am to take undertaking only insofar as the construction, my lord, suit item number 2, my lords, it is 5 guntas in total. I am constructing in 1 guntas. If I were to stay only, I will not claim equity insofar as 1 guntas. Remaining 4 guntas again will be at. I am giving for the entire 5 guntas of property.
Yes, please come.
And he has to state no tomorrow.
I will record that.
Number 1, my one more submission is that, my lord, the order may be restricted in respect of the construction of the building.
Yes.
Only for the construction.
That one. I will record.
Tomorrow he should not extend
Yes, yes.
renovation.
The petition is filed.
Only for the construction. That's all.
Questioning,
Not for
an
any other
order
purpose.
That is passed by the senior civil judge and JMFC Ankola in
My lords, MA number.
heinous appeal number 2 of 2025 dated 19/12/2025. The plaintiff here, the respondent herein is the plaintiff in the suit.
No, my lords. Please, correct.
Respondent herein is the plaintiff in the suit. The petitioner is the sole defendant.
No, my lord, defend number 5.
There are
The petitioner is the defendant number 5.
5.
The suit is filed. What is the relief in the suit?
My lord,
Suit
suit
for
for,
declaration and injunction.
my lord, partition, separate possession, declaration, mandatory and permanent injunction.
Partition also.
Please.
Suit is filed for partition, declaration, and for injunction. In that, the plaintiff has filed I number I number
1 and 4, my lords.
What are those two?
My lord, 1 was in respect of injunction of all the suit properties. I number 4 was in respect of suit number 2, item number 2, my lord, regarding construction.
Only I number 4.
Please.
The I number 4 is filed, seeking an injunction restraining the petitioner herein from making construction. That IA came to be dismissed or allowed?
Dismissed, my lord.
Dismissed by order dated
8/12/25, my lords.
8/12/25.
8/12/25.
8th December 2025. While dismissing the said application, the trial court has observed that the petitioner had made out a prima facie case, but has to fail to show the other two elements, that is balance of convenience and irreparable loss, and dismiss the same. Agreed thereby, the plaintiff had filed MA. That order is at
My lords,
Sorry, madam.
please, my lords. That order is forthcoming, my lords. Annexure E.
agreed by that. MA number 02 of 2 of 2025 is filed before the senior civil judge and JMFC Ankola. And the learned judge, by order dated 19th of December 2025, had allowed the appeal filed by the
No,
appellant.
Not the appeal, ma'am.
Not the appeal,
Only
madam.
order
Interim
on
application.
This one, miscellaneous.
Please, no, my lord. In miscellaneous appeal itself, they filed one more IA, my lords. MA was not allowed in merit on completely, my lords.
MA is pending.
Then what is the purpose of MA?
Please, my lords. They have already.
No, in the light of this,
Please.
now the suit can be
Suit-
proceeded.
Please, my lords, please.
Please.
In the light of this order, the suit can be
Suit can be
proceeded.
proceeded.
In the miscellaneous appeal, another IA is filed seeking injunction that came to be allowed by the appellate court. The appellate court had observed that
He has no title, nor he has produced any document.
My lord, para number 14 of page 69, reasoning starts, my lords.
the appellant in an application is only disputing about item number 2 of the suit schedule property. She is never disputing about item number 3 to 7 of the properties. She averred that item number 3 and 4 is standing in the name of the appellant and respondent number 1. Item number 5 to 7 standing in the name of defendant number 2, who has got changed the kata of the item number 5 to 7. Whether the plaintiff is having half share over the suit schedule property or not ought to be discussed after the conclusion of the full-fledged trial. Moreover, in the appeal, the respondent number 5 contended that already the plaintiff is claiming the relief of declaration and partition and also seeking the relief of mandatory injunction. The respondent number 5 is constructing a house in 1 guntas of land. As per the production of the photos by the respondent number 5, it is noticed that the respondent number 5 has hurried to complete the construction work by seeing the situation of civil vacation of the court. The attitude of the respondent number 5 shows that he is having intention to complete the construction work within the civil vacation by using the modern technology implements. Hence, the court felt that it is all the more necessary to pass an order of injunction restraining the defendant number 5
Please, 5.
from making further construction. Agreed thereby, the petitioner is before this court. When this matter came up before the court for preliminary hearing, this court has passed an order that he shall file an affidavit before this court stating that in the event he is unsuccessful in the suit, he shall not claim any equity. An affidavit is filed before this court stating that that in the event plaintiff respondent number 1 is successful in the list pending before the court, the petitioner, defendant number 5, undertake that he will not claim any equity in respect of the suit property, item number 2, and accordingly the affidavit is filed. Learned counsel appearing for the plaintiff has objected to the same and submitted that he should have stated that there is a construction and he is making the construction, and in respect of the construction, there is that he will not claim any equities. The construction is in respect of 1 guntas of land, whereas suit scheduled property is is an extent of 5 guntas. Next pair, having heard the counsels on either side, produce material on record. In the suit for partition, declaration, and injunction, the defendant is making the construction, defendant number 5, and the photos are placed before the court. In these kind of matters where the construction is involved, if the construction is stopped and after the suit is disposed, if the party has to make the construction, in view of the escalation of prices, it would be it would have an effect on the defendant. In those circumstances, this court felt it appropriate to direct the petitioner to file an undertaking affidavit that he will not claim equities. An affidavit is filed. This court has already considered the objection that is raised by the defendant. In the light of this observation, in the light of this undertaking, nothing survives for consideration before the court. Now you want for the other, you have questioned both the IA number 1 and 4.
No, 2 minutes. Now, the IA number 1.
Before the first appellate court.
Appellate court.
Yes, only the rejection of injunction order.
So, as far as IA number 4 is concerned, no further adjudication is required, even by the appellate court, as in view of the undertaking. In that view of the matter, this court is passing the following order.
Trial court may be directed to dispose the suit early.
Before the appellate court, your one has to.
I have to withdraw. I will withdraw it.
Accordingly.
I will withdraw. I have to withdraw it. It will not serve.
Record that.
Please.
Please, madam. But
it is submitted by the land council.
Trial court may be directed to expedite.
Here is the petition.
Sorry.
25 minutes. 25 is the suit.
In view of the order being passed by this honorable court.
The land council submits that as far as IA number 1 is concerned, they will withdraw the appeal. In that view of the matter, the order impugned dated so and so, passed in MA in IA number so and so, in MA number so and so, is set aside in the light of the undertaking filed before this court, and the petitioner shall not claim any equities in respect of the building which is constructed in suit schedule item number 2 of the property.
Yes.
In the light of this order, nothing survives for consideration in the MA as far as IA number 4 is concerned.
Please. The appeal, please.
That he will
Please,
that he will do.
Please.
Yes.
Please, grateful.
Yes.
Please.
Next.
My lords, insofar as other respondents filing dispensation.
Memo is filed seeking dispensation of notice to so and so. Memo is taken on record and notice to so and so is dispensed. Yes. Yes. Any other password?
Till number 41.
So only one
Password. Yes.
Yes.
Number 41.
Appear for the petition.
Respondent, you appear. Yes.
Yes, Suhas.
Madam, appear for the petitioner's counsel. My lords, this is a case where sugar factory has commenced crushing operations in the month of November, 11th of November, 2025 for the sugarcane season 2025 to 26, my lord. Now crushing is going on. My lord, under the sugarcane control order, class 3 provides that the factory who purchases the sugarcane from the farmers has to pay sugarcane price within 14 days. Otherwise, it attracts so many other provisions, including penal provision and seizure of sugar. And also they can take extreme step, my lord, of selling the sugar and to make the payment to the farmers apart from other steps. But under these circumstances, the sugar factories, my lord, are unable to pay within 14 days because the adequate working capital is not provided the banks because the sugar industry is now in the red. But that is very difficult to generate the funds except selling the sugar, and the restriction imposed by the Union of India under the Sugar Control Order 2025. Earlier it was 66, my lord, says that unless until I give you the release orders, monthly release orders, you cannot sell it. But this is the restriction under the Sugar Control Order 2025. Whereas Sugar Cane Control Order class 3.3 provides you must make the payment within 14 days. But I am not able to make the payment. Now I am holding the stocks of 6 lakh quintal of the sugar in my godown. Now as on today, it is almost 200 crores outstanding dues to the farmers. I have to make the payment. But this is not the question, my lord. Though I have questioned with the validity of the certain provisions of the sugar control order, my lord, end of the day, we may not press for it. It is only an interim relief. It will take some relief to the sugar factories.
The whole purpose of that clause is to safeguard the interest of the farmers.
No, my lord. The interest of the farmers is provided under Sugar Control Order 1966, Sugar Cane Control Order 1966, where it is provides for I have to make the payment within 14 days. But whereas the Sugar Control Order, there is a distinction. Sugar Control Order restricts the sugar factories to sell the sugar without the release orders, monthly release orders from the Union of India. But the whole object is to ensure that the Union of India, that the sugar should not be sold away immediately. We say it's an essential commodity. But only few sugar factories are coming before the court. Some difficulty. And latest interim order, my lord, in the Kalburgi bench also. In fact, I myself appeared. His Lordship Justice Pradeep Singh Yarur has granted the interim order, my lord. And we have to make the major portion of the sales realized from the sale of sugar to the farmers, my lord. I can also, your lordship can put also a condition that I have to submit the monthly statement to the director of sugar or to the central government, serving a copy on the other side, and to place it before my lords with regard to the sale of sugar and making the payment to the farmers. Every payment is made through the accounts.
I have received.
Accounts only.
But so far as my lords, I have no instruction from the department. Send the copy today. So far as my lord stock is concerned, my page number, my lord, annexure A.
It will,
My lord, it is not a major portion, my lords. Because my lords, major portion as on their stock as on October 2025, my lords. As per the my lords, page number, my lords, that is page number 70. They have stock was shown in the, that paper is 91. Karnataka Jamkhandi sugars is 26 ton 120. That is on 30/11/25 minutes.
Subsequently, crushing is going on. Crushing is going on. Every day we are crushing more than 10,000.
My lords, this honorable court has directed them to release the 40% of the, not major, my lords. That is the major portion means, my lords, they are remaining only 10%.
The petition is hereby permitted to sell the sugar produced for the current crushing year 2021-2026, subject to the condition that it would utilize major portion of the revenue to clear the dues of the farmers on priority basis.
My lord, so what happened, my lord? So the central government make rules because of, my lord, they have to keep the 10% of the sugar to that elevate to the PDS.
No, there is no PDS.
They have intention is, my lord, they have sell the all the that sold the all the sugars and remaining only 10. They are taking the permission from the remaining only, my lords. They have not as on today, my lord, as per the stocks. As on today, it is on the stock on today on, my lord, 30/11/25, my lord.
I'm sorry to intervene, my lord. I'm sorry to intervene. There is no baby sugar obligation nowadays.
Sugar be kept and remaining be sell, and whatever is sold, that we will clarify. 10% of the produce, whatever sugar, they shouldn't sell it.
If the major portion is, my lord, released to the people.
That's what we will say.
There's major in the, but the percentage, my lord, that is what I'm saying. Major portion means they have sold the 90%. That is all major portion.
Not sold. This is the order of the court.
Yes, my lords. I gone through that order. Please, my lords, please.
So, if 10% of the stock is kept,
please,
and remaining percent is sold,
please,
and in whatever is sold, from that major portion of it shall. But we should quantify what is the major portion.
That is, my lord, status. That is statistics.
Now,
they have to do the statistics.
No, as on today, my information is 200 crores is outstanding. That can be recorded, my lord. Today only I got the information from the management.
200 crores is outstanding.
Outstanding to the farmers as on today. and crushing is going on, it may go on till the next month.
No, the learned judge's order was
Ah.
majority of the portion. What
Please,
is
madam.
that? Let us
Please.
specify what is that portion.
Very well, my lord.
10% you have to keep it.
Very well, madam.
You have to, I mean, that is for the PDS by the central government.
No, I am sorry, my lord, for intervening. I am handling the sugar, one submission to my lords, I am handling the sugar industry matter for more than 25 years. The levy quota, 10% requisition by the Union of India has been dispensed with from 2013. It is no longer is there, my lord. I have
Then how
placed
come
it.
you are making such submission, Mr. Counsel?
It is there.
Then
I
my
have
lord,
produced the
that is why
document
I
of
have
notification.
submission to on 40% may be released. That is what.
No, you just said 10% has to be kept. He says
Yes, my lord.
that has been, that is no longer in vogue, right from 2005 or 13 is.
Please.
So how come you are making a
But that is
submission?
my, I have no instruction. Let them pass the order, my interim order, subject to my variation or modification of the order passed by this
That
honorable.
is always there.
Yes, I have no instruction that today I have followed.
So that majority we need to clarify. What do you say on that?
Please, madam, your lordship may kindly clarify.
No, what is that? What is?
Madam, what I am submitting is the stocks which I am holding, madam, by pursuant to my lord's order, whatever that I liquidate, that and then making the payment to the farmers, madam, all payment to the farmers only online, no cash transaction that has been dispensed with. And we will submit the same before your lordship once in a month, and also serving the copy of the Union of India. This is what the standard order also being passed by many of your lordships, my lord.
That is not coming up.
That's there, not there, my lord, but your lordship can put a condition because I have no
that
objection.
will say, no, that major portion that we have to quantify, that is what I'm saying.
Your lordship can say, all right, my lord, 90%, 10% may be retained and we will subject to your lordship's order.
90% no, my lord, 60% it may be released. 60% my lord.
No,
That is, I have no instruction. That is subject to my lord liberty move this court before that variation or modification the order passed.
Order I'll pass. If you want any modification, you come up.
Yes, sir, please, my lord, please. Please.
Please.
Present petition is filed. Questioning the clause number 5, 6 and 10 of the sugar within brackets.
First, my lord, validity of challenge, that was no, my lord.
325 as ultra virus of the Constitution of India. The interim prayer that is sought to grant stay of the impugned order dated 30/10/2025 issued by the respondent number 2. Insofar as the petitioner is concerned, and permit the petitioner to sell the entire sugar stock produced in its both units, that is unit number 1 at Hire
Padasalgi, it's a village.
unit number 2 at NAD KD Hindi Taluk during the sugar seasons 2025-2026. When a senior counsel appearing on behalf of the petitioner submits that because of this clause number 5, 6, 7 and 10 of the sugar control order, the petitioners are facing a lot of hardship. And the similar matter has come up before the bench at
Kalburgi.
The court has passed the following order. Look at this, extract this order. It is submitted that a similar order may be passed. When counsel appearing for the Union of India submits that, in the order it is stated that majority of the
Major portion of
the revenue to clear the dues of the farmers, which is not quantified by the court. Next part. Considering the fact that already in similar matters, a Kalburgi bench has passed an order, and also balancing the interests of the petitioner as well as the farmers, this court deems it appropriate to pass the following order. The petitioners are permitted to sell the sugar produced for the current season, that is 2025-2026.
25-26 minutes.
2025-26, subject to the condition that they would utilize 90% of the revenue derived from the said stocks to clear the dues to the farmers and farmers system. The respondents, the petitioner, every month, how much time it takes to sell this?
And it takes its own time, and it is
Take
not
the
so
updates,
easy
my
to,
lords.
no, it may not be so easy to liquidate also. It takes its own time.
No,
Months
generally,
to-
how much time it takes?
For it clearing the entire stock, it will not be possible in 3 months or 4 months. It will go on, it depends on
Every month,
Please,
the status
So,
report
yes, my
with
lord.
regard to the sales shall be placed before this court by way of a memo.
Please, my lords.
If the respondents, if
Yes,
the
liberty to, my
any
lords.
modification of the order basing on subsequent instruction, the respondents are at liberty to move this court.
Please.
Mr. Your name
DSG,
is-
I mean DSG, Deputy Solicitor General.
No, your name is.
DSG. Venkatesh Karvi.
It's there.
I am representing Union of India, the DSG, Deputy Solicitor General of India.
Union of India is represented by Mr. So and so. Then.
Respond 1 and 2, my
What
lords.
about 1 and 2 both?
1 and 2 both.
Yes.
Obliged, my lord. Great.
Keep that order. Yes, next.
Seal number 1.
Yes.
Raghavendra Purai, Nagarasi Kalluri.
List after the DCR is received. And then the second one, 1.1, I number 1 of 23 to condone the delay of 143 days for the reason stated condone. Next two.
Seal number 2.
Notice.
Hearing on IS, seal
notice,
number 2.
notice.
Issue notice. Srinivas B. Nayak. Srinivas B. Nayak, list to seal number 2.
No, in this only I said notice list number 2.
Recalling, I have complied with the office subject.
This court, by order dated 21/2026, petition to comply with the office objection. Pending consideration of IA, it is submitted that the office objections are complied with. IA number 1 of 2025 is filed, seeking to condone the delay of 29 days in recalling the application. IA number 2 of 2025 is filed to recall the order dated 27/11/2024. Considering the reasons stated in the accompanying affidavit, IA number 1 of 2025 is allowed by condoning the delay of 29 days, and also consequently IA number 2 of 25 is allowed by recalling the order dated 27/11/2024, and the appeal is restored to file. Issue notice to the respondent.
May I request for a call for records since.
First, let the notice be served, then we will.
Please.
Yes.
Seal number 3. Sunil Khoth.
Office objection has been compliant. Office objection has been compliant, my lord.
See, the petition, this court by order dated so and so has permitted the petitioner dated 21/2026 to comply with the office objection pending consideration of I number 1. It is submitted that the same is complied with. Next, I number 1 of 2025 is filed to condone the delay of 13 days in recalling the order. And I number 2 of 25 is filed to recall the order dated 6/2/2020, the same order. Notice.
There is another
Yes.
appeal filed by the connected along with my lords.
What is that?
Another appeal filed by the
Just along with so and so.
Number kodi sir.
4.
Seal number 4. Siddhappa Sajjan. Nagarasi Kalluri, Siddhappa Sajjan.
I number 1 of 2034 is filed to condone the delay of 131 days condoned on condition. Admit final hearing TCR is 5.
Seal number 5.
I have filed the wakalat by obtaining the NOC. So
In
Guru
this
Kumar,
case?
in this case, man, I am for the appellant.
Submitted that so and so has filed the NOC wakalat. Is
And
directed
kindly
to
connect
reflect-
with company appeal, man.
Reflect the name of the council. I number 1 of 2025 is filed to condone the delay of 434 days condoned on condition. List along with so and so.
Please, man.
Seal number 6.
Final hearing TCR. Yes, 6.
Seal number 6.
Appeal by the land user, my lord, seeking enhancement of the award.
Yes.
Yes.
There is a delay in filing of the above appeal, my lord. The land is acquired in the,
Delay of can it be condoned? 15 days.
yes, my lord.
Where are they? Where is the AGA?
AGA? AGA?
As per Supreme Court judgment, my lord, interest can be denied, my lord.
Huh?
Interest can be denied, my lord.
Not under the new act. Let's see.
It is a old act, my lord.
Let's see.
The notice may kindly be issued, my lord. Notice may kindly be issued.
Notice is
My lord,
already.
respondent number 2 is appealing for Lingesh Kattimani, my lord.
R2 is already served. Who else are there to be served? How many respondents?
Only 2 respondents, my lord. Respondent number 1 is AJA.
Is for R1.
R2
R2
is-
is already served.
My lord. Penal advocate is there, my lord.
What is the name?
Lingesh Kattimani, my lord.
So and so. Print the name of so and so. Yes. List after 2 weeks. Yes, 7.
Please.
Seal number 7.
Notice. Notice.
Issue notice.
Much obliged, Your Lordship.
Seal number 8. SC Bhuti.
Appealing for the appellant. My lord, this is a appeal 8 and 9 are the connected matters. My lord, the appeal by the insurance company challenging the liability, my lord. The accident occurred between the 3 vehicles. The tribunal has saddled, my lord, liability upon the trailers. My lord, the trailers are not insured. And also, my lord, they have not, my lord, registered the within the date of, my lord, accident. But the tribunal has saddled, my lord, 50% liability upon the insurance company. My lord, the other insurance company also filed the appeals.
Just along with all that.
Just along with.
Please.
Next.
An interim order may be extended, my lord, in both matters.
What is the interim order to be?
Interim order, my lord, stay of, my lord, judgment and award passed by the tribunal. They have filed the execution petition
No, why is it for limited period?
till next date, my lord.
Interim order for 50% is deposited.
Already deposited, my lord.
Yes, and until further orders.
Please.
Yes, just along with so and so. 9.
9. 8, 9, 6.
Seal number 9.
9.
9 also say, yes.
10. Seal number 10.
10, my lord. Insurance company have challenged the liability on the ground that the vehicle was partially implicated in this case. That the accident happened in the private premises. And they took the 3 days of delay in filing the register and the
How
complaint.
many days?
3 days.
They submitted that. There is a delay. Land transfer, the appellate insurance company submits that. There is a delay of 3 days in filing the complaint. And also the vehicle is not involved in the accident. Consider the same. 50%. Yes. Notice to the respondent 11.
Seal number 11.
My lords, I appeal for appellant, my lords. Appeal by insurance company, my lords, challenging quantum of compensation, my lords, on the ground that, my lords.
How much is awarded?
My lords, 14,62,700 has been awarded, my lords.
What is the admitted amount?
My lords, we do not admit, my lords, since we dispute the dependency, my lords, on the ground that, my lords, respondent number 1 to 3, my lords, the married daughters, my lords, of the deceased, my lords, and respondent number 4 was the major son, my lords. He was deceased, was aged 64 years, my lords.
The son's age?
Son's age, my lords. As on the date of claim petition, my lords, he is aged 33, my lords. He was a major son, my lords, and he was working in a garage, my lords. It has been admitted by the
33.
claimant.
And what about the daughter's age?
Daughters, my lords, claimant number 1 is 40 years, my lords, as on the date of claim petition, my lords. 38, claimant number 2 is 38 years, my lords. And
So
claimant
it
number
is,
3 is 36 years, my lords.
Percent amount on such deposit, they are entitled to withdraw as per the conditions laid down in the award. It is submitted with the land counsel to the petitioner, appellant, that they are questioning the quantum of compensation, and the children cannot be the major children cannot be the dependents of the deceased. Yes. Next.
Admission matter. Seal number 12. SC Bhuti. Arvind D. Kulkarni.
Yes, admit. Post to final hearing. Call for the PCR. Yes, next.
PCR.
13.
Seal number 13.
My lord, in this I am appearing for respondent number 2, my lord.
Case of death, my lord. Income considered by the is on lower side.
Which year is the accident?
2014, my lord. 7,500.
Taken.
6,000, my lord.
So it has to be taken as 7,500
500.
only on that issue.
Only
So
on that.
what is the age?
Age, my lord, 28 years.
40% future prospects. How many are the dependents?
2 dependents, bachelor death, my lord.
Case of bachelor.
Bachelor.
$5,250 into 12 into
17.
it comes to 10,71,000. Parents are the claimants.
Please.
48 into 2 comes to 96,000, 36,000 and 10,000.
My lords, 18, my lord.
You said
Multiplier
17.
is 18, my lord. 24 years.
But we should take because you have already said.
Sorry.
It
My lord,
comes
in
to
this book, 11 lakh.
Huh?
11 lakh 34,000.
7,34,000. Plus,
My lord, in this owner is liable, my lord.
let it be. What is your submission on this?
There is no liability upon them, my lord. They are not necessary party.
Yes.
R4 is already served.
10,76,000 is the.
Please,
Give the
ma'am.
file. Agreed with award passed and MBC number 878 of 2014 dated 2nd January 2020. The claimants are before this court seeking enhancement of the compensation. The tribunal has awarded the compensation as per the table given below. Where is the table? No table.
Please, ma'am. Table is there. No table, my lord. No table.
In the synopsis,
Synopsis,
the tribunal has awarded the compensation of an amount of rupees
10 lakh 17,200.
10 lakh
17,200.
17,200 and held that the owner alone is liable to pay the compensation. The claimant is before this court. Next para. When counsel appearing for the appellant claimant submits that the claimant is before this court seeking enhancement of the compensation. It is submitted that the accident had taken place in the year 2014, but the court had taken the income at 6,000 instead of 7,500. It is also submitted 7,500. Next para. Though notices are served on the respondent owner of the vehicle, there is no representation. No wakalat is filed. When counsel appearing for the insurance company submits that they have no liability. Next
SBI.
para.
SBI Bank, my lord.
Bank, my lord. It's not insurance company.
Respondent bank submits that they have no liability. Next para. Having heard the counsel for the petitioner for the appellant claimant, peruse the material on record. Accident had taken place in the year 2014. Hence, this court, as per the chart prepared by the Legal Services Authority, is taking the income at 7,500. As he is aged 28 years and unmarried, future prospect at 40% would come to 3,000. Then his income is 10,500. As he is a bachelor, 50% has to be deducted. It comes to 5,250 into 12 into 18. Under the head of loss of dependency, he is entitled for 11,34,000. Consortium 48 into 2, 96,000. Funeral expenses 36,000. In the light of the law laid down in so and so, legal expenses 10,000. Altogether, the claimant is entitled for an amount of rupees 12,76,000, which has to be paid by the owner of the vehicle. The entire amount shall carry 6% interest. Yes, next.
Please, ma'am.
Yes.
Seal number 14. Chandrasekharam Hasmani.
Case of death, my lord. Age is under dispute.
Lord, yesterday he given me appeal memo. I sent it to company yesterday only.
Last time also the same reason it is adjourned.
He is given yesterday.
You can file your wakalat within a week.
I see the papers.
Huh?
I want to see the papers, lower court.
No, it's only you can.
Next Thursday, without fail, I argue the matter.
Yes.
These are all the small issues which you don't require papers at all. Yes, next. Speak at the request of respondent. No further time will be granted, whether any wakalat is filed or not, matter will be heard and order will be passed. Yes.
15 NR Kupeluru, Gita KM.
No representation. List this matter in the month of June.
June.
Yes.
Seal number 16 urgent. Seal number 17. MB Patil. MB Patil. DM Patil.
Case of amputation, last time, case of amputation, below knee, 100% disability, my lord, the division bench. I have
As per
forward-
schedule, my lord, 50% is there, my lord. They have, he's a agriculture coolie, my lord. He can do another work, my lord. Even schedule, doctor is also,
Matter in the month
my
of
lord,
April.
My lord,
doctor is also itself. shows
judgment
that,
I
my
have,
lord.
lordship. Your lordship kindly see, division bench and also Rajkumar and Ajay.
Judgments which you are shown or not, in those cases, the facts are different.
Below knee, my lord. Amputation
The
of
driver, it is a different aspect.
No, my lord, even carpenter, even agriculturist, this is the judgment followed by the division bench. Your lordship kindly see. Judgment is there, my lord, division bench. Who judgments are there? My lord, paragraph 17, your lordship kindly see. 17. The extent, my lord, 2007.
To please show the Supreme Court judgment,
Supreme Court, Ajay Kumar and his, my lord.
that we will see.
Yes, my lord. I have forwarded the last time, my lord, that is there.
Look at it.
Ajay Kumar, para 10.
Must be in the file.
Ajay Kumar.
Ravindra.
Ajay Kumar.
Adil, Ajay Kumar. Adalri run.
Take that.
Your lordship kindly take the para
Adalla.
10, my lord.
Yes.
My lord, in para 10, my lord. Rajkumar and Ajay Kumar. My lord, para 10.
That's what.
Your lordship, para 10.
I've seen that.
See, the asset and effect of permanent disability, my lord, that has to be seen, that activities of the avocation. Your lordship kindly turn the page number.
Lord, that judgment is itself is show that, my lord, different avocation, different status
That's
is there.
what I'm saying.
Ah,
No,
that's why
not
that's,
status.
my lord.
That given two examples. In
right.
fact, my lord, in a hurry, my lord, I could not.
The third step is to find out
yes,
whether
ma'am.
Yes, yes.
the claimant is
Yes.
totally disabled.
Yes, you lordship
Even
kindly
if it
bottom,
is-
my lord, bottom. In another, they have stated two examples have given. One, my lord, one driver, one the carpenter. Suppose the doctor has assessed the disability of 50% or 60%. So what is the occupation? So here is the, my lord, the agriculturist. He can't, my lord, do anything. My lord, he has to flow all these things.
One doctor is not stated. by-
Next week, my lord, I will, next week.
This is matter in the month of March. Yes,
Next week, my lord.
March. Yes, 18.
Seal number 18. 18. Further hearing matter.
Yes.
That was heard on the last date of hearing, my lord.
Case.
Why
Case
is
of
it?
death,
Regarding
ma'am.
the
Bachelor death.
fal-
ma'am.
Huh?
Case of death, bachelor death. ma'am.
falsely
The
implication of the
complaint,
insured
date of
vehicle.
accident is on 15/11/2015. And
First is your appeal.
Please, sir.
Second is,
my appeal,
on what ground you are here?
enhancement, enhancement, case for death of enhancement.
Who appears for the
Claimants, ma'am.
divisional manager?
No, I am for the,
He's the
Insurance company.
insurance
So second is your appeal. Second appeal is yours, MFA 102980. On what ground you are before this court?
Last time I advanced the argument, my lord. The insured vehicle is falsely implicated on the ground
Why
that
is this adjourned on the last occasion?
he has sought the time. Your lordship has expressed that matter will be fit for
Falsely,
remand to the
well,
tribunal
Falsely,
for recording the
the
evidence.
vehicle is falsely involvement is the ground is there, my
Is
lord.
this a case where the pillion rider was not examined?
That is the case,
That-
my lord.
it's
Now
a fit-
the falsely implicated the vehicle of the motorcycle, my lord. And so after the investigation, the police have filed a charge sheet and a FIR and a Panchanama. They have clearly stated that the said vehicle is involved in the vehicle. And even though the insurance company has not challenged that
Why
charge
insurance
sheet.
company will challenge a claim?
If
Criminal case,
if it is the involvement of vehicle is there, my lord.
criminal case, why will the insurance company challenge? It will not challenge. It is not a party.
I can't.
Therefore, my lord, therefore the tribunal has awarded 9,36,000
Will
rupees.
remand the matter.
Please,
For only your instructions, the matter is
yes, he has sought the time.
agreed with the award passed in MVC number 320 of 2016. Dated 17th May 2018. Both the insurance company and the claimants are before this court. Claimant's appeal is MFA number 10036 of 2022. And the insurance company's appeal is insurance company or insurance company only?
Please, madam. Insurance company
Company's appeal is MFA
102980.
number 102980 of 2018. You their appeal? Next appeal. The claimant is before this court for enhancement of the compensation. The insurance company is before this court that the claimants have not proved and established that the insured vehicle has involved in the accident since the complaint was lodged after a lapse of 9 days from the date of the accident, and which indicates that the complaint is an afterthought. As per the wound certificate, certificate that is Exhibit 9, the claimant had sustained simple injury and got discharged against the medical advice. The claimant had been in hospital.
No records are produced.
Yes, ma'am.
No records are produced.
According to the claimant, he has been in the hospital by 10:25 p.m. and the age of the injury is below 12 hours. However, the wound certificate and the treatment records were not produced. Without the wound certificate, the court had considered and passed the order. It is also the case of the insurance company that the tribunal has not considered the complaint filed by the brother of the deceased, stating that his mother is also admitted to KIMS Hospital, Hubli, and he was in emergency ward. But the claimant has not produced any records as to why injury and treatment in KIMS Hospital, Hubli, which shows that the deceased has not died because of the RTA and the insured vehicle is not involved in the accident. It is submitted that the deceased was a pillion rider.
Please.
The deceased was a pillion rider. The complaint is given after 9 days, and even the rider of the vehicle was not examined. All these circumstances strengthens the case of the insurance company. Next, learned counsel appearing for the claimant submits that after conducting a full-fledged investigation, the police have filed the charge sheet against the insured vehicle. In that case, it is for the insurance company by producing the cogent evidence to say that the said charge sheet is filed without any investigation, and any other material if required, it is they have to file. But without doing any of it, they cannot come before this court and submit that the vehicle is not involved in the accident. Next para. Having heard the counsels on either side, produce the material non-report. It is an undisputed fact that after 9 days from the date of accident, the complaint is filed. The
3 days.
Huh?
3 days.
3 days.
3 days.
Not 9, 3 days. It is the rider of the vehicle was not examined. The brother of the deceased was along with him when he was admitted in the hospital. But in the FIR, he has taken a different stand. The wound certificate was not produced.
Not
the wound certificate. Initially, as per the certificate, it shows that there are no injuries. The petitioner, the claimant, was discharged against the medical advice. All the material records, medical records, and non-examination of the rider is fatal to the case of the claimant. In that view of the matter, balancing the interest of both the parties, this court deems it appropriate to set aside the award dated so and so and remand the matter to the court accordingly. On so and so is set aside, and the matter is remanded to the trial court. Both the parties are at liberty to adduce evidence, and all the issues are left open for the court to decide. Without further notice from the court, the party shall appear before the court on 17th February, within 6 months from the date from that date, the court shall dispose of. The amount in deposit shall be forthwith transferred.
Maybe order to be refunded to the appellant.
Why?
Because liability is to be determined. Liability is to be
Anyway,
determined.
let it go to the trial court.
Then the trial court may be directed to invest the amount in some other natural asset.
Yes, in a fixed deposit.
Final hearing matter, seal number 19. Prithvi case, NR Kupeluru.
Appear for respondent.
Case.
Appear for respondent. Records are necessary in this case.
Why?
But the tribunal has held that there is no nexus between the injuries and the death occurred.
Claim petition is dismissed.
But only medical expenses have been awarded. 32,000 is awarded. It is held that there is no nexus between the injuries and the death.
Yes.
There is a recent Supreme Court judgment, my lords. Irrespective of nexus, my lord, the legal representatives are entitled for the compensation, my lord. I'm sorry, my lord. It was I didn't get the judgment, my lord.
This is matter. Registry is directly called for the TCR. Yes, 20.
Please. Seal number 20. By Lakshmikant Reddy.
My lordship, I'm appearing for the claimant, your lordship. The petition is filed on 63A.
My lord,
So
in this
time of 2 days may be granted, your lordship. Time of 2 days may be granted, your lordship.
my name is deleted. Kindly show
This is
the
matter after two.
Dharnappa Kolewad. He is filed the appeal.
Read the name of
M.I. Katigi.
M.I. Katigi.
And shown the SS Kolewad. SS Kolewad. He is
SS
filed the
Kolewad.
appeal. Please, please,
This is the name of, print the name of so and so. Yes, next.
Much obliged.
21.
Seal number 21.
There is a connected appeal filed by me seeking enhancement of
A
the
list along with so and so. After 2 weeks. Yes, 22.
obliged.
22. Seal number 22. Ravindra Armane. Suraj S. Mutnal.
Who appears as the respondent?
I am appearing for the respondents.
Yes. My lord, insurance company's appeal, my lord, challenging the finding on negligence. My lord,
only ground.
and quantum of compensation also. My lord, case of death.
First, the negligence aspect we will see.
Negligence. My lord, my submission is the deceased was crossing national highway, my lord, along with cattle, cows and buffaloes. At a place, my lord, where there was no provision. It was, my lord, that place cannot be used for crossing the road by taking cattle with the person. My lord, at the at that place, my lord, there is another provision made by the government, my lord.
Shall we read that particular, the observation of the court?
Pardon me, yes.
Where is it?
Pardon me, my lord.
No, where is the finding?
Yes.
Para 13.
Yes, your lordship. Here, from paragraph 11, my lord. Respondent number 2 insurance company is alleging that there is contributory negligence on the part of the deceased. It is specific case of insurance company that deceased has not used cart underpass to go to Katabi village, and hence she is negligent. I have perused spot mahzar and hand sketch marked at exhibit P3. It is an admitted fact that Mahadevi, after grazing cattle, was returning to house and crossing national highway. As per exhibit P3, spot accident is not zebra crossing place, which is meant for crossing the road. Exhibit P3A sketch prepared by the police indicates that the point of the impact with the deceased was at distance of 6 feet from the left side of the road, and 24 feet road is available at right side. It is therefore clear that the pedestrian had not only stepped down to the road, but also traveled a couple of feet onto the road. It is clear from exhibit R1 photo and hand sketch that at the place of accident, road is straight and driver of the vehicle would have easily seen the pedestrian. It is to be noted here that as road is straight, visibility as a consequence of it is much better. No doubt a pedestrian is not expected to cross the road suddenly, especially in a highway. However, a pedestrian committing an infraction of a rule cannot by itself lead to the conclusion that he had contributed to the actual accident. The driver is expected to drive defensively, and being a professional driver would have the knack of preventing accidents. Reliance can be placed upon the decision of Division Bench of Honorable High Court of Karnataka in MFA 4701 of 2005. So may I read, my lord, everything?
Yes. I have read.
Yes.
So according to the observation of the court is,
yes,
there is no indicator that there is an underpass.
No, I have produced documents, your lordship.
Here, if you see.
My lord, I have produced photographs of the scene of accident. Kindly see the photographs. And I had written a communication letter to the highway authority. They have also replied, my lord, as per exhibit R6, that there is a provision for passing of the cattle.
Exhibit RC, cart underpass may be there to go to so-and-so village, but it is nowhere near spot of accident. So the defense of insurance company is not sustainable.
My lord, I have produced the photographs and...
it is nowhere near, it is somewhere, somewhere it is. That's what the court's observation is.
My lord, kindly peruse exhibit R6. Because the spot was also made known to the highway authority. And they have replied that there is but near, my lord, near the place of accident.
It is nowhere near spot of accident.
No, that is a wrong observation. I have laid evidence, my lord. Everything has been done. Photographs have been taken.
Read that evidence.
Pardon me, my lord.
Read that evidence.
In the meantime, kindly see the photographs, my lord. And exhibit R6.
We'll take next week.
Yes.
Next.
My lord, and some cross-examination is in Kannada language, my lord.
Let's just matter after 3 weeks.
Yes, my lord.
Number 23, Umesh Yainapur, SK Kayakmat.
I appear for the respondent, my lords.
Lord, owner liability is there, my lord.
it's owner liability is there, my lord. Only on the ground of at the time of driving, my lord, he has no valid driving license. Driver has no valid driving license, my lord.
Yes,
That
what do you say?
Rider was not having DL minors, he has been charge sheeted, so the owner has been,
No, no,
the liabilities.
pay and recover.
Pay and recover will apply.
Please, my lords.
What about the quantum? You are
My
not
lord,
on
quantum, my lord, the income is not considered properly, my lord.
Which year is
2016 accident, my lord. 8,250 is there,
Which
my
year
lord.
is accident?
2016 accident is there, my lord. And
8,750, my lords.
Court has taken
please.
6,000.
6,000. What is the age?
21 years, my lord. 40%, please. 21 years, my lord. Future prospectus may be considered 40%, my lord.
Court has considered future
25%.
Court has considered the future prospect.
The tribunal has
Yes, my
not
lord.
considered, my lord.
Yes, my lords. Considered as a 25% has been taken. It should be 40.
40%.
Losses of consortium also taken by the tribunal.
Let's take step by step.
Death of a bachelor, my lord, so 50% has to be deducted.
Yes.
Two dependents are there.
Thirteen lakh 23,000 dependency comes.
It comes to 14,65,000.
Please.
Against?
Against the 8,10,000, my lord. 8,10,000.
Where is that? Page number?
Losses of dependency, my lord.
Hmm.
Page number 14.
8,20,000. The agreed with the award passed in MSC number 1072 of 2017, dated 18 March 2021. The claimants are before this court, seeking enhancement of the compensation, as well as questioning the liability that is fixed on the owner of the vehicle. The tribunal has fixed the liability. The tribunal has granted the compensation as per the table given below at paragraph number 19 extract. The tribunal has considered the income at 6,000 and considered the future prospects at 25% and granted the compensation. No, this before the table and granted the compensation as per the table given below. Then counsel appearing for the claimant submits that even if there is no driving license to the driver of the offending vehicle, still the principle of pay and recover will apply. It is submitted that the accident has taken place in the year 2016. Court has taken 6,000 as income instead of 8,750. As is aged about 21 years, future prospects at 40% ought to have been taken, but the court had taken the future prospects at 25%. Even under the conventional heads also, the amount that is awarded by the tribunal is not just unreasonable. Next parallel, counsel appearing for the respondent admits that the tribunal has rightly considered and rightly granted the compensation, and there are no grounds to interfere. Next paragraph. I've heard so and so. This is the first coming to the aspect of liability, considering the fact that this is an accident, the driver of the vehicle is not having the valid driving license, that itself cannot be a ground for the court to exonerate the insurance company, considering the judgment of the Honorable Apex Court in Swaran versus so and so. The principle of pay and recovery will apply. Insurance company is liable to pay the compensation and recover the same from the owner of the vehicle. Then coming to the compensation, as this accident has occurred in the year 2016, this court is taking the income at 8,750. Future prospects at 40% will come to 3,500. Then the income is 12,250. As he is a bachelor, 50% has to be deducted towards his expenses. Then his contribution to the family is 6,125 into 12 into 18. Under the head of loss of dependency, 13,23,000. Coming to the loss of consortium, 38 The 48 into 2, 96,000. Funeral expenses 36,000. In the light of the law laid down in Meghalaya also so and so 10,000. Altogether, the claimant is entitled for an amount of rupees 14,65,000. Accordingly, the appeal is partly allowed, enhancing the compensation from 8,20,000 to 14,65,000. The enhanced amount shall carry 6% interest. The entire amount the insurance company shall pay and record the same from the owner of the vehicle.
Lord, records may be sent back to the tribunal. The records may be sent back to the tribunal.
It will go.
Obliged.
Yes.
Number 24, Lakshmikant Reddy.
I appear for the appellant insurance company, my lords. My lords,
What ground?
we have challenged on the ground of liability, my lords. As the appeal memo is totally different from the judgment, by mistakenly we have submitted the other appeal memo. So I'll file the amendment application, my lords.
This is matter after 3 weeks. Yes, 25.
3 weeks.
Much obliged.
Obliged, my lords.
Still number 25, Chandrasekhar Mosmani.
Claimant appeal for enhancement.
Katigi.
There is a connected appeal filed by the insurance company.
List along with so and so.
Number good.
My name is different. Kindly filed SS Joshi.
SS Joshi.
Is filed appeal.
Delete the name of Mr. M.Y. Katigi and print the name of so and so.
SS Joshi.
Yes, list along with so and so. S26.
26, Moy Katigi.
Company appeal, my lord.
Kurumari.
And for the respondent.
On the ground,
And the ground pay and recovery is order made.
not ordered. Is not ordered.
Order pay and recovery. He is having LMV license. He is driving the two-wheeler license. Then as per the age of the deceased, consider PM report 60 years. As per the petition number 2 age, he has produced his age documents. His age was as on the date of accident 51 years. Hence, the age cannot be considered as per ID and exhibit.
No, PM report is there. We will consider PM report, postmortem report.
Age of the petitioner's son, petition number 2 son, his age producer 51 years as on the date of accident. How can mother age was 60 years? As per the Aadhaar card and election identity card, 72 years as on the date of the accident.
Report is there or not?
PM report is there.
What it says?
60 years mentioned. It is.
When there is a dispute with regard to the age, which has to be considered?
Aadhaar card is and
No. Postmortem report has
he is admitted petition number 2, his age was 51 years as on the date of accident. Then if his age was admitted in 51 years, mother age is how can consider 60 years, my lord?
But we can't consider the other thing, which is convenient to the insurance company.
No.
Postmortem report would be the decisive factor for
No,
the
petitioner themselves admitted their age was 51 years as on the date of accident.
Whatever their admission is, medical evidence is more powerful than that.
No, my lord, petition number 2 is himself admitted as on the date of accident, my age was 51 years.
I will take the age as per the postmortem report.
Kindly calls for records, I will argue.
Yes. Call for the report, records.
Still number 27, CM Osmani, Nagarasi Kalluri.
I seek weak accommodation, my lord. In connected matter, I have to take steps, my lord. Weak accommodation, my lord.
Yes. A week's time.
Please,
Yes,
my lord.
28.
Please,
Number 28, Bahubalian Kanbargi, Sanjay Katigeri.
This is matter in the month of March. Yes, 29.
Still number 29, NR Kupeluru, HR Latur.
Appeal by the insurance company challenging quantum of compensation. my lord.
Both are, you're on NL.
Ready.
Where is it? Case of death or injury?
Death case.
Death.
This is what 28 years old.
Which
20,
age? What is the
28. my lord.
age?
28.
How much is the income taken by the court?
20,000, my lord.
20,000. Which year is the accident?
2018.
18. my lord.
Basing on what 20,000 is taken?
The claimants have produced, my lord, exhibit P14, the salary slip.
Anybody is examined?
No, my lord.
31 salary slips are produced before the tribunal.
On the last salary was drawn by the deceased was 28,000, my lord.
Have you produced the bank account statement?
No.
No, my lord, only salary slips are produced by only the
Except that
salary
salary
slips.
slip, my lord, nothing is
Sir,
produced.
you have to examine somebody in support of it.
Yeah, not examined, and also there is no rebuttal evidence by the other side, my lord. Insurance company or owner of the vehicle.
Cross exam.
It's for you. You are asserting the fact that you are earning 20,000. Burden lies on you, not on them.
But basis is only,
If you want, I'll remand the matter to examine the concern. Otherwise, we can't take that into consideration. At least you should have produced the bank statement to show that this is what is the salary that's in your account.
but already it is 2018, 7 years, my lord. But
What
one submission, my lord. One reasonable amount may be considered because 28,000 last drawn salary, but criminal taken 20,000.
28, my lord.
28.
Which year is this accident?
18.
2018, my lord.
We'll take 15,000.
It is very less, my lord, because 2018, because if there is no any documents, I agree for that amount.
To have the bank account statement produced before the court, then we will consider as additional
But
evidence.
again, it will take much time, my lord.
No.
Again, that they will file an appeal.
No, before this court.
I will ask the.
If the bank account statement is there,
Please.
we can safely consider, because every month there will be
Please.
in the account. Yes, the accounts for the claimant shall place before the court the bank statements by way of an appropriate application under Order 41 Rule 27. Yes.
Please.
Seal number 30. C.R. Turmare. S.C. Bhute. For the speaker.
It's a claimant's appeal challenging the liability, Lordship, 70% to the owner of the vehicle. Lordship, now at the time of accident, he has not produced the DL and RC book, Lordship. Now you have produced, Lordship, kindly. Weeks time, Lordship, the license and the
Yes.
kindly.
This matter after 2 weeks.
Please, Lordship.
Yes. 31.
Seal number 31.
Insurance company appeal, Lordship, or on two grounds. One is contributory negligence. That the rickshaw, though he was charged sheeted, the driver, he is not made liable to pay the compensation. So 50% or more than 50%. Actually, the accident was caused due to the negligence of the rickshaw, who immediately came and stalled his rickshaw in front of the tempo and to catch the passengers. And the two-wheelers went to the side. The tempo went and hit the auto rickshaw. Auto rickshaw went and hit the two-wheeler. The pillion rider of the two-wheeler died. Now, the whole liability is fastened on the tempo driver. Actually, the mistake is the auto rickshaw which stalled immediately to pick up the passenger. So we came in appeal saying that even the rickshaw owner has to be made liable. Point number 2 is pay and recovery order is not there, though there is no driving license. We had called for driving license, and the notice is there, acknowledgement is there. Still, pay and recovery order was not.
Let us see that finding with regard to the negligence.
Please. May I take Lordship to running page number 22, issue number 1. That is in page 12, reasoning.
Yes.
The issue is framed with respect to the rash and negligent on the part of the driver of the tipper bearing and auto rickshaw bearing chassis number so and so. So as to their cases, petitioner number 3 examined himself as PW1 and filed affidavit in lieu of the examination. PW1 categorically deposed that on 2/4/2016 at about 11 a.m. Sri so and so along with petitioner number 3 was proceeding towards so and so from Athani to on motorcycle bearing number so and so. Petitioner number 3 was riding said motorcycle and Shobha was a pillion rider. When they said when they came near Balli cross,
The driver of the tipper drove vehicle in a rash and negligent manner, dashed to the auto rickshaw. As a result, the said auto rickshaw dashed to the motorcycle. Now, first your vehicle. Your vehicle. What is this?
Tipper.
Tipper dash to
Auto rickshaw.
Auto rickshaw in turn dash to the.
To the two-wheeler and the pillion rider.
So why do you say that there is negligence of the auto rickshaw?
Because he came and stalled the vehicle beside on the road, pick up the passengers. If you lordship to see the next para, but the next para is a contradicting. There they say that the tribunal also there was a cross-examination of PW wherein it is admitted that when he was proceeding towards so and so village, the truck came from backside and dashed to him, and therefore thereafter dashed to the auto rickshaw parked on the said road. Actually, this is a contradicting the first statement. It did not directly hit the motor vehicle. It hit the auto rickshaw. Whereas it appears that exhibit P1 that the truck dashed first to the auto rickshaw and said auto rickshaw dashed to the motorcycle. It is worthwhile to state that it appears from both version discussed above that the driver of the tipper drove his vehicle in a rash and negligent manner dashed to the auto rickshaw standing on the side of the road. It is not outside the road. To pick up the passenger, it should have been on the footpath beside the road. He was standing on the road. In either way, it appears that petitioner number 3 did not ride his motorcycle negligently. Apart from this, it appears from the police records as well as evidence on record that the auto rickshaw was parked on the side of the road and the tipper dashed on it. He says it is on the side of the road. Actually, if the charge sheet is perused, though it is in Kannada, the vehicle was stalled immediately to pick up the passenger. So when a tipper is going, if he brings the auto rickshaw and makes his,
It was already standing on the road.
that is to pick up the passenger. If he
When you're going on the road, why should you go to the extreme left and hit it and that in turn to the two-wheeler?
that is if we are usually driving on the left side of the road, and when he comes and halts a vehicle.
He is already there. It is not that he came and
That is not when he is picking up a passenger. It is only when
if you can demonstrate from what is there before the court that he suddenly took a turn and stopped.
nowhere on the record it has come like that.
As far as liability will confirm the order.
But the charge sheet is also on the driver of the auto rickshaw. Had that been so, the charge sheet would not been on the driver of the auto rickshaw, Lordship. He is also one of the accused. Accused number 1 is the charge sheet speaks about the negligence, stalling the auto rickshaw on the road, blocking the way of the way. That is under section.
That is not with regard to the
283, section 283 of IPC has been charge sheeted.
Yes, then come to the quantum.
Quantum we don't dispute, but there was no driving license. Though we called for the driving license of the tripper driver, he has not produced it. Therefore, and he was charge sheeted under section 3 and of the Motor Vehicle Act. Therefore, he did not have a motor vehicle license. Therefore, pay and recovery should have been ordered to the extent of liability.
Yes.
My lords, I am for respond number 4, owner of the tipper, my lords.
What about the driving license?
My lords, I have produced, my lords. It's in exhibit R12, my lords. They have all produced that, my lords.
No. R1 is auto rickshaw driver, not tipper.
Wherever there is a driving license, that is your driving license.
Santosh, but here is the auto rickshaw.
So when it is not marked, however you search, you will not find. Please come.
Lords, kind permission. Future prospectus is not been considered in the criminal, my lords. Order 41 rule 33, my lords. Future prospectus has been not considered at the time of.
Where is your appeal?
Order 41 rule 33 symbol.
They are not on the quantum. They are not on the quantum. When you don't prefer an appeal, we will not consider all that. They are not on the quantum. If they are on the quantum, while doing it, I will also consider that. Insurance company is only on the question of liability, nothing else. The present petition is filed. Agreed with the order award passed in embassy number 2437 of 2016 dated 25th February 2022. The claim petition is filed seeking compensation of an amount of rupees 30 lakhs for the injuries for the death of the deceased in the accident. It is a case of the it is a case of the claimants that on 2/4/2016 at about 11 a.m., the, the deceased along with the claimant was proceeding on a motorcycle and she was the Korean rider. When they came near Gabli Cross, the driver of the auto rickshaw stopped his vehicle on the side of the road. At that time, the driver of the tipper drove his vehicle in a rash and negligent manner, dashed the auto rickshaw. As a result, auto rickshaw dashed to the motorcycle, due to which the deceased fell down and sustained grievous injuries all over the body. The tribunal on the issue of negligence had held that there are two versions. One is that the tipper dashed to the auto rickshaw and auto rickshaw in turn dashed to the two-wheeler, whereas evidence of PW1 that the tipper dashed to the two-wheeler and then dashed to the auto rickshaw. The court that observed that in either way, it appears that the claimant did not ride his vehicle negligently. Apart from that, it appears in the police records as well as evidence on record that the auto rickshaw was parked on the side of the road and tipper dashed to it. Admittedly, the accident in question took place at 11 a.m. In such eventuality, mere parking of the auto rickshaw on the side of the road itself cannot be considered as cause of accident when the driver of the tipper dashed his vehicle to the said auto rickshaw. When counsel appearing for the insurance company submits that there should have been a contributory negligence on the auto rickshaw, in spite of the fact that the charge sheet is filed against the auto rickshaw also, the entire liability is fixed on the tipper vehicle. Further, it is submitted that the driver of the tipper is not having a valid driving license, and in that case, the principle of pay and recover will apply. This aspect was not considered by the court. When counsel appearing for the driver of the owner of the tipper submits that the court has rightly fixed the liability on the insurance company. Land counsel appearing for the claimant submits that though they have not filed any appeal, still they can argue, they can seek for enhancement of the compensation. Next, having heard the counsels on either side, for submission. First, coming to the aspect of contributory negligence, the charge sheet is filed. As per the evidence on record, the driver of the tipper has dashed to the auto rickshaw. Auto rickshaw in turn has dashed to the motorcycle. Admittedly, the auto rickshaw was parked on the side of the road. The tipper has dashed to that, and now no evidence is letting to show that, except relying on the charge sheet, no other evidence is placed on record to show that that there is negligence on the part of the driver of the auto rickshaw. The court has rightly discussed about how in both eventualities, how the driver of the tipper was negligent. In these circumstances, this court is of the view that the court has rightly considered the aspect of negligence. Then coming to the aspect of pay and recover, when the driver of the tipper is not having a valid driving license, then the principle of pay and recover applies. and the insurance company is liable to pay the compensation and recover the amount from the owner of the vehicle. Accordingly, this code is passing accordingly, the appeal of the insurance company is partly allowed, holding that the insurance company is liable to pay the compensation and recover the same from the owner of the vehicle. The amount in deposit shall be forthwith transferred. Yes, next.
Number 32. Vishnath Badger. Narkupeluru.
Please, these two appeals are filed by the insurance company. MFA number 102147 and 102148, my lords. These are two injury cases, my lord. The appeal is filed on the ground that, my lord, the driver of the offending vehicle, that is a crane, my lord, crane,
These cases of injury, we will see some other time.
had not possessed valid and effective DL, my lord.
Lordship is covered by judgment of this honorable court already is held that.
List these matters after 2 weeks. Yes, next.
Number 33. Srinivas Binayak.
Owner's appeal.
Vajipati.
Yes. Yes.
Case of death, my lord.
What is the age?
The age, my lord, I am challenging only on the ground that, Lord, liability initially is challenged on, Lord, saddened on me to pay the
You are
compensation.
the owner of the vehicle.
I am the owner of the keeper. On the ground that, my lord, there was no valid driving license for the driver to, my lord, drive the tractor as a particular point of accident. Now, my lord, in view of the decision in the full bench of this court, Ningava's case, pay and recovery ought to have been ordered. That is the only.
Pay and recover not to the owner. It is for a third party.
Yes, that is only the ground. Lord.
Please come. Agreed with the award passed in MVC number 407 of 2018 dated 16 January 2020, whereby the court has fixed a liability on the owner of the vehicle. The owner is before this court. Then counsel appearing for the owner submits that even though the driver is not having a valid driving license, the principle of pay and recover applies. Then counsel appearing for the respondent insurance company submits that is available to a third party, but the owner cannot come on that ground. Next para, having heard so and so, as rightly submitted by the land counsel for the insurance company, the owner cannot come before this court seeking for a pay and recover for application of the principle of pay and recover. Accordingly, the appeal is dismissed. Amount in deposit shall be forthwith transferred. Yes.
Great.
Next.
Number 34. Rishas Maitu.
Lord, this is parted matter.
Appearing.
First matter, already your lordship has come to the conclusion. And in second matter, my lordship.
It's 24 lakhs, 21 lakhs or 4 lakhs it is. In between line is missing.
First case, my lordship.
9975 into 12 into 18. It comes to 21 lakhs. 21 lakhs 54,600. As far as loss, no. First case, 27 lakhs. 27 lakhs 13,200 plus 36,000 plus 1,32,000. It's coming to 28 lakhs. First place.
No.
28 lakh. MVC number 1238.
My lords, it comes more than that because dependency, my lords, has not disturbed.
27 lakhs 13,200.
200. Then
36,000 towards consortium.
Please.
It is 44 into 3. 36,000 towards funeral expenses. Consortium 44 into 3. Now we are taking it as 48. That is another 12,000 will increase. That is 48 into 3. It comes to 1,44,000.
My lord, escalation.
And another 10,000 towards legal expenses.
My lord, escalation, so far escalation considered is 2021 case, my lord. Escalation,
It is not 21.
2021 matter. Accident, date of accident 11/4/2021.
We are not concerned with when is the accident. We are concerned with
Judgment.
when is the judgment of the apex court in that, and from there, every 3 years, there has to be escalation of, that is what, no.
No, madam. That matter.
That is, I will consider your
That matter.
submission, and I will also record what is my finding on that.
No, just a submission, my lord, that this issue has been referred to the larger bench.
After Rajar bench gives the order, you can ask for review of this.
Total it comes to 28,91,200.
It's coming to 29 lakhs 32,000.
Please.
29 lakhs 3,200.
29.
In the first case.
Please.
Second case.
Second case, my lords, the question.
22 years.
22 years, my lords, there are 5 dependents, and my lords has come to the conclusion that the son, my lords, is the only dependent. In-laws, my lords, and parents, and my lords, I am relying upon the judgment, 2 judgments of the apex court.
So if this is the case, in all the cases, we have to take the both sides in-laws as dependents. Yes.
Subhash, my lords, may kindly.
You are looking at Sarla Varma.
My lords, in para 30, my lords, para 30 of the judgment.
30.
Please. Though in some cases, though in some cases, the deduction to be made towards personal and living expenses is calculated on the basis of units method indicated in Trilok Chandra. The general practice is to apply standardized deductions. Having considered the several subsequent decisions of this court, we are of the view that where the deceased, well also, I am reading this one, where the deceased was married, comma, the deduction towards personal and living expenses of the deceased should be 1/3.
No, my lord. See,
Paragraph number 30.
please, ma'am. Just, I will clarify ma'am, how to read it. Here, my lord, towards the, we are view that where the deceased was married, and addition to that, my lord, deduction toward personal living expenses of deceased should be 1/3. Next paragraph, where the number of dependents, family members 2 to 3, it should be inclusive. I will read again. We are view that where the deceased was married, this is the one condition. Second thing is should be 1/3 condition, my lord, where the number of dependents, family members is 2 to 3. That court has to ought to have decided that if the family member, if dependent are 2 to 3, then 1/3 deduction so far is considered to married. And then, my lord, if it's sole dependent,
We can't keep the semicolon commas as we want.
No.
We have to read from what the judgment
my
says.
lord, in this particular point, my lord, you have made this judgment where you have considered sole dependent 50% deduction. Yes, one day is a copy. No, that's.
Now, my dear.
No, here. I have the only one copy, my lord, that another division bench judgment was there.
New India Insurance Company Limited versus Sri David T. and another report in ILR 2002 is 50%.
My lords, 2000?
2012.
12. My lords, I am relying the judgment of the apex court. And also one recent judgment in the year 2024 ACJ. I have already given.
Where is that?
2024. And this judgment is from the, my lords, Gujarat High Court. That is reported judgment before the Gujarat High Court. And even before the apex court, this.
Let us
Please, my lord, second, my lords, para 2. The motor accident claims tribunal in short so allowed the claim petition wide award dated 7/2/2018 granted a compensation to the tune of rupees so and so, so and so on challenging the said award before the High Court by the impugned order dated so and so, the High Court deducted 50% towards loss of dependency on the pretext that it was only the wife who was the claimant having no children. The High Court directed to pay so and so, applying the analogy of a bachelor because the claimant was only the wife and not the children. Further, after having heard so and so appearing for the parties at length and considering the law laid down by this court in Sarala Verma and others, so and so reported in so and so.
My lord, this is another division bench of judgment recently is passed.
Who are you concerned with the division bench when there is a Supreme Court judgment?
No, no, that was discussed. Saralwama has discussed and interpreted how.
Sarla Verma, why do you require it when there is a judgment of the apex court?
That apex court judgment was, madam. Saralwama has very clearly held that the family dependent should be 2 to 3.
You please no, he relies on a Supreme Court judgment.
That judgment I interpreted, madam.
Please listen.
Please.
You rely on a division bench judgment. According to you, which I should consider?
Supreme Court judgment, madam. I am also referring to Saralwama only. I am not going beyond that Saralwama.
But Sarla Verma, you want to put as many commas as possible.
No, no, madam. That is where when comma, it is to be understood that, madam, the condition is she should be married. The party should be married.
Oh, look at this order.
Please, madam.
The motor accident allowed the criminal petition by awarded granting a compensation to the tune of rupees so and so. On challenging the said award, High Court by the impugned order dated 7/3/2022, High Court deducted 50% towards loss of dependency.
Here in same.
On the pretext that, please listen.
Please.
It was only the wife who was the claimant, no children, having no children. The High Court directed to pay 35 so and so, applying the analogy of a bachelor.
My lord, here.
Because
Please.
the claimant was only the wife and not the children. What other judgment you require when it is straight on the point?
My lord, here.
After having heard the learned counsel appearing for the parties at length, the analogy as drawn by the High Court is not justified. In view of the foregoing, we allow this appeal and set aside the impugned order passed by the High Court and restore the award passed by the claims tribunal.
My lord, again I have to be the Supreme Court has referred the Saralwama judgment. If you read the Saralwama judgment, my lord, that meaning should be that when they're married, the dependence has to be 2 to 3. If court come to conclusion that there is a 2 dependence, at least 2 dependence, then that 1/3 is to be deducted. That is interpreted.
In fact, earlier I have passed several orders, I have taken 1/3. Then when they were relying on a division bench judgment, because there is a judgment, I had to follow and pass 50%. I am always on the view that it should be 1/3.
No, I just brought to the knowledge of
No,
this.
I could see a judgment of a apex court, and as my view is also that.
No, Saralwama I interpreted in this case, my lord. And
What interpretation a division bench gives to Sarla Verma doesn't matter when there is a Supreme Court judgment.
My lord, here in this case, my lord.
I will record it, take that.
No, my lord. In this case, my lord, wife is here is a son is alone.
Whoever it is, dependent is a dependent. One dependent is the whole issue. When a person is married. Then we'll come to the next. So, what is the calculation in this?
My lord's calculation, my lord's, to the parents 15% of the estate that has been calculated, and to the son 50% has been deducted. Now it has to be 1/3.
How many are there?
My lord's, if this court come to the conclusion that my lord's parents and in-laws are dependent, it is deduction. Please, no, it is my lord.
No, which case? Second issue.
Rupa case,
MBC number?
MBC number 1239/21.
Age of the deceased is?
It's 22 years.
He is married.
Married.
And wife and?
Death of my lord's mother. Death of mother. First case, my lord has already decided.
That is over, that I understand.
This is
No,
death of mother.
22 years old is the claimant. Who is the deceased?
My lord's deceased is the mother of the appellant number 1. Please.
Son and who are other?
And my lord's in-laws and her parents.
In-laws of who? In-laws of the deceased.
Her deceased in-laws and her parents. Totally 5 members.
What about her husband is not alive.
Husband
Husband
first
is
case is husband.
already died.
He already died
My lords has already decided.
in the other case.
Yes.
Hmm.
In the same accident, mother and father are both are died.
No, husband is no more.
Please.
That in this case, my lord, first is
In
husband's
that
case.
case, they are already shown as dependents.
Yes, yes. In that case, my lord, father was died. In this case, my mother is died.
Hmm.
Father going to be decided matter. Now it is the case of mother.
That I understand.
Yes,
In
yes.
case of father, his parents must have been shown as dependents.
Yes, yes. That means
If once they are shown as dependents in that case, why should they be they dependents for the daughter-in-law also?
My lords,
No. Husband and wife died.
please
Husband's case is already decided.
decided.
Now it is the case of wife. In case of wife, her mother and the deceased mother and father, the deceased mother-in-law and father-in-law are shown as dependents.
Please.
What I am saying is, the mother-in-law and father-in-law, as mother and father were already shown as dependents
Yes.
in case of the husband. So they cannot be. And her parents can't be considered as her dependents. So who else is now? Only son.
Son.
Yes.
My lords, my submission is that, my lords, in our Indian, my lords, because it belongs to
can't,
village. Please,
That
please,
to a case
Please.
where we are deciding both the
Please,
cases,
please.
we can't consider.
please.
So,
But here, my lords, I am entertaining for consortium matter.
accident,
A consortium, my lords.
we will
Please,
calculate. When is
My
that?
lords, 14,250.
14,000,
250.
2021.
Please.
What was her age?
22 years.
Not claimant, deceased age.
22.
22.
Deceased age.
22.
22.
Mother.
Mother.
Mother was 22 years old as on
Deceased
date of
was
death.
aged about 22 years.
There is some confusion. You are saying that who died in MBC number 1239?
1239, my lords, mother of the, my lords, appellant number.
And why, when I'm asking what is the age of the mother, you say 22? What is the age of the mother?
Age of the mother, 49 years.
That's what I'm asking.
Yes.
40?
9. Sorry. 47.
Yes. Future prospects at?
40%.
How can it be 40%? 47 years old?
No, madam. Again, it is mistaken.
Again,
The appellant number one is a mother-in-law. She was 47 years. The deceased was a mother who is, she was 22 years old as on date of the accident. And now claimant is the son. Son was old.
11 months.
Was
11 months.
3 years old.
No, at the time.
Now he is 11
At
years.
the time he's 3 years old.
No, 11 months.
11 months old.
Please.
Here 3 years shown.
Yes,
As
now
on-
I understood. $5,000, it comes to 19,950 into 1 divided by 3 comes to 6,650 minus 1 and 13,300. Into 12 into 15. It comes to 28 lakhs
72,800.
2,800. Consortium, how many?
Only the single dependent is considered, madam.
When it comes to consortium, it is not about the dependency. It is about.
In both the cases, they are
Huh?
they are
That's
getting
why
the compensation.
No, it'll consortium is the loss of a person. That is what it is, loss of love and affection.
Yes.
Yes, how many in this case?
Out of
5 months.
5.
5, my lord, the mother and then in
Not mother-in-law and all will not
3
consider.
months. If that is so.
3.
mother, my lord, She is a married daughter.
Huh?
She is a married daughter. Her father and mother are also not entitled to loss of consortium.
Yes.
But my lords, under the head of consortium, so my lords, it is always my lords.
Only that the son is considered in this case a loss.
48,000. 36,000.
Because tribunal has already awarded to the my lords,
Sir, my submission in
parents.
this regard.
Because anyhow we are reappreciating
Please,
29 lakhs 56,000.
800. Please.
Please come.
My lord, my humble submission. In this case, my lord, minor interest is not protected.
Huh?
Minor interest is not protected. So far, the trial court has awarded loss of estate to the mother-in-law and father-in-law. That has to be set aside. But they have aggrieved person has not challenged it. We have satisfied it. So that amount which is awarded to the mother-in-law, father-in-law, that ought to have been goes to the son only.
Please come to the award and tell the court. Come to the award.
Please.
Order and show to the court what is it.
My lord, last 30 pages.
Paragraph
Paragraph 24.
30.
Internal page number 30, my lord.
Hmm.
Here,
Yes.
my lord, that the head of so calculation is given under serial number 3, my lord. Loss of estate to the petition number 1 and 2. They are the mother and father.
What is that? Hmm.
Loss of estate.
The petitioners number 1 and 3 of are entitled to total compensation of the
That
ratio
is-
with simple interest at the rate of 6% per annum.
Serial number 3, my lord. Serial number 3.
3 or who? The parents and the son.
Yes.
Hmm.
No, no. Here, in this case, my lord, married daughter is died, and the loss of estate 1 and 2 was sought by the mother and father, and their tribunal has held that they are entitled the loss of estate to the extent of 15%. That has to be set aside, and that my lord, the court has no, my lord, the calculation is considered. That has to be merged with this calculation. My lord,
Somehow both of you are really confusing the court.
my lord, total.
Come to the table at page number 17.
My lord, total award is 50.
Come to page number 17, Mr. Counsel.
70.
Paragraph number 17. First is 1238. Please refer to MBC 1238.
1238, ma'am.
Yes.
This is correct, ma'am. There is no dispute in this case.
Huh? There is no difficulty in 1238. Yes. Then please come to 1239. One, two, three, nine. The table is at paragraph number 24.
24.
Uh,
The total award is 23 lakh.
yes.
1,360. No, my lord.
Either 1 and 2 being the mother and father of the deceased group are entitled to, how are they entitled for this compensation?
They should not be entitled.
My lords, what happened?
They should
Before
not
that,
be
my lords, I told,
That's
I
why I'm
argued that 1 and 2 were awarded 15% of our estate. It is clear in page 36.
Represent them also.
15%. My lords may kindly see the finding at page number 36.
And we are not considering them as a dependent.
Yes.
No, they are not entitled for anything.
But what
Entire thing will have to go to the son.
Please.
In that case, if you are representing them, that I have to record. Are you representing, appeal is filed against, on behalf of all of them?
Please.
So what we say is, no, the entire amount of 29 so and so is loss of dependency is to the son.
But they have already deposited and they have withdrawn that amount.
Who has withdrawn?
Claimants before the trial.
How much?
Well, their share to the extent of 15%. Here, what tribunal has committed an error? Tribunal come to the conclusion that parents are entitled to the estate. 15% has been awarded to the minor son. 50% has did.
Oh no, any of that 15% is already withdrawn.
Please.
So the remaining 75% to him.
That my submission only that minor interest should be protected.
Huh?
Minor interest.
What I record,
That is-
I mean,
that is
record
the
is
concern.
already, it has been withdrawn 15%. So entire the remaining amount of 85% should be kept in a fixed deposit.
Please.
And my one more submission is that, my lords, since, my lords, he is a minor, I will leave it to the option of the court. For, my lords, his purpose, education purpose, some amount, my lords, may be released.
What is that sum amount? What is, how old is he?
Now, my lords, he is aged about, my lords, 6 to 7 years. I will leave it to your lordships.
So how much? Not leaving to the court. What is that you want?
Some amount for the maintenance,
Some amount.
some 2 to 3 lakhs may kindly.
Agreed with award passed in embassy number 1238 of 2021 and 1239 of 2021. The claimants are before this court seeking enhancement of the compensation by filing MFA number against MBC 1238 of 2021, MFA 105553 of 2023, and against MFA 1239 of 2021, MFA 105535 of 2023 or filed in MBC number 1238 of 2021. The tribunal has granted the compensation as per the table given below at page number, paragraph number 732. Land counsel appearing for the claimant submits that the court had failed to grant reasonable compensation under the head of consortium in the judgment of, as per the judgment of the Honorable Apex Court in Pranay Sethi. Every 3 years, there has to be 10% enhancement. That was not considered. Land counsel appearing for the respondent insurance company submits that enhancement has to be looked into from the date of accident, but not from the date of judgment of the Honorable Apex Court in Pranay Sethi's case. It is submitted that on all counts, the compensation that was awarded was just and reasonable. The coming to the loss of dependency is concerned, court considering all the aspects are rightly granted an amount of rupees 27,13,200. For the funeral expenses, they are entitled for 36,000. Towards consortium, 48 into 3, 1,44,000. In the light of the law laid down in Michael or so and so, legal expenses 10,000. Altogether, the claimant is entitled for an amount of rupees 29,03,200. Then coming to MBC number 1239, the tribunal has awarded the compensation as per the table given at paragraph number 24, extracted. In this case, the dependents are the mother and father of the deceased. Is it correct? Mother and father of the deceased and the son. Dependents.
Please.
Mother-in-law and father-in-law also.
They are claiming.
In 1239.
Yes.
In 1239, the dependents
Yes.
are 5 in number. That is the mother-in-law, father-in-law, mother and father, and also son who is aged about 11 months. According to, it is the contention of the land counsel for the petitioner that all of them have to be considered as dependents. And considering the same, the compensation ought to have been awarded. Land counsel appearing for the insurance company submits that they cannot be considered as the dependents. And in fact, the mother-in-law and father-in-law are the dependents in MBC number 1238 of 2021. And as she is a married daughter, question of the parents becoming the dependents also does not arise. It is submitted that only the son has to be taken as a dependent. Learned counsel for the petitioner submits that even if the son is considered as dependent, 1/3 has to be deducted as the case of a married women. He had relied on the order passed by the Honorable Apex Court in Babita Singh alias Singha versus New India Assurance Company Limited and another arising out of civil leave petition number 7774 of 2022, where in that case the tribunal had considered the wife as a dependent and deducted, as she's the only dependent, deducted 50%. And the tribunal has considered 1/3 towards deduction, whereas the High Court, considering her as the only dependent, has deducted 50%, and the Honorable Apex Court has reversed the said order of the High Court and held that it has to be 1/3, and the order of the tribunal is a well considered one. Land counsel for the petitioner, land counsel for the respondent insurance company, relying on a judgment of the division bench of this court, has held that in case of if there is only one dependent, it is 50% has to be deducted. He has relied on an order passed by this court in case of in MFA number 8223 of 2017 and submits that this court, considering the division bench judgment, had deducted 1/3. This court has perused the said judgment. Though this court has earlier deducted 50%, not 1/3. Though this court has deducted 50% basing on a division bench judgment in the earlier order. However, now considering the judgment of the Apex Court in Babita Singh referred supra, in that case, the deduction has to be 1/3. Hence, considering the income at 14,250 and as there are taking the son as the dependent, as neither the in-laws nor the parents or the dependents, considering the son as the dependent, this court is and 40% future prospects would come to 5,700, that is 19,950. As son is the only dependent, 1/3 would come to 6,650. Then the contribution to the family is 13,300 into 12 into 18. It comes to 28,72,800. Towards consortium, 48,000. Funeral expenses, 36,000. Altogether, the claimant is entitled for an amount of rupees 20. The son is entitled for an amount of rupees 29,56,800. It is submitted by the land counsel for the petitioner that as per the interim order, as the amount is deposited and as per the order passed by the court, 15% of the amount is withdrawn by 15% of what? How much is withdrawn? Because entire amount they don't deposit.
No, entire amount, because it is my appeal, man. Because it is my appeal.
15% of the amount is already deducted. Considering the fact that already 15% amount is deducted, the remaining 85% of the amount the son is entitled, and the same shall be, and the amount shall be kept in a fixed deposit. Further, for a period of, what was the court's order? Generally, what would be the order for a period of till he attains majority?
For a period of 13 years.
Till he attains majority, and periodically, whenever the amounts are required for the purpose of education, an application can be moved. An amount of rupees 2 lakhs can be released for the purpose of immediate necessities of the child. Yes. Both the appeals partly allowed.
Seal number 35.
I am for appellant, my lord.
Mali Patel.
I kindly request to short adjournment next week.
Yes, let's just start in the month of March 36.
March 36. SS Joshi.
Here for respond number 2 this case, that is Clement. The insurance company has come up with a
Please that, my lordship, there were two vehicles involved in the accident, but charge sheet is laid on the lorry, my lordship. Lorry hit the car, my lordship. Thereafter, car has dashed against the, that is a pedestrian, my lordship. Due to such accident, my lordship, the mother of the claimant has died, my lordship. That is the only, it is grievance raised by the insurance company, my lordship. No charge sheet is laid against the owner of the car, that is car, my lordship.
The council is not feeling well today.
Yes, sir.
2 weeks time maybe accommodate.
Kindly request in the first week, since, my lordship, he is pursuing the studies, claimant is pursuing his final year B studies. He is in need of some money, my lordship.
This is a matter on 11th,
Obliged.
Please, please,
on 11th, no, it's 12th.
12th,
please.
Yes, 37.
12. Appeal number 37.
My lord, claimant's appeal for enhancement, it is case of death, my lord.
Where is, who appears for the respondent?
Please.
Ready?
Respondent 3, my lord.
Regarding, my lord, trial court table, my lord, page number 30 of, my lord.
On what ground you are seeking enhancement?
One ground, my lord, consortium, wife, unmarried daughter,
Loss
and
of dependency, no quarrel on that.
there is no dispute, my lord, loss.
Come to the table, where is
Table,
it?
my lord, page number 30, my lord.
So, loss of dependency,
That is correct, my lord.
26 lakhs, 43,264. Then how many are the claimants?
My lord, 3, my lord. Wife, unmarried daughter, and mother of the deceased, my lord.
3 into 48.
Plus
It comes
escalation.
to 1,44,000, 36,000,
And
10,000.
10% escalation, my lord.
After escalation only it becomes 48.
Yes, please.
If you say another 10,000, the insurance councils won't accept.
And second submission, my lord, regarding apportionment of compensation, my lord, the trial court awarded 30% to the wife and 40% to the unmarried daughter, my lord, and 30% to the mother of the deceased, my lord. That taking into consideration of
1 minute.
Lordship, that
It comes to 28 lakhs 33,264. Are you representing all the parties?
only, my lord, I represent for wife and unmarried daughter, my lord.
Wife and unmarried daughter.
I am
Wife, 1 minute. Wife, how much is granted?
30%, my lord.
Wife and 40% to the,
Unmarried daughter, my lord.
and
30% to the mother of the deceased, my lord.
you represent mother?
Yes, mother. 30% is 70-30. That is 70% and 30%.
For considering, my lord, the unmarried daughter, my lord, the education and married expenses in future.
Yes,
And
but they also have to live. They are also dependent on.
Yes.
No, you
At least-
can't 30, 40. It has to be 70 because both of them are together.
Yes.
70 plus 30.
at least, my lord, 50% to the unmarried daughter, my lord, and 20% to the mother of the deceased. And
Ultimately, how much what will happen? 50% to the unmarried daughter, 20% to you.
a trial court awarded 40% to the unmarried daughter and
So
30%.
50%. So what we will do like this?
Huh.
50% to the unmarried daughter, 20% to you, 30% to her.
Only I leave it
Let
to
it be. What is the age of the mother?
66.
66, my lord.
66.
And,
Then we'll make it 25%. 25% to the mother.
my lord, already there is no appeal from mother, my lord.
No, it is how much is granted to the mother.
Mother is 30%. my lord.
That's what I'm making. I'll make her 25%.
25.
25% to the mother.
Please.
So 45 to the
Unmarried daughter, my lord.
unmarried daughter, 30 to the wife.
Please.
Lordship, one submission, Lordship. Lordship, towards love and affection, also 30,000 has been given, Lordship.
That what this court is awarding would be the same. So we will not look at that chart.
Please.
The agreed with award passed in MVC number 269 of 2022, dated 5th October 2023. The claimants are before this court seeking enhancement of the compensation. The claimants are the wife and the daughter, and the mother is the respondent. The land council submits that as far as loss of dependency is concerned, they are not agreed with the same. Our consortium reasonable amount is not awarded, and further, daughter is granted, unmarried daughter is granted 40%. It is apportioned as 40% to the unmarried daughter, 30% to the wife, and 30% to the mother. It is submitted that apportionment is bad, and the same requires to be modified. Next para. Land counsel appearing for the mother submits that the court has rightly considered and granted the compensation. The no interference is called for. And the land counsel appearing for the insurance company also submits that no interference is called for with the well-considered award. Next para. Having heard so and so. As far as loss of dependency is concerned, there is no dispute. Then coming to the consortium, there are three dependents, 3 into 48, 1,44,000. Funeral expenses, 36,000. Legal expenses, they are entitled for 10,000. Altogether, the claimants are entitled for an amount of rupees 28,33,264. When it comes to the apportionment, considering the fact that the unmarried daughter and her future, this court deems it appropriate to apportion the same as 30% to the wife, 45% to the unmarried daughter, and 25% to the mother.
Partly.
My lord, one more submission
38.
regarding the trial court fixed the FD for till her attainment of majority, my lord, for a minimum.
Always, whenever it is required, you can move an application. That is in the interest of the, that we can't change. Yes, next. 38.
Number 38, Nagrasri Kalluri, Sunanda Patil.
Yes.
Lord, it's an insurance company appeal on both the grounds, liability as well as on the quantum. Liability on the ground that as on the date of the accident, driver on the wheel does not possess the license. Date of accident is 2015. It is pre-amendment.
Yes. Then
Even
quantum.
then, my lord, I am relying upon the judgments of the FX court and the coordinate bench of this court. My lord, the coordinate bench of this court, order passed in 23rd day of January 2024. I will draw the attention of the lordship to the para number 18.
Yes.
Page number 8.
Yes.
Only one. Exhibit P6 discloses that the driver of the lorry did not possess valid driving license as on the date of accident. However, the copy of the driving license so and so. Therefore, the insurance company is not liable to pay the compensation. Since the owner is contesting the matter, he is duly represented. Principles of law enumerated in the case of Yellava and other pay and recovery does not arise.
Yes, this I will record. Next, what about the Supreme Court judgment?
Yes, my lord, Mahavir versus United India, my lord. I will draw the attention to the para number 3 of the judgment.
Yes.
The tribunal found in favor of the insured and held that the insurance company has failed to establish that the owner did not entrust the vehicle with the person having a valid driving license. The High Court found that since in the investigation police had filed a charge sheet, there was sufficient evidence to show that the owner of the vehicle had not entrusted the vehicle to a person having a driving license. We cannot exceed.
It is filed by the owner of the vehicle. Bill is filed by the owner of the.
Yes, my lord.
Yes.
Even.
Yes, next.
Balakrishna Chavan regarding the pay and recovery, my lord.
Yes.
I will drive the attention to the para number 8.
Yes.
The only aspect for our consideration here is as to whether in the facts and circumstances of the present case, an order to direct the insurance company to pay and recovery is required to be made on this aspect. The law is well settled that if the liability of the insurance company is decided and they are held not to be liable, ordinarily there shall be no direction to pay and recover. That is the crux of the case, my lord.
Yes, next.
Even though they have passed the pay and recovery in para number 13, they have elaborated that it is affects court in view of the power they have passed.
Yes.
In Amudavalli versus HDFC Ergo, my lord, in para number 1, line 2, my lord, on the question of pay and recovery, this order is also. In page number 2, my lord,
Yes. Yes.
the High Court has set aside the order of pay and recovery, my lord. The same was upheld by the Apex Court in para number 6, my lord. Now the only issue is to whether the insurance company should be directed to pay an amount and then recover from the owner, which means the court adopted the various cases helped
This is
in
a
the
case of a
claimant.
gratuitous passenger.
Yes,
How can?
fact may be differs, my lord. Only thing is that principle regarding the pay and recover.
Pay and
My lord,
recover on
my
the
lord,
question
I
of
do
driving
agree.
license.
I do
No, no, no.
agree regarding,
Can't mix those.
no, my lord. Fact may be differs, my lord. Principles laid down, whatever they have laid down, I have submitted, my lord.
Yes, I'll consider. Yes, next.
Observing my lord, my submission is that whatever I have relied upon and observed, that is to be reflected in my order, judgment, and the order can be passed. Regarding the disability, my lord,
Yes.
wherein the court below has taken the disability to the extent of 20%, wherein the doctor,
There is a case of death. I have asked only to post in priority the case of death. So it has come. This matter, list has parted. on-
Your lordship may kindly we see that I have filed.
I'll hear, it's already 4:48. I'll hear it on Tuesday.
no, my lord, I am on the next week, I am not be able to attend, my lord, I am out of station.
That's parted on 17th.
My lord,
17th.
please.
Yes, next.
My lord, only that is my submission.
Yes.
49? 39?
Yes, 39.
Pajapati?
Lord, insurance company has challenged the quantum and negligence. The quantum is with regard only the.
Next Thursday. Yes, 40.
My lordship, kindly withdraw the withdrawal amount, my lordship, 50% deposit.
We'll decide.
I am for the respondent in this case, my lord.
40 also.
Serial
Next.
number 40.
41.
40.
41?
40 serial.
Serial number 40, ma'am. Serial number 40.
Next week, next Thursday it will come.
41, my lord.
Serial number
Enhancement
41,
of
we have party.
compensation. Enhancement, my lord.
That's what, both will come on Thursday.
That's
Yes. Any signature?
My lordship, one submission. Serial number 39, we kindly listed on the hearing on I am, my lordship. One.
Yes.
Sir. Sir. Sir.
ಪಾಠೋಡ. ಯಾವ ಮೂರು?
Sir.
ಎಂಟ್ರಿ ಮಾಡೋರು ಏನು ಹಿಂಗೇನಿರಲ್ಲ.
Sir, serial number 54, sir.